Hello, everyone. So, as the exams are approaching, the need to revise the subject is increasing even more. So, here I am with the CMA Inter Law Marathon. Now, this is part one of marathon where we are revising the section corporate laws, right, which is 40% of your syllabus. This particular marathon is in 100% English. So, the students from particularly from South India or anyone who is having any language barrier or want to specifically revise in English, keeping in mind that ultimately the answers have to be written in English, so I should know how to write it and I can gel with it well. So you can use this particular marathon. So it's segregated chapter wise according to Companies Act classification, and thereafter we have the portion of directors, we have the portion of KMP, control, and rights of shareholders, and all of that, right? So it is strictly according to institute syllabus and revise. I have tried to revise the entire portion in a detailed manner, yet keeping it very time bound and concise, so it won't waste much of your time and you can quickly revise the entire subject with me. This is not the replacement of original class, this is super fast revision which you need to know or which you need to do before exam. So please don't consider this as the main classes or this to absolutely clear the entire concept. No, it can clear your doubts if you have somehow in the topic when you listen to it, but it cannot clear the concept. Okay, the entire concept. For that, you can check out my website bookmyvideo.in, where you can find the details of the classes. You can also find the details of the books in case you need, right? So the entire set is also available, which is a kind of solution to all your requirements and needs, right? And it's high time you begin the revision. This particular revision is relevant for the coming June as well as December 25 attempt, right? So the time gone is gone, but the time that you have now shouldn't be wasted. And you might have a lot of regrets that oh my god, I've done this, I've done that, right? What to do now? So sulking about your mistake will lead you to another one, so don't sulk now, and just gather all the energy that you have, put in, revise the subject well. In case you have any more queries, you can always drop in the comments and we can come up with better solutions and videos and guidance, right? Keep the channel subscribed for more videos coming before your exams, and all the best. Enjoy the marathon. Thank you. So we begin with basically the very first chapter, which is preliminary, right? Now you have to understand one thing, that what is a company. Although this is never asked in examination, but in general you must know about it. So company we can understand in two ways. One is the general meaning of company, and the other is the definition of company, right? So the general meaning is nothing but it is a voluntary association of people who have come together for a common objective or profit motive, right? So that is what we mean by company. But if we go by the definition of company as given under Companies Act 2013, what is company? Company is nothing but incorporated under the Companies Act 2013 or any previous laws. So if I talk about that I have a company which has been incorporated under Companies Act 2013, that is going to be treated as a company. But if I say that, okay, I have Reliance Industries Limited, which was incorporated in previous Companies Act, that is also a company even under Companies Act 2013. So all the companies that we have till date who have been registered under the present Companies Act 2013 or previous Companies Act, which was prevalent at that particular point of time, they're all treated in the definition, or they're all covered in the definition of company. So that is one thing, right? Thereafter, we have certain features of company, right? We have certain features of company. So what are the features? The very first one, separate legal entity. Now company is a separate legal person. That's what makes it special from a general proprietorship, because it is a person, maybe not maybe definitely not natural person, it is an artificial person, but it has its own separate entity, right? So it has its own separate corporate existence. It is distinguished from the members who have invested in it. It is distinguished from the directors who are actually taking decisions for the company or taking care of its management. No, it is different, right? The next one we have limited liability. Now, again, although still we have certain companies wherein the liability is unlimited, that is, we have unlimited company, and there are also certain cases where the liability becomes unlimited because of fraud and likewise. But in general, otherwise, we have a company, its liability is unlimited, but the liability of the members of this company is going to be limited. Limited to what? Limited to the extent of, if it is a company, limited by shares. So whatever amount as a member I have agreed to contribute, that means supposedly I have agreed to take 5 shares of 100 each. That means I have agreed to give an amount of 500 to the company, right? So my liability is restricted only to 500. Now, if I have paid entire 500, there is no unpaid amount left, right? If I have paid 400, 100 is the unpaid amount, right? So my liability or the shareholders can be called only to pay that unpaid value of his shares, that is 100 in the given case, right? So that is the liability which may be asked for, and not more than that. And if it is a company limited by guarantee, then the amount of guarantee is what can be called for. The third one is perpetual succession. What is perpetual succession? No matter who comes and who goes, there will be this company in existence, and it has been legally given birth to, and it is going to be legally wound up, right? Otherwise it cannot happen that, okay, there were 2 members who had invested in the company and the members have died, so the company comes to an end. No, that does not happen, right? The company has its existence from incorporation till winding up, right? It is going to survive, it is going to go on and on and on, right? Then we have separate property. Of course, when we say the company has its separate legal existence, it is a separate person in the eyes of law, then it can also hold properties, it can hold investments, it can acquire land, it can acquire building, right? So it has the power to acquire the assets, transfer properties in its own name. It need not, like if I talk about partnership firm is not a separate legal entity in the eyes of law. So whenever partnership firm wants to buy shares of a company, they cannot buy the shares of the company in their own name. What they have to do is they have to buy the shares in the name of their partner, even though the firm is investing in it, right? So likewise, this the same problem does not exist in case of company. Then we have transferability of shares. What is transferability of shares? If I have invested in the company, I can transfer this investment to someone else also. If I want to withdraw that investment, I am in need of funds, right? So I have bought 4 shares, I can sell these shares to somebody else, right? That means transferability of shares exists. In public company, the shares are freely transferable, but when we talk about the private companies, although there are restrictions, but again, the shares are transferable, okay? Then we have common seal. What do you mean by common seal? Common seal was mandatory before Companies Amendment Act 2015, right? So before that it was mandatory. Now it has been made optional. It is the official signature of company basically. Okay. Now, if the company chooses to keep a common seal, so on every official document, they will affix that common seal. But if they choose not to have the common seal, because now it is optional, then every document is going to be signed by 2 directors or a director and a company secretary, wherever it is appointed. Okay. Next, we have capacity to sue and be sued, which is not written over here, but then that is also something that you must know. So what is capacity to sue and be sued? Now, you are a separate legal entity. You can sue someone directly and you can also be sued. The company can also be sued. No matter who I was dealing with, the company has provided me the product which was not up to my mark, I can sue that particular company, right? So the company can also be sued. Next, we go to a concept called as corporate will. Now, first thing you have to understand that what is a corporate will, and thereafter we'll be able to understand the concept of lifting of the corporate will, right? So what is corporate will? It is like shelter, right? Or basically you can say it separates the members and the entity, right? So it is a kind of privilege that, okay, the company has a separate entity. So there is a curtain, there is a shelter which allows shareholders that, okay, fine, we're safe. Whatever is happening in the name of company, and company shall take responsibility. Company will be responsible, although I am signing, although I'm taking decisions, right? So all the shareholders, directors, they're all involved, they're running the company, because company is an artificial person, yet there is a shelter, there is a curtain which is actually protecting the shareholders, which is actually protecting the members. But that does not mean you can take undue advantage of the same, right? So if you are taking undue advantage of the same, you're doing some fraud, that, oh, let me do some fraud in the name of company, I am never going to be responsible. So although there is a separate entity, right, you are separate from that company, but still in certain situations like fraud, what may happen is that this wheel of incorporation, this curtain which exists between you and the company, will be lifted, and you will be held responsible for the actions that company has done. Why? Because we need to punish the persons who actually did wrong, because company is an artificial person. Company cannot indulge in fraud. Yes, there can be errors, yes, there can be a few delays and all that. For that, company is going to be liable, company is going to be penalized and everything. You will not be made responsible if company runs into losses for a contract which was made according to your professional judgment. No, the company will bear the loss, right? So that is something else. That is the shelter which you are being protected against, right? But in certain situations, the corporate wheel may be lifted. So what is corporate wheel or lifting of corporate wheel? Disregarding, when you disregard that it is a separate entity, and when the law ignores the company and concern themselves directly with the members or the persons who are managing the company. Okay, now there are many cases in the past where judicially they have passed such decisions that they have lifted the corporate wheel and have held responsible the persons who were running the company or who have invested in the company, right? So what were the cases? The very first one is trading with enemy, or you can say determination of enemy character of the company. Now, what is an enemy? That you have to understand. Company can be our enemy or our friend, or anyone we are dealing with can be our enemy or our friend, right? How do we decide that? When there is a war, or when the one country is not at peace with the other country, all the persons, all the entities of that other country, they become our enemy, right? So we are not supposed to contract with them, right? So for example, if India is at war with China, or if India is at war with Pakistan, whatever it is, so all those things will settle down for that during the tenure of war. Now during this tenure, you have to understand one basic thing, that there is a company, or let me say there is a company which is incorporated in India, right? Which is incorporated in India. So ideally it is an Indian company. Ideally it is an Indian company, but it has 4 shareholders, and all 4 shareholders, let's say, are Pakistanis, right? Now, if for example, this should not happen, but if for example, India is at war with Pakistan, so all the companies or entities or persons should not be dealing with this Indian company also, right? Because ultimately their shareholders are Pakistanis only, right? So basically this Indian company was protected, or these shareholders were also protected, and there was a concept called as corporate wheel, that you are different and we are different, right? So we will deal with only the company, we don't concern who you are, right? But at certain situations we need to remove this curtain and actually look behind, and we will treat you not as an Indian company but as a Pakistani entity. Why? Because we want to determine the character of the company. So we want to determine and we want to check whether you are an enemy or a friend, because we want to contract or we want to enter into any agreement with you, right? So I hope this is clear. Fine.
The second one is laws of taxes and duties, or basically you can say protection of revenue. Protection of revenue. So what is protection of revenue? When the government wants to protect its revenue, right? If you're trying to evade taxes, they will ignore the separate legal entity status and they look behind that, okay, who is trying to do that, right? Then we have avoidance of welfare legislation. What is avoidance of welfare legislation? There is a famous case law of associated rubber industry, and that basically says that, okay, there is a company which was earning this much, and because of its earning it had to pay bonus is what? It is a welfare legislation for the labor class, right? So bonus, it had to pay bonus. Now what they did is they diverted this income to someone else so that the profit gets reduced and I have to accordingly pay lesser bonus. Now both these companies, both these entities were merged as one, although they are different, but they were merged as one. Why? Because you are trying to avoid a welfare legislation which is not allowed. Okay. Then we have to protect public policy. Obviously, yes, this goes without saying. And the court will not even take a moment to do this, because if there is a public policy and that has to be protected, no matter what they have to do, they will take that particular action only. Fine. Okay. The next is prevention of fraud. Fine. Prevention of fraud. What is prevention of fraud? Again, a case of Jones versus Lipman. Just a second. See, basically, this is a case where the company is being formed for, I would say, improper conduct. Basically, it wasn't exactly fraud, or you could have called it fraud also. What happened in the Jones versus Lipman case, to be precise, he was supposed to. Mr. Lipman actually was supposed to sell a house, right? But he refused to later on, right? Now, if you go to the court, they can pass an order for specific performance that nahi, you must sell this particular house. So what he did is he formed a company and transferred that particular house to the company, right? So he could clearly say, no, I don't own the house. The company is a separate legal entity. So in that case, the corporate wheel was lifted. Why? Because the company is used for improper conduct, right? Likewise, we have another concept called as company mere sham or cloak, right? So whether you use the company only for committing some illegal things or doing some fraud, then that is also a case where the corporate wheel will be lifted. It was done in the case of Guilford Motor Company versus Horn, right? And then you have if you do any contempt of court. Do you know what is contempt of court? Disobeying the orders of court. If the court tells you that you have to furnish penalty or you have to submit this particular amount by the end of 15 days, you have to do that. In that situation, if you don't do, the company will not be responsible, right? The people can be responsible, because at that moment the corporate wheel may be lifted by the court, right? So company is an artificial person, it cannot disobey the orders of the court, right? So the persons who are actually managing the company are doing that, right? And the last one, where the company actually acts as an agent of its shareholders. Agents of shareholders means what? A company has been formed and the company is not taking its own separate decisions. It is just the agent of shareholders. So if it's specifically the agent of shareholder, the corporate wheel may be lifted. The next topic that we come across is kinds of companies. There are different kinds of companies, right? So we have mostly types of companies covered in section 2. The definitions are covered in section 2 and we will read them one by one, and thereafter we'll go to the formation of company, right? So the very first one, which is given over here, although we have a lot of categories which it can be categorized into, right? Like based on the number of members, based on control, which is holding subsidiary, associate, right? We have different types of companies. Now the very first one that we're discussing over here is private company, section 2, clause 68. Okay. Now, what is a private company? Private company basically means a company which has minimum paid up share capital as may be prescribed. Now, nothing has been prescribed. So, no minimum paid up share capital has been prescribed. That is point number 1. Secondly, when we talk about private companies, it has 3 things in its articles. What are the 3 things? We have restriction, we have limitation, we have prohibition, right? So there are certain conditions and articles of association of a private company which must be there. What are articles of association? We have two fundamental documents of every company. One is MOA, second is AOA. Of course, this is the revision class, so you know this very well, so I don't need to explain you this, but still. Memorandum of Association is the charter document and contains the details about the company. What is the name of the company, with which liability it has been formed, where is it situated, right? Who are the members and everything, right? So that is what is included in MOA. AOA is basically the internal rule book of a company and tells us what are the regulations which the company needs to follow, right? So in every articles of association of a private company, there has to be a restriction that the private company cannot freely transfer its shares. There has to be a limitation that a private company has to have minimum 2 members, but it can have maximum 200 members only. So it limits the number of members to 200. You cannot have, a private company cannot have 250 members. No. If you want to have more than 200 members, up to 200 it's fine, but if you want to have more than 200 members, you have to convert your company into a public company, and then you can do that. But when we are computing this limit of 200, wherever there's a joint member, like me and my husband, we jointly hold a share in a private company. So we will not be treated as two different members. We'll be treated as one member only, right? Secondly, a lot of times to employees we given incentive and they're being given shares. They're being offered shares under schemes. Now, if I am an employee of a private company, because there are many private companies which continue to remain private, but they're operating on a very large scale, like we have Flipkart, right? So it's not a public company. It does not want that public issue. So it continues to stay private, but it is a huge company. So there might be a lot of employees, might be the number of employees may be in thousands, lakhs, right? So in such a situation, they might be offered some shares. Now, if every employee is to be counted as one member, then there will be so many members. So this ESOP scheme won't work in private companies. So that is why what is there is that these members and these employees who became members, they'll be entitled to all the benefits of members. It's just that they will not be counted in this limit of 200. So they acquired this membership, they acquired the shares while they were members. They'll not be counted in the limit of 200, even if their employment ended with the company and they continue to be the shareholder of the company. Still, they become the former employees. Still, they will not be counted in the limit of 200. So this is one thing that you have to remember. So every private company is going to have the restriction on transferability of shares, limitation on the number of members, and prohibition that it cannot invite public to subscribe for any securities of the company, whether it's debentures, whether it's shares, or anything like that, right? So this is about a private company. We add suffix private limited to a private company, and OPC and small company is also a private company. Then we move to the next part, which is a public company. What is a public company? Public company, which is not a private company, is a public company. So simple, right? And having minimum paid up share capital as may be prescribed. Again, there is no minimum paid up share capital which has been prescribed. Okay. There is one thing that you need to remember in the concept of public company, and that is deemed public company. Deemed public company, what is it? So we have a subsidiary of a public company. Okay. Now you have to understand that private company has lesser compliances to do. It is not exposed to a lot of things that you have to follow this, you have to disclose that. But public companies, because they are also open to public issue and they might have public money and all that part, right? So they have a lot of disclosures to make. Now, supposedly there's a public company which has even gone for IPO and has a lot of public money. And when they have taken that money, they have invested that money in the private company. Now, that private company is not supposed to report anything. So this becomes a problem. So to avoid this particular thing, what has been said that if you are a private company, but you are a subsidiary of a public company, then you will also be deemed to be a public company. And now you will not enjoy any exemption benefits which are given to a private company, but you will have to comply with all the requirements that a public company has to do. Okay. So this is a subsidiary of a public company is deemed to be a public company. That is one thing that you need to remember. Okay. So I hope public company, this is clear. Fine. Now, the minimum number of directors in a private company is 2, and in public companies, it is 3. Right? There are a lot of differences that you will eventually explore in private and public companies. The next concept that we come across is Section 2, Clause 62, one person company. Now, OPC was not in existence before. Okay, so although there was a concept of one man company, but otherwise this has been a newly introduced concept under Companies Act 2013, and this has immense benefits because the individual entrepreneurs who do not have multiple people to come together and form a private company or a public company, because in public company you need at least 7 persons, and in private company also you need at least 2 persons, right? So the ones who do not have a lot of people, what they can do is they can form a one person company. So it helps the individual entrepreneurs, right? What they get is they get the benefit of limited liability, they get a lot of legal protection because that is company will be separate, that will be separate. Companies get better credit facilities and access to market, right? There are a lot of opportunities. If you're working in the area of handicraft, or you're a weaver, artisan, you can always form a company, and it will give you an opportunity to start your own venture with a proper corporate formal business structure, right? So it has huge benefits. Moreover, if I talk about OPC, there are lesser compliances. You don't have to hold that AGM, right? Lesser compliances in terms of you don't have to file less returns. The annual return is shorter, right? The board's report is shorter, right? So balance sheet, you are not supposed to prepare cash flow statements. So there are a lot of compliances benefit also which you get, right? Apart from that, if although we will discuss it in chapter 2 when we discuss about incorporation, and there is a section 122 which also tells us that a lot of things are not going to be applicable on OPC. So of course OPC has tremendous benefits. Now OPC can be registered as a company, as a limited company, limited by shares or limited by guarantee, right? But OPC will always be a private company. It cannot be a public company. So OPC is a type of private company with some special features. What are the special features? There is just one member in the company. So there are very high chances that this one member may become incapable to enter into a contract or may die. So what will happen? All the shares get transmitted to the legal heir, but still there will be a problem to run the company because he is the sole person, and in most cases he is the sole director. Okay, so what happens? There could be a problem. So in such a situation, OPC has been designed in such a manner that you have to have a nominee. Okay, so the memorandum of association of OPC company will also indicate a name of nominee. So you obtain somebody's prior consent that, are you ready to become the nominee of my OPC? The person says yes. There's no qualification required to become the nominee. Any person can become the nominee, right? That person should not be a minor. He should be at least be competent to enter into a contract, and there are certain requirements which eventually we'll discuss. If I want to form a one-person company, I need to be a natural person. A company cannot form another OPC because the concept originally is for the individual entrepreneurs, right? So I have to be a natural person. I have to be an Indian citizen. I may be a resident of India. I may not be the resident of India. There are many errors in different materials regarding this update and amendment, which came long back, right? But remember, this is what you're reading is correct. Okay. So he may be a resident, he may not be a resident, and that particular person can incorporate a one-person company, and you have to find another such person. That means a natural person, an Indian citizen, whether resident or not, to become the nominee. You ask that particular person, are you ready to become the nominee? Obtain his prior written consent, and along with the consent, you submit this and write the name of that particular person. If the sole member becomes incapable to enter into the contract, or if the sole member dies, then that nominee will take place of the sole member, right? So the perpetual succession concept will actually be intact. Okay. One person cannot incorporate more than one OPC. You cannot incorporate two OPCs. So you cannot be a member of two OPCs. You cannot be a nominee of two OPCs, right? And all details we will discuss when we actually go on to the incorporation part, right? OPC cannot be incorporated as a Section 8 company. What is a Section 8 company? Section 8 company is a company which has been formed for charitable objects. Okay? I hope so far the things are clear. One more thing that you need to remember, that if you're talking about one person company, you cannot invest in any body corporate. It's not allowed. That means you cannot buy shares of another company, and likewise no company can invest in you, because the only sole member who can invest in you is an individual, right? So basically OPC cannot be a holding, OPC cannot be a subsidiary, because you're not allowed to invest in the securities of any body corporate, and you are not allowed to carry out NBFC activities. Non-banking financial activities, they're not allowed, right? So there are certain restrictions. You cannot be a Section 8 company, you cannot carry out NBFC activities, you cannot invest in anybody's corporate. Okay, so these are the things that you need to remember. And basic benefits I've already told you. There are more detailed exemption benefits that we'll discuss later. Okay, fine. There is no concept called as compulsory conversion of OPC into a public or private company now. That has been deleted way back. Okay, so even if you find it somewhere, please don't read it. Fine, that does not exist as on date. Okay, the next concept that we come across is holding company, right? Okay, what is a holding company? Basically, when we talk about holding, subsidiary, associate, they're all based on control. So holding company does not have a proper definition in itself, but when we talk about subsidiary company, we'll understand holding company as well, right? So what is a subsidiary company? Subsidiary company, if there are two companies, okay, because this is a relative concept, you cannot understand this standalone. You can say this is a private company, that is a public company, but you cannot say this is a subsidiary. This is a subsidiary in relation to whom? Like if I say I am a mother, I'm a mother to my child, not to everyone else, right? So when you say subsidiary, subsidiary is a relative concept, and if I say subsidiary, there will always be a holding, and they have a holding subsidiary relationship. It's not a subsidiary to somebody else, right? Some other company. So when I say subsidiary, then there is a holding company which actually either controls the composition of board of directors or exercises more than half. So even if it is 50.0100001%, then that is also a subsidiary. So if one company, let's say, has 50.04% shares in another company, we will say this company is holding and this company is subsidiary. Why? Because shareholding or share capital is as good as voting power unless DVR shares are issued, differential voting rights shares are issued, which we actually get to know later, right? So in the chapter of share capital, I'll explain you that, right? But as of now, if one company, and this is a concept of holding company and subsidiary company. So I cannot say that if I am an individual shareholder and I hold 60% shares in a company, I'm a holding company, and that, no, I'm not a holding company, right? So there has to be a body corporate for establishing this particular concept, right? Now, if one company either controls the composition of board of directors, that means that company is appointing, that company is removing, right? So they have a good control over the who is going to be the board of that particular company, or exercises or controls more than half of voting power. Now, this more than half of voting power could be individually or could be together with its subsidiary. What do we mean by that? Let me take a quick view. We have a company A Limited, and A Limited holds 70% shares, let's say, in B Limited. So A and B have a holding subsidiary relationship directly, right? Now B Limited holds 40% shares in C Limited, and A Limited holds 15% shares in C Limited. Now, if I try to establish the relationship between A and C, they're not holding subsidiary prima facie or directly, right? Because A Limited holds only 15% shares in C Limited. However, A Limited has a control of 15% plus its subsidiary also has a control of 40%. So if I sum total 40 plus 15, it comes out to be 55. So together you have a control of more than half of voting power with your subsidiary. Then they also establish a relationship of holding and subsidiary. Fine. I hope this is clear. Okay. Now there is a restriction given in law. What is that restriction? That you cannot have more than 2 layers of subsidiaries. One thing you have to understand, that one company can have n number of subsidiaries. That is not the restriction, right? So if I form a company A Limited could have a lot of subsidiaries. The problem is in layering, right? That is, the subsidiary of A Limited is B Limited, the subsidiary of B Limited is C Limited, the subsidiary of C Limited is D Limited. So layer 1, layer 2, layer 3, that is how it goes, right? So you cannot have more than 2 layers of subsidiaries. However, if you're a banking company, NBFC, insurance, or government, then this restriction does not apply to you. Okay. Now, when we come to the holding company is very simple. What is holding company in relation to other company? Is a company of which such company is a subsidiary company. So that is very simple. Now we come to the next part, which is associate company. What is an associate company? Associate company is the mid, right? Like, you cannot become the subsidiary because you don't or if I am a holding company, or if I am a company, I am holding, let's say, 30% shares in another company. So that company does not become my subsidiary. Why it does not become your subsidiary? Because you need to have more than 50%. So you don't have that much control or that much voting power. Yet you have a significant influence. What is the significant influence? Having a control or at least 20% voting power. 20% or more. So if I am a company and I hold 21% shares, 20% shares in that other company, then that company, it is called as what? Associate company. Okay, so if it becomes your subsidiary, then it will be called a subsidiary only. But if it is not subsidiary, but you have significant influence, then that is what is called as associate company. I hope that's clear. Okay. The next concept that we are reading over here is the concept of small company. What do we mean by small company? Very popular among students, because we have seen a lot of recent amendments and amendments in small company. Section 2, clause 85. Now, what is a small company? Small company is nothing but a type of private company first. Okay, so a private company, if it operates on a small level, that means it meets certain prescribed thresholds, it is operating within that threshold, then it is called a small company. And small company have a lot of benefits. So first thing, if you're a public company, you cannot be a small company. If you're holding company, that means you are investing in in securities of some other body corporate. No, you're not a small company. If you're a subsidiary, that means somebody is investing in you. You're not a small company. So if you're a public company, you're not a small company. If you're holding company, you're not a small company. If you're a subsidiary company, you're not a small company. A Section 8 company already is entitled to a lot of exemption benefits in different ways. It will not be conferred the status of being a small company. And if you're a company which is governed by special act like Insurance Act, right? So you're not a small company. So these 5 types of companies will not be treated as small company other than this. So if you're a private company, other than these, and you meet a certain threshold. What is the threshold? See, the current prescribed threshold is that your paid up capital should not exceed 4 crores and your turnover should not exceed 40 crores, not to exceed 4 crores or 40 crores. Right? So this is what is being prescribed. Now you have to understand very well, because students get confused and they mess up everything. So understand one thing very clearly. When we're talking about the definition which is stated in section 2 clause 85, what does it say? Small company means a company other than a public company, right? So small company means a private company. Paid up capital of whose does not exceed 50 lakh or such higher amount as may be prescribed, which shall not be more than 10 crores. So the maximum amount which may be prescribed can be 10 crores. Now we have to see that paid up capital should not exceed 50 lakhs or such higher amount as may be prescribed. CG has the power to prescribe this amount up to 10 crores. CG has used this power and prescribed an amount of 4 crores. So 50 lakhs or such higher amount as may be prescribed. So we have a higher amount prescribed, 4 crores. So we say that paid up small company means a private company, paid up capital of which does not exceed 4 crores. You get it? But when you're writing the entire thing of the definition of small company, you must write the entire thing. Okay. Secondly, and. So it is a twin condition compliance. You have to comply with both the conditions, then only you can proceed forward. Right? So what is the other condition? Turnover of which does not exceed 2 crores or such higher amount as may be prescribed, it shall not be more than 100 crores. So CG has the power to prescribe turnover up to 100 crores. CG has used this power and prescribed the turnover of 40 crores. So 2 crores or 40 crores, that is the higher amount prescribed. Okay, so I hope this is clear. Moving to the next type of company, which is Section 8 company. What is Section 8 company? Section 8 company is a company which is formed for charitable objects, right? Charitable purposes like you can say commerce, science, arts, sports, education, research, charity, religion, okay, environment, and a lot of other things. How do you form a Section 8 company? Firstly, Section 8 company is formed not for profit motive. It is called as a non-profit company, right? See, whenever we are talking about NPOs, whose intention is for the betterment of society and not for profit motive, they can be formed either as a trust, you register the trust, or they can be formed as cooperative societies, or they can be formed as Section 8 companies. Okay, so Section 8 company, of course, comes under Companies Act. Earlier, we had Section 25 under Companies Act 1956. Okay, now we have Section 8 companies under Companies Act 2013. Okay, fine. They don't need to use the suffix limited, private limited. They can be formed as a private company or as a public company. That is not a problem. They cannot be formed as OPC. Now, because they are formed for charitable purposes, they cannot utilize their profits in filling their pockets, right? It cannot be distributed as dividend to the members. They have to, if any surplus is generated, they have to plow it back to the purpose or to the object only. Fine. So prohibition on payment of dividend. There is no minimum number of directors required, because if it is formed as a private company, there will be 2 minimum number of directors. If it is formed as a public company, there will be 3 minimum number of directors. But in case of Section 8 company, this is not the case. Fine. We have a lot of other things to read about Section 8 company, like how do we obtain license, etc., etc. But we'll be doing this when we discuss about the incorporation part. Fine. Then we have government company. What is government company? My dear, government company is different from government department. First of all, you have to note that down. Okay. The second thing, if we are talking about central government as well as state government. So if central government or state government or a combination of them, 2 state governments, central government and 1 state government, whatever it be, right? Or many state governments, they hold at least 51% of paid up share capital. At least 51%. Or you could say 51% or more. See, when we are talking about the definition of subsidiary, it was more than 50. So even 50.01% counts over there. But here you need to have at least 51% of share capital. If it is held by government, doesn't matter, central government, state government, or jointly by both of them, then that particular company is going to be called as a government company. Now, whenever, let's say central government holds shares, like we have ONGC. So when you open the shareholding pattern of ONGC, what you will see is that the shares are in the name of president. So when the shares are being held by central government, they'll be in the name of president. And if they are held by central state government, they'll be in the name of governor. Okay. So no specific person that currently I'm in that position, so the shares are in my name. No, it is in the name of office. Okay. Next, if you have a subsidiary of ONGC, then that will also be treated as a government company. So subsidiary of a government company is also government company. Okay, fine. Then we have something called as a foreign company. Fine. What is a foreign company? Now, foreign company is a company which is incorporated outside India, but It has a place of business in India and conducts business activity in India. Now, this place of business in India could be a direct place of business or could be through an agent. It could be a physical place of business or it could be an electronic place of business. Like what, ma'am? Like, let's say we have somebody in US who is imparting education through online like this only. Do they have a place of business in India? The answer is yes. They have an electronic place of business in India. Electronically, they have established a place of business because they are doing business in India. They're conducting business activity in India, right? They're imparting education over here. So that is what. Will it be called as a foreign company? The answer is yes, because if you're incorporated outside India and you're doing business outside India only, we're least concerned, right? Indian laws are not going to be applicable on you unless you want to raise funds from here, right? So we have a separate chapter for that. But otherwise, if you are a company outside India and you're doing some business in India, you have a place of business in India. Maybe it is a physical place, maybe it is an electronic place, maybe you have opened a place, or maybe you have hired just someone and that particular person is selling your product. So you have a place of business through as your agent, right? So it doesn't matter, you will be called as a foreign company. Okay, now this electronic mode has also been defined, like you have any digital supply transactions, you have telemarketing, telecommuting, telemedicine, education, as I told you, right? Any cloud computing, any data communication, right? Voice transmission or whatever, they're all inclusive in the definition of electronic mode. Okay, now what you have to understand, because there are a few more sections which are being given over here. Firstly, when we are talking about place of business, you have to understand that if there is a company and that company is having a share registration office over here or share transfer office over here, that means whatever transfer deeds they receive, the transfer is being executed at a place here, then that will be treated as having a place of business in India. Okay, it will be treated as having a place of business in India. There was another case law, there were some representatives of a company. There was a company which is incorporated outside India. They came to India frequently. They visited India and stayed in a hotel, right? They were actually looking for a business deal, right? They were wanting to purchase some machinery, purchase some articles, and they stayed in that particular hotel, right? Every time they came here, they stayed in that hotel. It was held that that hotel is also a place of business. Okay, so you have to understand that. Now, we have few concepts that we need to understand. Concept number one, that section 380, we have a separate chapter for companies incorporated outside India, and we don't have to read the chapter in entirety. It's not included in our syllabus. What we have to read is one section, section 379, some part of it, and we have to understand and know that there are two sections, section 380, section 381. Section 380 tells that you must deliver certain documents to ROC. Which ROC, ma'am? Maybe it is having some electronic place of business. There is a company incorporated outside India. It can work in India by forming a subsidiary also, by forming an Indian company also. Then that case, it is not treated as a foreign company. That Indian subsidiary becomes an Indian company only. But let's say, for example, there is a company incorporated outside India. It opens a branch over here and is selling goods in India. So that particular company is going to be treated as a foreign company, and that company has to comply to certain things and follow certain Indian laws. So we have a separate chapter for that, out of which we have to read certain portion. One, that if you open a place of business over here, there are certain documents that you need to furnish to ROC New Delhi. Okay, so for all foreign companies, we have ROC New Delhi. Second thing, which we have section 381. Section 381 tells us that you have to maintain certain accounts. Like the Indian companies prepare and maintain books of accounts, right? Likewise, you also have to prepare and maintain the books of accounts. Okay. The third thing is the concept of deemed Indian company. What is deemed Indian company? Now try to understand this with focus. Okay. What is deemed Indian company? Let's say there is a company which is incorporated outside India. Okay. And it has certain shareholders A, B, C, and D. Okay, it has certain shareholders A, B, C, and D. Now, out of these, B is an Indian, C is an Indian, D is an Indian. A is not an Indian. Indian means citizen of India. That particular person may be NRI, doesn't matter, you're a citizen of India. So they are all three Indian citizen, or let's say there are four friends, they were living in India, they are Indian citizen, they moved to US and there they incorporated a company, so they are still Indian citizens, right? So out of these, three are Indian citizens. A has 10% shares in the company, B has 20% shares in the company, C has 50% shares in the company, 5, 6, 7, 8, and again D has 20% shares in the company. Okay, is this clear? Now this particular company opens a branch in India. That is, you can say establishes a place of business in India. So this company will be called as a foreign company, yes or no? So far, I hope the concept is clear. Now you have to understand another concept, where at least 50% of the paid up capital of this foreign company is held by Indian citizens, Indian companies, or in a combination of the two. Then that particular company is treated as deemed Indian company and it has to comply with certain additional provisions as if it was an Indian company. So it has to comply with the provisions of this chapter and some other provisions what may be prescribed as if it was an Indian company only. So in the given case, if we look at this, 90% of the shares of this company is held by Indian citizens. So this establishes the concept of deemed Indian company. See, if 50% or more paid up capital of such company is held either by Indian citizens or and company or body corporate incorporated in India, then this particular chapter and some other prescribed provisions will apply to the company as if it was an Indian company in respect of its Indian business. So I hope this is clear. Okay. Then we have listed company. Listed company. What do we mean by listed company? There are certain companies which are listed, there are certain companies which are unlisted, right? So we have recognized stock exchange. It is nothing but like a marketplace. So if I am a company, I have issued certain securities to general public, it is mandatory that before issuance, I have to apply to the stock exchange and get the listing done, right? Because if you are offering shares or securities to public, it is the duty to provide them a platform to sell it, to buy it, right? So it is nothing but a platform. Like if I want to sell my product, I have to get my listing done on Flipkart. It's as simple as that, right? Of course, there are technicalities, but the concept stands very simple. So there is stock exchange, we have NSE, we have BSE, right? Two broad famous stock exchanges. Now, if any of your security, it doesn't matter, all of your securities, a company is not listed, its securities are listed. So if any of your securities listed on a recognized stock exchange, then you are called as a listed company. Okay. Now, there is one more thing that you need to understand. What is that, ma'am? There could be a private company also whose debt securities might be listed on a stock exchange platform. It is allowed according to SEBI regulations, right? Not the shares, but a kind of debt securities that is allowed, right? We don't have just one platform on stock exchange. We have the main board, we have SME, we have IGP, that is Innovators Growth Platform, wherein people or companies look for angel investors and like, right? So there are cases. Secondly, there may be a situation that I'm a public company, I have issued equity shares, I have issued debentures, or I have issued preference shares. I have not done the listing of equity shares. I have listed my non-convertible debentures, which will never convert into equity. I have listed my non-convertible debentures on the stock exchange. I have not listed my equity shares. Okay. Thirdly, I am a public company. I have not listed my shares on any recognized stock exchange in India, but have listed it in a foreign jurisdiction. That means stock exchange of US. right? There the trading is going on. So in all these specified cases, that is, if I am a public company and I have listed only debt securities or preference shares on private placement basis, which I issued on private placement basis, right, and not my shares, or if I am a private company and I have listed my debt securities which I issued on private placement basis, in all these cases, for the purpose of Companies Act 2013, these companies will not be treated as listed company, only for the purpose, because once you become a listed company under Companies Act, you're subjected and prone to a lot of other compliances, right? So to stop that, okay, fine. Financial year and KMP, basically I'll be discussing financial year as and when required, and KMP at the end. Now, there is one more thing that I need to discuss. What is that? It is producer company. What is producer company? Actually, I would say we have Companies Amendment Act 2020, and it has actually notified producer companies, and we have section 378A to 378ZU. They deal with the producer company, right? So what is producer company? It is nothing but it is a group of farmers or agriculturists, right? So they have come together and their association is legally recognized as a producer company. They are producers, right? So when they come together, and what is a company? It is a voluntary association of people with a common objective. So all the farmers have a common objective, all the agriculturists have a common objective, right? What is their aim? Their aim is to improve the standard of living and etc., right? So they have come together, and that is, if your objective is that, if your objective is production, if your objective is harvesting, if your objective is grading, pooling, or you can say even some research or training in that particular field, right? If your object is harvesting, processing, insurance of primary produce, other welfare measures, providing education, supply of machinery, etc., then if you have that particular object, then that is called as a producer company. So the object of producer company are given in section 378B, and which you should learn, right? Because that's the only thing that you have to learn with respect to producer company. You don't have to read all the sections, but whatever sections you have to read, you'll do that, right? Okay, so next we will start with, okay, I don't think I discussed with you about PFI. PFI is one such thing that I want you to know. What is PFI? Public Financial Institutions, Section 2, Clause 72. There are a list, 5 institutions which have been there. LIC, then we have IDFCL. What is it? Infrastructure Development Finance Company Limited. Then we have UTI, Unit Trust of India. Then we have all those institutions which were notified by central government under Companies Act 1956, and other institution which may be notified by CG in consultation with RBI. Now, CG cannot notify any financial institution as a public financial institution. When you add public, it denotes like it belongs to the government. First thing, right? So if there is any financial institution, first thing, it has to be established under Central Act or State Act, like LIC established under LIC Act. Okay. Or there should be a situation that at least 51% capital is with the central government or state government, because it gives you an impression that this belongs to the government. So it is a financial institution rendering financial services, but it belongs to the government. Okay. So it may be recognized, it may be notified as given. Fine. So I think so far the things are clear. Let's now revise the chapter of incorporation of companies and matters incidental thereto. Ideally, if we see, it is chapter 2 of Companies Act 2013, which starts from or comprises of sections 3 to section number 22, right? Okay, and of course the rules to go with it. Now, very first thing that you have to understand is section 3. Okay, section 3 basically tells us how do we form a company. The first thing that it tells us that a company may be formed for a lawful purpose. It simply implies that if you choose this particular form of business organization, you can make this type of company only for a lawful purpose. And there are 3 types of companies which may be made. If you want to make a public company, then you need to have at least 7 or more persons are required to form a public company. If you want to form a private company, then you need at least 2 persons. And if you want to form an OPC, then only one person is sufficient, right? So a company may be formed for a lawful purpose. These are the three categories of companies which can be formed. And if you want to form a company, all you have to do is subscribe the name to the memorandum, comply with all the requirements which are given under the Act, which basically we read in section number 7. So in section number 7, we read the detailed procedure of incorporation of a company. Section 3 only tells us how a company may be formed. So it tells if you comply with all the requirements, a company will be formed. Fine. If I'm talking about OPC, it also tells us that in case of OPC, you also need to have a nominee. So you obtain his prior consent in the prescribed form and you state his name in the memorandum of association. If at all the sole member dies or becomes incapable to enter into a contract, then what will happen? The nominee's name that you have given will take his place and he will now be the sole member, right? So that is what is being told to us. And once you have complied with all the requirements, ROC, Registrar of Companies, of which we have a basic idea, and now is not the time, revision is not the time to give you all those details, right? So what ROC will do, ROC is an authority which is actually meant for keeping all your records, right? All the records relating to the company, right? To facilitate the whole process of incorporation. So they get all those documents, they allot you a certificate of incorporation, they give you a corporate identity number, which is also known as SIN. The short form is SIN, right? And we need to preserve all the documents till the dissolution of the company, right? So that is what the formation is all about, right? Now we'll start with the entire process. These are some basics which are given in section number 3. Now we'll start with the entire process. Okay, so you need to have some basic idea about the promoter also. Who is a promoter? See, whenever if I want to form a company, I am a person who gets the idea. Okay, I want to start a factory and I want to form a private company. So I'll be needing one more person. So 2 persons, maybe we can start a company. Now I have just this basic idea. I go to a chartered accountant or I go to any other professional and I tell them that, okay, I want to form this particular company. Now they are actually providing me assistance, right? So they are professionals who are actually helping me out. So they are not the promoters, we are the promoters, right? We are the promoters as in me or my friend, or maybe I could only be the promoter. I have arranged more people, I have arranged funds, I have prepared the documents. So the person who is doing all those tasks, that preliminary steps of gathering people, preparing the documents, deciding the name of the company, doing the filing, entering into pre-incorporation contracts, that particular person is known as basically promoter, right? Now, promoter may change during the lifetime of the company. Right now, or maybe let's say when Reliance was incorporated, of course, there was Dhirubhai Ambani. Right now, does he exist? No. So that means the company does not have any promoter? No, the company still will have promoter. What happens if now the company is in short of funds? Who is arranging the funds for the company? It's not just the directors that they're doing everything. There is still the need of that upper hand promoter, right? So who is still taking all those efforts? It is the Ambani family. So they are the promoters, right? Even under SEBI regulations, you need to write about the promoters, right? Okay, let's not get into all that. So the definition of promoter is defined in section 2 clause 69, which simply states that promoter is somebody who is named in the prospectus. So if you want to know that who is the promoter of this particular company, his name will be written in the prospectus wherever it is issued. His name will be written in annual return. So by seeing at that, you can get to know that this particular person is the promoter of the company. Secondly, he will have control over the affairs of the company. Maybe he is the promoter, he has 60% shareholding in that particular company. So because of that shareholding, he has a good control on affairs, right? Or otherwise also he might be the MD, right? Or he might have just a contract with a company that I'm going to take these decisions, right? So somehow he is controlling the affairs. Or the third situation could be that board of directors are acting according to his directions, right? So board of directors is accustomed to act according to his direction. So in all the 3 cases, he is going to be the promoter, right? Okay. Now, so before the company is actually incorporated, Promoter is somebody who selects a name. Now, how do you select a name? You need to comply with section 4. You need to comply with rule 8, right? Rule 8A, rule 8B. And there are a lot of words which are being clearly given, that we have rule 8, which says that these are the list of undesirable names or undesirable words which you cannot use in the name of the company, right? So whenever I'll slightly skip this part and I'll actually first take you to the process of incorporation, which is name reservation, right? So you are trying to select a particular name, right? How do you select a name? The name should not be identical or resemble to an existing company. If there is already an existing company in the name of Reliance, I can never get the name of my company as Reliance, because it will give a presumption to people that, okay, there is another chain, another company which the Reliance Group has opened. No, right? So that will not be allowed. Secondly, it should not constitute an offense. I am abusing someone in my name or demeaning some community. No, that cannot happen, right? Third, it should not be undesirable according to central government. As I told you, there is rule 8A, which actually gives us a list of this. We have rule 8, which tells us that what is not going to be considered as resemblance and all that, right? You don't have to read all the rules in a lot of details, fine. Then we have another part which says that there are certain words which can be used only by a government entity. Like if I use the word board in the name of my company, like we have central board of something, it gives us an impression that, oh my god, this belongs to the government. So if I am opening a private company and I'm using such terms which actually gives an indication that it belongs to the government, no, my dear, we cannot use that, right? And if we want to use that, we need to obtain CG's approval. So we cannot use this, we cannot use this, we cannot use this, and we can use this subject to approval of CG, right? So this is how we actually decide what name we want to get. The process is entirely automated in the current scenario, right? So we have a beautiful form Spice Plus, which is divided into two parts. Part A is for name reservation and part B is for furnishing the entire set of documents. So when we are filling part A, they can be filled together also and they can be filled separately also. Once your name is reserved, then you can also fill part B, which is advisable, right? So part A, you give in the basic details, you suggest a name keeping in view all these restrictions, and then the name is approved. So that is the first thing that happens. That is the first thing that happens. Okay. So you file it with ROC. Supposedly your application form has no defect, your name will be approved and your name will be reserved for 20 days from the date of approval, which can further be extended. 20 plus 20. Okay, just a second. For 20 days, then for another 20 days, or at once for 40 days, right? So this can be done. This can be done. Now, if there is defect in the form, then you are being given a choice. You're being given a chance to rectify that particular defect. And if you rectify the defect, supposedly you haven't given this particular information properly, and ROC asks you that fill this information properly. So you fill it and submit it within 15 days. They can still approve your name reservation application. Otherwise, it will be rejected. Okay. Supposedly you thought that, okay, I can get this particular name only if I am a construction company. So although you don't want to do that construction business, you're not a construction company, but you provided some fake information and false documents and you got this particular name. That means you have reserved your name by furnishing some incorrect particulars. In that situation, there might be two cases, right? One is that you just filled part A of Spice Plus, right? You haven't filled part B. The company is not yet formed. Only the name is reserved. So what will happen if it is found that, oh my God, the information that you submitted was not correct? So they will cancel your reserved name and they will impose a penalty. ROC will impose a penalty of 1 lakh on the promoters, whoever is making an application, right? But what if the company has gone one step ahead? That means they reserved the name by furnishing incorrect particulars. Thereafter, the company was also formed. And now we get to know that, okay, the name was reserved by furnishing incorrect information. Then what will happen? They will give you an opportunity of being heard, and they can pass any relevant order. They can ask the company, okay, change your name within 3 months, or they can strike off the name, or they can also submit a petition for winding up, that no, just wind up this company, whatever liabilities are there, pay them off, and close down this company. Okay, so this order may also be passed. Okay, so this is basically the first step in the process of incorporation, which is name reservation. Name reservation, right? Second step is about filing of documents. Now, why have I come over here? Section 7 tells us the entire procedure about incorporation of a company. It tells us that you need to prepare certain documents and give it to ROC, and ROC will issue you a certificate of incorporation, right? So the first thing that you did is you have to fill Spice Plus form. Spice Plus form, part A you have filled, you have reserved your name. The name reserved is for, in general, a period of 20 days, which can be extended up to 60 days, right? By giving, of course, additional fee. Now, the second step is you're preparing all the documents. The first document that is needed is Memorandum of Association. The question comes, what is Memorandum of Association? It is given in section 4. Okay, it's given in section 4. What is memorandum? So memorandum, the definition is given in section 2 clause 56, which actually tells us nothing. It basically tells us memorandum means memorandum as originally framed or as altered from time to time. Okay. Now, what is it? It is the basic document of any company. It tells us about the company. What is the name of the company? Where is the company? What does this company do? What this company can do? Who has formed the company? Right? Everything, basics about the company. That means first, name clause. If it is a private company, it will be written like Shivangi Private Limited. If it's a public company, it will be like Shivangi Limited. If it's OPC, there will be OPC in bracket, right? So we have read suffix about all the different types of companies, and that's how adding suffix and the name is being written, right? The next is situation clause. Situation clause does not mean you need to write the entire address of the company. No. You only need to tell us the state in which this company is situated. So only the state. Third is object clause. Object is what? The purpose for which company is being formed. It actually tells us the scope and purview. That okay, company can do these many things. Company can't do beyond this. So these are the 4 things which are written. Company can do only these 4 things. If the company does anything outside this, it is going to be violation, right? Because we have a doctrine of ultra vires, right? Okay. Next is liability clause. Liability clause basically tells us whether the liability of the company is limited or unlimited, because an unlimited company can also be formed. So the liability of the company, the liability of the members of the company is limited. First thing, limited by shares, limited by guarantee, right? So that is what they are going to write. Next is capital clause. Capital clause, we have different types of capitals about which we'll read in the chapter of share capital, but right now we have registered or authorized share capital with the division. Division means there will be 1,000 shares at the rate of 10 each. So 10,000. That is how it is being written. And succession clause only in case of OPC, where you write the name of nominee. Okay. Now, when I'm talking about memorandum of association, we basically have 7 schedules under Companies Act. In that, Schedule 1 tells us about all the formats of memorandum of association and the model articles. So if I am a company which is limited by shares, then what I can do is I can, as it is, pick up table A, right? So it has the format or pro forma of memorandum of association, and thereafter the name of the company is this. I have filled that particular information. The company, the liability of members of the company is whatever, right? So that is how it is. So respective forms are there in Schedule 1. The memorandum of association has to be printed, signed, divided into different paragraphs. It has to be prepared by every company. It's required at the time of registration, and later on it can also be changed or altered according to section 13. So we have section 13, which talks about alteration of memorandum. Very important section from examination perspective, right? Okay. Then we have articles of association, which is basically given in section 5. What is articles? Articles are the internal rules of the company, that how the company is going to run, right? Like if a shareholder does not pay call money, what is the procedure? How we will forfeit his shares? You have read about forfeiture in accounts also, right? So how will we forfeit his shares? So that is given in articles of association. So a lot of powers, a lot of internal things are actually given in the articles of the company, which are company specific. Of course, within the powers which are conferred under the act, you cannot do anything beyond that. But within that, you can always state, okay, my company can do this, my company cannot do this, right? So that are internal rules and regulations. Of course, they are given in respective tables. There are model articles which you can adopt as it is, or you can strike them off. You can change any clause. You can do whatever you want to, right? Again, the same thing, it can be later on altered also. There is one special thing in articles of association, and that is called as entrenchment provision. Section 5, entrenchment. What is entrenchment? Entrenchment means basically making something more difficult. If I take you through section 14, which is alteration of articles of association, it tells us you have different clauses of articles of association, and if you want to change any clause, basically you can do that by passing special resolution. What is special resolution? Special resolution means we call the members, we ask them, and if 3/4 members agree, 3/4 majority has to be obtained, right? So if there are 100 members who are actually voting, who have actually voted, there should be at least 75 members who say yes. Then SR is passed, otherwise SR is lost, right? So this is SR. And we need SR to alter every clause of articles, right? Supposedly in one clause we have written that Shivangi is going to be the MD for life. Now I know that, okay, I am ready, I agree to put in all that efforts, considering the fact that they have written in the articles that I'm going to be the MD for life. But what if tomorrow they change it by passing SR? So I'm a little concerned. I say, no, I want to add entrenchment. Before I agree to this, I want to add entrenchment. That means I am saying that changing this particular clause make it more difficult. How can you make it more difficult? There can be ample of ways. One such example, that this particular clause will be changed when members or when I get 90% majority. When I get 90% majority. So this is adding entrenchment to articles of association. Now, entrenchment can be added at the time of formation. Of course, whoever agrees to this, who will actually subscribe, otherwise they'll not subscribe. So you don't need to obtain anyone's permission, right? Otherwise, later on, if you're adding some entrenchment, the existing members might say, no, this was never decided, this is not happening, right? So if you want to later on add this entrenchment, then in a private company, you need to ask all the members, and if they all agree, then only you can add entrenchment. And in case of public company, you need to pass SR. Okay, fine. So I think this is clear. Okay. Now, there is one more section 3A before we actually go on to the process of incorporation. What is section 3A? Section 3A tells us members severally liable in certain cases. As we read in section 3, you need to have minimum 2 members in case of private company. You need to have minimum 7 members in case of public company. And this is not just required at the time of incorporation, but throughout the lifetime of the company, right? But supposedly I started the company with 7 members and I formed a public company. One fine day, or I shouldn't call it a fine day, one bad day, 2 of the members met with an accident and died on spot. Now, how many members are left? There are 5 members left, right? Out of these 5 members, there are 2 members who are in abroad, right? Somewhere enjoying their holidays and everything. So we have 3 members here in India who knew about the accident and who now know that, okay, we are just 5 members remaining. What should they do? Should they continue the company with 5 members? Okay, I started with 7 members. What if 2 members died? No, they cannot do that. Law says that you need to find 2 more members and make it 7, because that is the statutory minimum. Statute says minimum number of members has to be 7, right? So that is the statutory minimum and you must comply with that. But of course, law understands that you cannot comply it in one day. So you need a span of some days, right? So the law has given you a span of 6 months. Okay, go ahead and comply with it. Go find out the members. But if you carry on the business after 6 months also with the reduced member, then every member who knew this fact that, okay, we are less than 7 members and you're still doing business, then those members are going to be severally liable for the debts of the company which you contracted after 6 months. Clear? So that is section 3A. Fine. So I hope you have understood memorandum and articles also, and the first step of incorporation. Moving to the next step. So you have reserved your name and now you are preparing all the documents, right? What documents are needed? I have already told you about the basic document. What is the basic document? It is memorandum and articles of the company. Now, memorandum or articles, they are going to be duly signed by the subscribers, right? How do they sign it? In the manner as prescribed. So that is the first basic document that you need. The second thing is a declaration. Declaration by whom? Declaration by anyone who is involved in the formation of the company. That is declaration by professional. It could be a chartered accountant, it could be a cost accountant, it could be a company secretary, it could be an advocate, right? Whoever is engaged in the formation of the company, right? And declaration by your director. In the articles, we write that this particular person is going to be the director of the company. So whoever is mentioned in the articles as the director or the manager, she also has to give that declaration. So 2 people are going to give the declaration, and this I call as a compliance declaration. What is a compliance declaration? That all the requirements have been met. All the requirements have been met. So first is memorandum, articles, declaration by CA, CMA, CS or advocate, and declaration by directors, right? That all the requirements have been complied with. The next is again a declaration, and this declaration is given by the subscribers and the directors. Subscribers and the directors. And in this declaration, they actually tell us that we have not done any offense, that we have not been ever found guilty in promotion, formation of the company or management of the company. We have never been found. Okay. Secondly, we have never been found guilty of any fraud relating to the company in the last 5 years. In the last 5 years. And whatever document we are submitting, they're all correct. They are all correct. Of course, the documents that we are submitting are correct to the best of my knowledge, to the best of their knowledge, right? So that is what the declaration they are going to give. So declaration of compliance by these 2, declaration of no offense by these 2, and thereafter the particulars of what? Particulars of office. That means the address of correspondence till the registered office is established. So if a company has an existing registered office, great, you'll provide that address. If they do not have, then any correspondence address, still actually you find a registered office address for the company. Next is particulars of all the subscribers, particulars of all the directors, consent of directors. Okay, so all these documents are going to be compiled, are going to be attached in Spice Plus Part B, and thereafter you are going to submit it to ROC. You have to preserve all these documents till dissolution. ROC will issue you a certificate of incorporation in INC 11. and allot you a corporate identity number, that is SIN. Fine. I hope so far the things are clear. You should also know about ultra wires. What is ultra wires? The basic things I've already told you. There is a case of Ashbury Railway Company, which we'll read a little later. Okay, fine. Now, there is section 9. What does section 9 tells us? Okay, one more thing which I want you all to remember. There are certain details about signing, because I told you you have to make memorandum of association and articles of association and get it signed in the prescribed manner, right? So there are basic some rules of signing. They are going to be signed by every subscriber. Okay, and when you sign it, you are going to write what is your name, what is your address, what is your occupation. Okay, and then there will be a witness who will attest the signature of the subscriber. Okay, that is clear. Now, supposedly the subscriber is illiterate and he cannot sign, then what will happen? It's a basic thing that he will affix his thumb impression and the witness will authenticate that, right? So that is going to be happening. Supposedly there is a subscriber who is a body corporate, so of course he cannot sign. Then in such a case, who will sign? Then there will be any director or officer of the company who will be authorized to sign. Then that particular person will sign. Supposedly the subscriber is LLP, then who will sign? The partner of LLP will sign. Okay, supposedly the subscriber is some foreign national who does not reside in India, then we also have to comply with the Hague Postal Convention, right? If you're not a part of it, right? So you have to remember all those basic details. If I am talking about here, ma'am, there has to be some subscriber details. Then what do we need about the subscriber details? Your personal details like your address, your email, your ID proof, your residential proof, your proof of nationality. If you are a body corporate, then we also need your SIN, right? So basic details are required. If you are a LLP, then your copy of resolution that you have, that all the partners have agreed by, right? Okay, then particulars of first directors, against the same thing. You also need DIN in case of first directors. Fine. So these are some intricate details which are also required to be learned by all of you. Please don't think that you can skip this particular part, right? Now, if later on it is found, just like we studied that if later on it is found that you have reserved the name by furnishing incorrect information, there's a penalty. Likewise, if later on it is found that you have incorporated the company by furnishing some incorrect information, then again there could be two situations. While screening the application, it is being found and the company is not yet formed, then whoever was responsible will be liable for section 447, that is a universal section under Companies Act for fraud, about which we read in the chapter of Prospectus, right? Secondly, if the company is formed and the promoters, first directors, subscribers, they are going to be liable under section 447, and there will be additional orders. Additional orders like what? If an application is made to tribunal, what tribunal can pass order like? Okay, this particular management from the very beginning, they are involved in fraud. They are submitting incorrect information for formation of the company. So we must regulate the management. So this order can be passed. Tribunal can also direct that, okay, the liability of the members was limited, but since they have done this, we'll make the liability of the members unlimited. Or they can remove the name from the register of the company. They can also wind up the company or pass any other order as they may deem fit. Okay, as they may deem fit, right? Okay. Then once the company is incorporated, the subscribers now become the members. The subscribers now become the members of the company, right? Okay, give me one sec. Section 6 tells us that Act is going to override the memorandum and article. So whatever is given in the Act, is going to be supreme. And if you write anything in memorandum, or if you write anything in articles, or if you pass any resolution, if you make any agreement, and that particular point contradicts the act, you have to keep in mind that always act is going to be superior, right? So if I try to recall the entire procedure, what is happening is, there's a promoter, he applies for name reservation, he prepares the documents, application, MOA, AOA, declaration of compliance, declaration of no offense, particulars of registered office, particulars of subscribers, first directors, right? And everyone, he files those documents with ROC, and ROC allots you a certificate of incorporation, right? So I think so far the things are clear. Okay. The other details also need to be remembered, right? Yes, ma'am. Okay. This also I've told you. Right. Next section that we can see on screen is section 10A. But before that, we also have section 10, which actually tells us about the effect of memorandum and articles. That once your memorandum is submitted to ROC, along with the incorporation documents, everything, once your articles are submitted to the document, they have registered your documents, then it is going to bind the company to the members and the members to the company, right? They're bound by each other. It does not bind the company to the third parties, but otherwise it is going to bind the members and the company. So whatever is written in those articles, you have to comply with it. Whatever is written in those in that memorandum, you have to comply with it, right? Next is section 10A, which talks about commencement of business. See, earlier this section did not exist, and therefore whatever company was incorporated, it could immediately start its business, but now that is not possible. Now what happens is, this is basically nothing. Earlier this used to happen. Now what happens is, if you are a company without share capital, you can start your business immediately. That's not a problem. But if you are a company with share capital, you need to ensure certain compliances. One, you are a company with share capital, right? So there would be subscribers to the memorandum who have agreed to contribute some amount to the share capital. Like, let's say there are 4 friends who have formed a private company. They all have said that, okay, I'm going to give 50,000 and I'll get 500 shares at the rate of 100 each, right? So that is what they have said to the company. Now, once the company is incorporated, they will contribute whatever amount they have said, and the company in turn is going to issue them shares. This should happen because it is a company with share capital. It is mandatory for them to invest what they had agreed to, right? So the company has to file INC 20A within 180 days of incorporation. What is this? This is nothing but a declaration by the director that yes, the subscriber has paid the agreed amount. Plus file INC 22. What is INC 22? It is about the registered office. Supposedly the company started with the correspondence office. Now it will have a registered office because it need to have registered office from 30th day of incorporation. Earlier it was 15th day, now it's 30th day only, right? So once your company is registered, within 30 days you need to find a registered office, and from that day onwards till the dissolution you must have a registered office at all times. So you need to give those details also, right? And thereafter you can commence business. There is penalty for non-compliance of provisions, and if without filing such declaration you're doing business, and then ROC can come and they can inspect, and if they believe that there is no business, they can also remove your name from the register of members. Okay, then we have section 12. What is section 12? Section 12 talks about registered office, publication of name, everything. So first, your registered office cannot be a PO box. It is very different from corporate office or head office. You need this particular registered office because all the documents, notices are served here only, and based on where your registered office is situated, it determines your domicile of the company, right? So company within 30 days of incorporation must have a registered office, and you must furnish this to ROC within a period of 30 days from incorporation, right? First thing. Secondly, every company, doesn't matter you have a small branch, you have a big branch, you must affix the name of the company and the registered address outside every office, in proper legible characters, which can be read, right? It has to be in local language also, if that is a language which is used generally in that particular locality. Like I have always given you an example of Bengaluru, that's my favorite, right? Okay. So I think that is clear. Now, if registrar has a reasonable cause to believe that, okay, you have opened the office, but you're not doing any business from this particular office, they can come and they can physically inspect that particular place, and thereafter they can also initiate removal of name of the company. Okay, fine. We have certain things about one person company, right? What is one person company? We all know that. So who can incorporate a one person company? Natural person, Indian citizen, whether resident or not. You don't need to be a resident of India to form a one person company or to become its nominee. Even if you're not a resident, you can still form one person company, you can still be the nominee of that one person company. Okay, first thing. Now, what additional things are there when you're forming a one person company? Then additional things are about finding a nominee and obtaining his consent, right? Okay, so along with the documents MOA, AOA, the compliance declaration as to no offense, particulars of directors, of subscriber, right? We have one subscriber only, director's consent, address, everything. You also need to furnish the consent of nominee when you are incorporating a one person company, right? So that is the simple thing. Now, what different we have is that if you have given a name of one nominee, can it be changed? Supposedly you did not like that particular nominee. Yes, it can definitely be changed. See, first of all, there could be a nominee who can withdraw his own consent, right? So what will happen in this particular situation? He or she is withdrawing a consent by giving notice to the sole member, right? Now the sole member will nominate another person as nominee within 15 days from the receipt of the withdrawal, right? And they are going to notify that to ROC, and that particular person will be written as nominee. There could be a situation that you are replacing nominee with another person, right? So if there is any such change, we have INC 4, and within 30 days you can do that, right? Then there could be third situation when the nominee is actually becoming the member because of the death of the sole member. So if the nominee becomes the member, he is going to nominate another person within 15 days. So when he becomes the member, he's going to nominate somebody within 15 days. Okay, so that is what actually happens. Fine. Okay. Now, one person cannot be a member in more than one OPC, but can be a nominee in one company. If he becomes member in two, he is going to choose within 180 days. So at one point of time, you can be a member of one OPC and a nominee of another OPC. You cannot be a nominee of two OPCs. You cannot be a member of two OPCs, but you can be a member of one OPC and a nominee of one OPC. Supposedly, where you are nominee, that sole member dies and you become the member. Now at one point of time, you're a member of this OPC also and you're a member of this OPC also. So you have to choose which OPC you want to continue as a member, right? There are a lot of exemption benefits which OPC gets, right? You don't have to prepare cash flow. You have an abridged return, right? Annual return, which we talk about in section 92, right? There are easy signing provisions. We talk about financial statements of OPC. It has to be just signed by one director, right? There is a board's report. You don't have to prepare that elaborate board report. Your board's report is going to be a abridged one, right? You're not required to hold annual general meeting because who you will meet with? OPC is a company with just one member, so you're not going to meet with your own self, so no requirement to hold AGM, right? Then no requirement or you can say relaxation in case of board meetings also, and in case of filing of financial statements also. You are not supposed to file the financial statements within 30 days from AGM, right? What is it? Within 6 months from the close of financial year. So you have different provisions, right? Okay. So I think this is clear. Moving to the next part. If I talk about conversion, OPC can definitely convert itself. See, voluntary conversion is there. Compulsory conversion of OPC has been deleted long back. Okay. So compulsory, voluntary conversion, of course, OPC can convert itself into private or public company by altering the memorandum and articles. And all you have to do is file an application with ROC. If ROC is satisfied, they'll approve and grant you the certificate. So nothing very special. You have to comply with all the requirements. If you're converting into a private company, comply their requirements. If you're converting into a public company, comply with their requirements. And you can do that. That is not a problem. Okay. Then moving to the next part, that is Section 8 company. What is Section 8 company? We all know that it is a company which has been formed for charitable purpose, right? So what are the eligible objects of such type of company? You can promote environment, you can promote charity, you can promote commerce, you can promote science, education, research, sports, a lot of things, right? Okay. Now, can Section 8 company be formed as OPC? The answer is no. See, there are only 3 ways how you can form a company. It could be private, it could be public, or it could be OPC. So when you're forming a Section 8 company, or when you're forming a government company, you can form the company as private or public, right? So if you are forming a Section 8 company, you could form the company as a private company or as a public company. It doesn't matter. It is as good as a private or a public company. The only difference is that because it is a company which is doing a lot of charity, right, and its motive is not to earn profit but the welfare of society, it gets a lot of grants, it gets a lot of benefits, exemption benefits under Companies Act, under Income Tax Act. It gets a lot of subsidies, grants, donations, etc., etc., right? So because it is conferred with a lot of advantages, you cannot start a company just like this, right? Because we all know that India is full of corruption, right? So basic checks. You need to obtain license from central government, right? So license from CG is needed. Now earlier there was a whole system that you need to obtain the license, then you need to apply for the incorporation. Now we have the license obtaining information or application incorporated within the application of incorporation. Okay, so you fill Spice Plus, therein only you provide some additional details which actually helps you get the license as well as COI. Okay, so if there is any person who wants to form a Section 8 company, right, maybe a private Section 8 company or maybe a public Section 8 company, you don't need to add limited or private limited at the end of your name. But what you can do is you can fill Spice Plus and submit it. What is going to be the attachment? Of course, there is going to be memorandum of association, there is going to be articles of association, there is going to be that compliance declaration, right? Apart from that, there is going to be an estimated income and expenditure account for the next 3 years. Okay. For grant of license, you know that. And declaration of by every person, whoever is making an application. Okay. So once you submit all these applications, ROC is going to issue a certificate of incorporation. Now, if license has been given, this license can also be revoked. Who has the power to grant license? ROC has basically the power has been delegated. That's why I'm saying ROC. You please remember central government only for your exams. Now, the granted license can be revoked. Supposedly, the license was given to you and there were some additional conditions also told to you that, okay, we are giving you the license, but you have to comply with these 4 conditions. You have to comply with Section 8, plus you have to comply with these 4 conditions. You did not comply with Section 8, license can be taken back. You did not comply with the conditions which were stated, license can be taken back. You are doing some fraudulent conduct, license will be taken back. You are violating your objects. You're not doing any fraud, but you are not supposed to do this thing, because your object clause clearly stated that you can promote sports, but you're doing something else. Maybe that's not fraud, maybe that's not some improper conduct, but you're violating the objects, right? Or you're conducting affairs against public interest. Supposedly you're doing something in the name of religion, but that's creating a not so harmonious environment, right? It's somehow instigating the riots and all that, right? So that's against public interest. So again, license can be revoked. Okay, so in all these situations, license can be revoked, and central government will direct that, okay, change your name. That means if you're a private company, add private to your name, and it may also pass additional orders. Additional orders like winding up if necessary in public interest. Here you need to understand one thing. What is that one thing you need to understand? Is that whenever a Section 8 company is being shut down like this, then you have to understand that winding up order may be passed. Winding up order may be passed is like whatever assets are there, sell off those assets, pay off the liabilities, whatever excess assets are remaining that are not going to go in the pockets of the members. Rather, it will be transferred to another company which has the similar objects. Okay. Secondly, the entire company may be sold, and the whatever sale proceeds are there, it will be transferred to IBC fund, right? Or there may be an order of amalgamation in public interest that, okay, let this company be amalgamated with this particular existing another Section 8 company, right? So that can also happen, right? Then we have certain provisions. Just a second. Right. Then we have certain provisions with respect to conversion of Section 8 company. Okay. Now, if you want to convert Section 8 company, the first basic requirement is that you must have had filed your financial statements and annual returns. Okay. If you want to convert Section 8 company, then there will be a notice which will be sent to the members, because you need SR. So first you will send notice to the members. Notice will be accompanied by explanatory statement that you send to the members. There is general meeting of the members, and in that general meeting you pass SR. That is the first thing. Okay, that is the first thing. So if you are converting Section 8 company into any other company, you need SR at general meeting. The next thing is that you need approval from regional director, right? So you will also make an application to RD, right? And you will give a copy of it to registrar. You have to attach a lot of things. You have to attach the proof that you have given it to the authorities, also what representation you have got from the authorities, right? And that is what you'll get. So you file an application to them also and a copy to registrar. Now within 1 week, you publish a notice in INC 19. That is a notice which is published in the newspaper, vernacular newspaper, English newspaper, and also the website of the company, right? So that everyone gets to know and they can raise objections if they want to. Okay. Right. So RD is going to issue order approving conversion, and thereafter company will call general meeting, pass SR, amend MOA and AOA, file it with ROC, and ROC will issue a new certificate of incorporation. So this is what actually is the entire process of conversion of Section 8 companies, right? Section 8 companies also have a lot of benefits, that if you want to call the meeting, general meeting has to be called by giving 21 days notice. But here you have to give only 14 days notice, right? They don't have any requirement of minimum number of directors. Otherwise, you have the requirement of minimum number of directors, that in a public company, there must be at least 3 directors. Here you don't have that requirement, right? They don't need to form those committees, nomination and remuneration committee and all like that, right? Okay, so I hope this is clear. Fine. Moving on to the next part. Alteration of memorandum. Alteration of memorandum is given in section 13, right? Whenever you want to alter the memorandum, it has to be altered by passing special resolution. First is name change. So if a company wants to change its name, can it do so? The answer is yes. How can it do so? By passing SR. Plus, you need CG's approval. So if you want to change the name of the company, you need CG's approval. However, if you're just converting a private company into public company, you're not exactly changing the name. But supposedly the company's name is ABC Private Limited. You're making it a public company. So you will what do? Delete this private and the name of the company now will be ABC Limited. So for this, you don't need CG's approval. Okay, for this, you don't need CG's approval. You can change the name of the company only if you have not defaulted in filing your financial statements or annual returns, or you have not defaulted and you have not defaulted in repayment of deposits, debentures, interest. If you have defaulted in that, then rectify that default, right? You cannot change it. Okay. Fine. So we have two things. This is about voluntary name change, which is actually given in section 13, And this is the procedure that I have already told you, that you make an application to CG, and once CG gives you an approval, you intimate the same to ROC that yes, my members have approved by passing SR, and I have also got CG's approval. You register my new name and issue me a new certificate of incorporation, right? Okay, so that is about name change. Okay, so registrar is going to enter the new name and in place of the old one, issue you a new certificate of incorporation. Fine. We will come to this a little later. First, we will complete all the alteration of memorandum, right? The second one is situation clause. Alteration of situation clause. Now, when I'm talking alteration of situation clause, it basically means that you are shifting your registered office from one state to another. Because if you're shifting it within the same city, it does not amount to alteration of memorandum at all. If you're shifting it from one state to another, then that is going to be alteration of memorandum, right? And for this, you need again CG's approval. So you make an application, you need SR for sure. Okay, you need SR for sure, right? So you have passed SR. No problem at all. Here, what you need to remember is that central government gets an application for change of registered office, right? Now, before approving, they will satisfy that you have creditors, you have debenture holders, you have other people, right? Have you made sufficient provision for their discharge of obligations, or you have provided them the adequate security? See, you could have done three things: pay their debts, make sufficient provision for their debts, or provide them adequate security. If you have not done this, CG is not going to grant you approval to shift your registered office from one state to another, right? Okay, so CG is going to satisfy that, right? There is an entire detailed procedure which has also been given, but you have to remember what I am telling you. Okay, so once you get CG's approval, I'll just come back. Once you get CG's approval, you have SR, you have CG's approval, right? You file this with both the states, right? So you file it with the registrar of the old state as well as the registrar of the new state, right? The registrar of the new state will actually give you or issue you a fresh certificate of incorporation, right? The third is change in object of the company. Change in object clause. Again, the object clause can be changed by simply passing SR. However, if you are a company, you issued prospectus, you raised funds from public. Supposedly, you have raised 1 crore rupees from public saying that I will do this and this. But now you're not going to do this. Now you're changing the objects and doing this. So you have taken their 1 crore rupees. They wanted you to invest in this, and that's why they have given you the money. But now you're doing something else, right? So if you have raised funds from public, and out of that 1 crore, you still have 10 lakhs remaining. That means you have raised funds from public and you still have unutilized money. You cannot change your objects just like this, just by passing SR. No, you have to pass SR through postal ballot. Okay, and how it will be done? the resolution is going to be published in the newspaper, English as well as vernacular, right? Wherever registered office is situated, it will also be placed on the website, and any shareholder, if he dissents, he will get an opportunity to exist. How he will get an opportunity? As according to SEBI regulations. Fine, so he'll get an opportunity to exit. That means if he doesn't want to continue, you will repay him. Okay, so this is going to happen. Fine. Once this approval is accorded, then you will intimate to ROC, and ROC is going to give you that, is going to certify that, right? And every alteration has to be noted, has to be registered. If you are just doing alteration in your own paper and not actually registering it with ROC, then it does not make any sense. It is not going to have any effect. Clear? Okay, so these alterations only we basically discuss. We don't discuss about alteration of capital clause or liability clause. Basically, we read in the chapter of share capital. Fine. Okay, now apart from that, we have certain other cases also where there may be change in the name, where there may be change in the registered office, right? So one name change is given in section number 16, which actually talks about rectification of name. So here you don't want to voluntarily change the name of your company, but you're forced to change the name of the company. Why? Because somehow the company got registered with an identical name. Although this does not happen when computer is at work, right? Now it's all AI. So this situation does not come across, but it may happen, right? So in such a situation, central government would direct the company to change your name within 3 months. And once you get that direction within 15 days, you have to intimate ROC with CG order, reserve a new name, and ROC will issue you a new certificate of incorporation. If you fail to do so, central government will issue you a new name, and thereafter you can voluntarily change your name if you want to. Okay. Second case. If there is a registered trademark, okay, like Book My Video, let's say, right? So it is a registered trademark, and there is somebody who formed a company with Book My Video Private Limited. Now, I might have an objection because I already have a brand name in this particular thing, right? So I raised an objection within 3 years of their incorporation. Okay, I have made an objection to ROC, and ROC is now what going to do? Central government works through ROC only. So central government is going to direct that particular company that no, change your name within 3 months, and the same entire process is going to follow. Okay. Secondly, if I want to change my registered office from one city to another, all I need to do is pass board resolution. From one city to different city within the same ROC, pass SR. That's it, right? From one ROC to another ROC within the same state, I need to get the permission of RD, and this I have already told you, right? Alteration to object clause also I have told you. Next is alteration of articles. Section 14 tells us about the alteration of articles. Again, it is something which can be passed or which can be done by simply passing SR. Okay, simply passing SR. If I want to convert private company to public company, I will pass SR. SR plus altered copy of altered articles of association, I will submit to ROC. Clear? But, if I am converting my public company to private company, see, public company is exposed to a lot of compliances. It has to disclose this, disclose that, right? It has taken funds from public. A lot of things might be there. Now it is trying to convert itself into a private company. So government will be like, wait, let me check. Right? So in this situation, you also need to obtain approval from CG. So SR needs to be passed. There will be approval from CG, and your altered articles of association, you will submit it all to ROC. This I've already told you. Right? You will submit it all to ROC. right? We have section 15, which tells us that every alteration that you have made in memorandum or articles has to be noted in every copy of memorandum of or articles. If you actually circulate any unaltered copy, then there is going to be penalty of 1000 for every copy, right? Okay, there is section number 17 basically, which tells us that if any member wants a copy of memorandum or articles, you have to provide them within 7 days of request. Okay, fine. Then we have section 19, which talks about subsidiary and holding. That subsidiary company cannot hold shares in its holding company, right? It's going to be like a vicious circle, right? So it is not allowed. However, there are certain exceptions. What are the exceptions? Exception number 1. If I am a subsidiary company, or let's say we have A Limited holds 10% shares in B Limited. Okay. Then B Limited acquired 57% shares in A Limited. That means A Limited is holding these 10% even before it became the subsidiary, right? So where the subsidiary company is a shareholder even before it became the subsidiary company, then that falls under an exception and it is allowed, right? Secondly, subsidiary company is holding the shares as a legal representative. Supposedly there's a deceased member and who has made this particular company as a legal representative, so it is not holding the shares in its own capacity, right? Or maybe it's holding the shares as a trustee. Okay, so these could be the situations. In these two cases you will get the right to vote, but in this case you will not get the right to vote. Okay, fine. Then we have section 20. Section 20 basically talks about the service of documents, that whatever document you want to send to the company or you want to send it to some officer, how you can do that. Registered post, speed post, courier, leave it at the registered office, or any electronic mode or any other mode as may be prescribed. So that is something which is allowed. Fine. If you want to send to the member or ROC, post or registered post, speed post, courier, leaving at the office, electronic or any other mode as may be prescribed. The only difference is here post is not there. Okay. Fine, these are some very basic detail, some very intricate details. Section 21, that if there is any authentication which has to be made, it is going to be made by KMP or any officer who is authorized. Then we have section 22, which talks about execution of bills of exchange. So if the company has to prepare a check or has to prepare a promissory note, right, whatever it is, then he may authorize somebody. If the company is having common seal, yes, in writing it may authorize any person as attorney in or outside India. If there is no common seal, then authorization shall be made by 2 directors, or where company has company secretary, by director plus 1 company secretary. Clear? Next, we are going to revise the chapter of prospectus and allotment of securities, right? If we talk from the Classification of Companies Act, it is chapter 3 and it comprises of sections 23 to 42. Right. Basically, this particular chapter is divided into 2 parts. The first part talks about public offer and the second part talks about private placement. Right. So, beginning with section number 23. Right. The very first section of this particular chapter talks about how can securities be issued. If we are talking about a private company can issue securities by way of private placement, which we talk about in section 42, part 2. Right. Secondly, it can issue securities by way of rights or bonus. Right, both of which we read in the chapter of share capital, right? So we have rights issue, section 62 followed by section 63, right? So we have rights, bonus and everything that we read over there. Okay, if I talk about a public company can definitely issue securities by way of private placement, rights, bonus, and it can also issue securities to public through prospectus by complying this part 1 of chapter 3, which is all about public offer, right? So if I'm talking about making a public offer, if there's a private company and it wants to raise funds by issuing securities could mean equity shares, it could mean debentures, bonds, whatever we are talking about, right? Securities is a wide term. So a private company wants to raise funds by issuing securities, it can do so only by private placement or rights or bonus, right? Bonus is simply capitalization of profits. It's nothing, you're not taking anything from people, but you're just capitalizing your profits and issuing them additional securities. However, when we're talking about rights issue is you are issuing securities to your existing shareholders, right? So you're giving a preferential right kind of thing, right? You're giving a right to your existing shareholders that I am in more need of money. So I want to issue 100 more shares. Are you ready to buy it? So you're giving an offer to your existing shareholders. If they accept it, great. If they don't, then we have the further procedure, how to approach, right? So a private company can do only that. But when we're talking about a public company, because private companies are prohibited to make public offer, right, to subscribe to their securities, but a public company can do so. So public company, if you want to make a public offer, if you want to raise funds by issuing securities to public, then you have to comply with part 1 of chapter 3. Part 1 of chapter 3, which talks completely about public offer. What are the different types of public offer that we have? IPO is when a company makes an offer for the first time. Initial public offer. FPO is further public offer. So if you've already made a public offer and you're making a public offer again, that is FPO. And there is something called as offer for sale. Offer for sale is a public offer of existing securities that we'll talk about. Okay. So all this is done by issuing prospectus. There are certain cases where prospectus is not needed. I'll exactly tell you what prospectus is. We're here to revise the entire thing, right? So you have to comply with part 1. Along with that, you also have to comply with SEBI Act and regulations in case of listed companies. Of course, any company which is making a public offer will be a listed company for sure. Because whenever you want to make a public offer, the first requirement is to make an application for in principle approval of listing to any stock exchange that you want to. Unless you get that approval, you cannot proceed with a public offer. So if your approval is denied, there is no way that you can go ahead with a public offer, right? So every company who has made a public offer will definitely be a listed company. Okay, fine. So we'll talk about the related section. Securities, you don't need to. Now, what do we mean by prospectus? See, prospectus ideally is defined in section 2 clause 70, which simply says that any document, let it be red herring prospectus, let it be shelf prospectus, let it just be an advertisement, a circular, a notice, which is actually inviting public. Okay, then see, prospectus is basically not an offer. It is an invitation to offer. Why it is not an offer? Because supposedly there is a company which has issued prospectus that the company wants to issue securities, 1 lakh securities at the rate of 10 each. Okay, let me be very practical and make you understand in the situation of the practical world. There are so many IPOs which come, right? We have this company's IPOs coming, etc., and we are applying for the IPO, but not everyone gets the IPO. Right? Some people get did you get that IPO? Oh, no, the company didn't allot it to me, right? So if it was an offer, if I applied for the security, if I applied for that share, if I applied for IPO, that would be an acceptance and that would amount to a promise. But no, it is not so. That is an invitation to offer. Then I, by applying to that IPO, is making an offer, and the company, if accepts or allots, that is acceptance of offer, and then that becomes a binding promise, right? That's how it's actually happening. Now, right. So basically we have a beautiful section number 26, where we talk about the prospectus. Okay, there are a lot of things which are given for prospectus. Earlier, the section used to be very long. Now it's not that long, but still we have a lot of content to be read, right? Prospectus is actually needed to help the investors take an informed decision. Why? Because it will have so many details which are mandated by law, that if you're raising funds from public, they are gullible investors, they might not be knowing, they might not be aware of the entire happenings, everything, right? Because even if I talk that okay, I am going to invest, I might be knowing certain things about a certain company but might not know certain things about a certain company, right? And I believe I should be highlighted with at least the basics, right? So that is why law has mandated certain things, that if you want to raise funds from public, you must give them an offer document which should contain these details, at least this information, that if you're raising fund from them, you should tell them what you're going to do, right? Who is behind you? Who is the promoter? There's a lot of things. Where have you got the approval? Where will listing be done? So there are a lot of details which are required to be inculcated in the prospectus. If the question is asked, what details are there to be stated in the prospectus, then we have section 26, which states the matters, and it clearly says, okay, let's move further. Let's move further. Okay, I will first take you through that. Yes, here is section number 26. Fine. So the first thing that it tells us, that every prospectus is going to be dated. So there must be date on the prospectus, because prospectus also has a life. What is the life? The prospectus is going to be valid 90 days after a copy is delivered to registrar. So once you have prepared the prospectus, you also deliver a copy to registrar. Earlier there was mandatory registration, now it's simply filing. So you give the copy to registrar, they keep in their records, and now whatever prospectus is dated, then it has a shelf life, or it has a validity of 90 days only, because after 90 days a lot of events, a lot of information which you have written in that will tend to change, because the scenario has changed, because maybe the financials have also changed, maybe the company is now running into losses, and the people who are actually investing in the company need to know that, right? Okay. Now, every prospectus which is issued is going to be dated, is going to be signed. It is going to contain the information as specified by SEBI in consultation with CG. As specified by SEBI in consultation with CG. Now, there is another thing which is written, that SEBI, until specifies such information, whatever regulation SEBI has made under SEBI Act in respect of such information shall apply. So now, to know what should be written in prospectus, we actually need to go through the regulations which have been made under SEBI Act. We are not getting the information here under Companies Act, because under Companies Act, SEBI with consultation to CG has not prescribed anything. But under SEBI Act, therein they have made the regulations, and those regulations specify that what information and what reports must be given in the prospectus. Okay. Now, apart from this, there is also going to be a declaration. Okay, a declaration of compliance and a statement that whatever we have written in the prospectus, there is nothing contrary to SCRA and SEBI and rules. SCRA is what? Securities Contract Regulation Act, and SEBI, you very well know, Securities and Exchange Board of India Act, right? So there is nothing in contravention to these acts as well as the rules, right? So this is going to be written. This is going to be written as the content. Okay. Apart from that, there is an expert statement. Expert statement may be included in the prospectus, but it will not be included if he is not engaged, not to be included unless he is not engaged in formation, he has given his consent and not withdrawn it. Above points are mentioned in the prospectus. So one thing, he should not be a promoter, right? He should not be involved in the formation of the company. The second thing, he must have given the consent and he must not have withdrawn the consent. And third point, you must have written these things in the prospectus. So only then you can incorporate expert statement also in prospectus. Validity, I've already told you. There will be a clear disclosure on the cover page that a copy of prospectus is already filed with ROC and what documents are attached with the prospectus. So this is basically what is written in section number 26. If you do not comply with the provisions of section number 26, there is punishment for the same. Okay, fine. We come back. Now, if the company wants to raise funds from public through issue of prospectus, that is known as public offer, we have section 40. Section 40 tells us that whenever you want to make a public offer, what you should do is make an application to the desired stock exchanges for listing. If you have made an application to, let's say, 3 stock exchanges, you must get approval from all 3. If you have made an application to 1 stock exchange for listing, you must get approval from that, right? So rejection by even one of them will amount to complete rejection. Fine. So if permission is granted by all, then only you can proceed with. You have to prepare the prospectus. You have to include the name of stock exchange from where you have got in principle approval from listing. For listing, right? Thereafter, you will send it to ROC for filing. Within 90 days, you have to give the offer to public along with the application. You receive the application money. Nowadays, it's all the money is blocked. People don't actually remit you the application money, but the money is blocked. If the share is allotted, the money will float to the company. If it is not allotted, then it will be released, right, by the bank itself to the customer, right, to the investor. Money collected to be kept in separate account. If minimum subscription is received, then allotment shall take place and you will refund excess money. Now money can be used, but no variation in terms of contract. However, if minimum subscription is not received, you will refund all the money. Now, one by one, we are going to read it in detail. But before that, what do we mean by variation of terms of contract? Because as I said, there is not going to be any variation on terms of contract. Where is variation? Okay, I'll go with the same sequence as I have written. I will not switch here and there. It will only create some confusion for you. Okay, so here till so far we have done. Let's begin with the allotment part, right? So we have first made an application to stock exchange for in principle approval. We have got the permission. We have filed the prospectus with ROC. Within 90 days, we are issuing it to public. That means the public offer is made, right? Okay. When we issue the same to public, right? We have a proper platform. When we issue the same to public, within 30 days, we must receive minimum subscription. What is minimum subscription, ma'am? Minimum subscription amount is basically 90% of whatever amount we need, right? Supposedly, we are raising funds of 1 crore. Then at least 90 lakh application we should receive. Now 90 lakh doesn't mean we are actually receiving 90 lakh but worth 90 lakh shares, right? If I'm raising securities worth rupees 1 crore, if I'm asking the people to buy securities worth 1 crore, maybe I will take the money in phases. That could also be the situation. It doesn't matter. But then whatever, and that is clearly stated in the prospectus. So minimum subscription amount will clearly be stated in the prospectus. Fine. So whatever amount is stated, you have to achieve that. No shares are going to be allotted to public until that minimum subscription amount is received. So of the entire issue, 90%, that is the minimum subscription amount. Now don't get confused with the application money, because there is also something called as minimum application money, right? Supposedly your share price is 100, right? Then a minimum application money has to be 5. This is, let's say, face value. It has to be 5. This is according to section number 39. However, if I talk about SEBI regulation says 25% of the issue price. So let's say the issue price is 200. So it will be 50 according to SEBI regulations. Okay. So point number 1, minimum application money, whatever amount is payable on application should be at least 5% of the nominal amount according to the section and 25% of the issue price according to SEBI regulation. Second, unless you receive minimum subscription, you cannot proceed for allotment, right? Third, supposedly minimum subscription is not received. If minimum subscription is not received, people usually, now all the IPOs are oversubscribed, usually, right? But there was a time when this was a problem, this was a concern, that what would happen, the companies would want 1 crore and they got applications for only, let's say, 40 lakhs. So they took all the money, but then they could not meet their fund requirements, because to start that project, they needed 1 crore. Now they'll have to look for other ways to arrange those funds. And if the funds are not arranged, what happens is the funds collected are actually all turned into ashes, right? So for this particular reason, minimum subscription holds a very important place, right? Now, if it is not received, what will happen is you have to, within 15 days from the closure, you have to refund that amount to the same bank account. But yes, if it is received, we will go ahead and allot the securities and also file the return of allotment within 30 days. What is written in the return of allotment? To whom we are allotting the securities, contract of securities for issued for other than cash. See, sometimes it may also so happen that we are issuing somebody the securities because we have taken some asset from them, and in against those assets we are issuing securities, right? So in those cases, in those rare cases, because we file this return of allotment in all the cases, right? Even if it is public offer, even if it is not public offer, we have to file the return of allotment. So this also will be there. Okay, registered valuer report for these are not required in all the cases, but these are required in different cases. But when I'm talking about the return of allotment, the contents are all listed over here, right? Resolution in case of bonus shares, because when we're issuing bonus shares, a resolution is passed, right? So that resolution and all of that content is required. Okay, now we come back. We made an application to stock exchange. We got permission from stock exchange. We filed the prospectus with ROC. Within 90 days, we have issued the prospectus to public. The offer opens. Whatever money is received, that is kept in a separate bank account, right? That is an escrow account which is being opened. The offer closes. We have to check whether we have received minimum subscription or not. If we have received minimum subscription, we can go ahead with the allotment. But if we have not received minimum subscription, we have to refund the same. If money is not repaid, then there will be a liability to pay interest also. Okay. Once we have allotted the securities, then we will file a return of allotment to registrar within 30 days, right? There are attachments which needs to be attached along with the return of allotment. Okay. So you have to understand basically one thing, that whenever a company is making a public offer, it must issue prospectus, right? One thing. Prospectus must be filed with the registrar before you can make a public offer. You must get in principle approval of listing from the stock exchange before you make a public offer, and this fact must be stated in the prospectus also. You must receive minimum subscription, then only you can then only you can proceed for allotment. Your application money should not be less than 5% of the nominal value of security, right? After making allotment, you must also file return of allotment. Whatever money you have received as an application money should be kept as in a separate bank account. So all these are the basic requirements that we have read so far. Okay. Fine. Default, I've already told you. Not required. This is something that I've already told you. Right. Now comes the next thing, which is talking about misstatement. What is misstatement? See, misstatement could be hiding something which must be told, or it could also mean something untrue statement. So prospectus basically should disclose all the material facts which are likely to influence the decision of investors, right? Just a second. Right. Okay. That is, it must be free from misstatements. Now, basically, there are two important sections section number 34 and section number 35, right? Section number 34 talks about criminal liability and section 35 talks about civil liability. Okay. Section 34, see, supposedly you are driving on a road and you, let's not talk about you, let's supposedly Mr. X is driving on a road and he met with an accident. Now, he was driving at a very high speed, so he has somehow violated a law for which he should be punished, right? That is criminal liability is being attracted to him. At the same time, because of him, somebody else has suffered damages, so he must also compensate that person and give damages to that particular person. That is civil liability, because you're liable towards civil people because they have suffered some losses because of you, and the other is you have violated a law, so you are also liable criminally for a punishment. So that is exactly what the scenario is over here also. So if there is a prospectus which includes any untrue statement or any statement which is misleading, right, then every person who has authorized that issue of prospectus is going to be liable under section 447. What is section 447? Section 447 actually gives us the punishment for fraud, and it says that it has different I wouldn't suggest you to learn this, right? But of course I have told you this, right? So there is a penalty and there is a punishment which has been given in detail about section 447, right? Now, if you prove that no, I had proper grounds to believe that this is true, and that is why I signed on this prospectus. I actually believe the statement to be true, because whenever we are vouching on any information, we always say to the best of my knowledge and belief. So I actually, if you can prove that you were innocent, you were not involved in the fraud, you actually at the time of prospectus, you believe that it was true, and this was not required, then you can always get that defense and you can be saved from that liability, you can be saved from that imprisonment, penalty and everything. Now, section 35 actually tells us that if there was a misstatement and on the basis of that misstatement, somebody relied and he suffered some loss or damage, then the director, the person who has authorized himself or is named in the prospectus as director, who's promoter of the company, right, who's an expert, then they are going to be liable to pay damages to that person who has sustained loss. So the first prima facie requirement over here is loss. If there is no loss, then there is no section 35 which gets attracted. Again, if you can prove this, that no, I consented to be the director, but when I got to know about all these malified intentions, immediately I withdrew my consent. So if you can do that, if you can prove that, then you're not liable, right? If you can prove that this prospectus was issued without my consent, I didn't even know that my name is incorporated over there, and when I got to know this, I immediately gave a public notice, you are away from that liability, right? And the last point, with regard to every statement which is made by the expert. Now, sometimes what may so happen, if I have to take an opinion of a doctor, right? I believe that particular doctor to be competent enough, and he gave this, and I went to some other person and told, look, this particular person is suffering from this and this is the medicine. So I have also conveyed the same to one of my employees, that this is what we have got, right? Now, can they actually, if that prescription or if that diagnosis or if that medicine is found to be untrue, can they actually blame on me? Yes, they can, but I get that defense. No, that I completely relied on that doctor. The same goes over here also. If there is a valuation report, right? Now that valuation report, I have relied on that valuation report. I thought that the person who is making that report is competent to make it. That person had given his consent. That person had not withdrawn his consent, right? So I have signed on the basis of that only. If that report is found to be untrue, how am I responsible, right? Because I have incorporated a correct extract of that report, and that report is made by a competent expert person, right? So that is also a point of defense. Fine. That is also a point of defense. Fine. If I go on to the same league, we also have section 36. Where's section 36? Just a second. Okay. Section 36 actually talks about punishment for fraudulently inducing people to invest money. Sometimes we have a lot of people who are coming over and who are saying that no, this is a stock in which you must invest, and look, you will make it will be just you invest 50,000 and it will be 1 lakh in just 2 days, right? So anyone who is making any statement, any false promises, any forecast, right, any deceptive, misleading information, right, and trying to provoke, trying to induce the other person that no, you enter into this underwriting agreement, okay, or you acquire these securities, or you sell these securities, right, or you enter this into this this particular agreement where we are not going to, you are not going to sell the securities, you are not going to buy the securities, but you are going to get the profit, right, from the fluctuation of securities. So you're entering into an agreement that, okay, you're not buying, you're not selling, that is not your purpose, you're just enjoying. That is actually something which is not allowed. Fine. Or you are inducing someone to enter into an agreement for obtaining credit facilities from the bank. Right? I have explained you all these points in detail in the class. Right? By giving you examples what exactly it means, but right now it is not the time to get into those many details. But in such situation also, what happens, that if there is some person who is inducing people to enter into such agreement to acquire shares, agreement to sell shares, agreement to underwrite, right, agreement to just get the benefit of profit by fluctuations in prices, or to enter into an agreement because you want to get some credit, or you want to get some loan from bank, right? So you are inducing that particular person that you invest because you want to obtain some loan, right? So in all these cases, the person is going to be again liable for section 447, because apart from the directors, apart from the people who are involved or who are charged under section 34 and 35, there could be a lot other people who are actually involved and who are doing this. Likewise, in the league, we have another section called as section 8, which talks about punishment for personating. Personating is what? You are making an application in a fictitious name. I am Shivangi Agrawal, but maybe I'm making the name in Queen Elizabeth, right? So this is what it is, a fictitious application. Maybe you're making to get shares in some fictitious name, or maybe you're making multiple applications in different names. Like I'm making one application only in the name of Shivangi, one in the name of Shivangi Bhargav, right? One in the name of Shivangi Agrawal, right? So why am I doing this? This is personating, maybe to acquire a lot of securities, maybe not to be in the we have read the concept of beneficial owner, registered owner, so now you understand the whole scenario, right? Or I am otherwise inducing the company to transfer the securities in a fictitious name. So in all these cases, again, the person who is doing this will be liable for fraud, section 447. Okay, fine. Now we start with the different types of prospectus. The very first one, abridged prospectus. What is abridged prospectus? It is basically the short prospectus, right? So it is containing all the salient features of prospectus, what are specified by SEBI, along with every form of application. There will be an abridged prospectus, because the prospectus in original, they are of 350 pages, right? So nobody can actually go through the entire prospectus unless they are very curious and they are making a very huge investment and they are competent to read it. Then of course they can ask for full prospectus and they'll get it. Otherwise, there is a abridged prospectus which is attached with every application. Fine. Then we have shelf prospectus. What is shelf prospectus? As the name suggests, it has a shelf life, right? It has a validity. Okay. Now, basically, it has a validity of 1 year, first of all. And shelf prospectus is not something which is issued for every type of securities, but only for some specific type of securities. Okay, so it is allowed only for that specific type of security. So there is a company, or I would say there are certain class of companies, as SEBI may provide, they can file a shelf prospectus with the registrar. Why? Because they want to raise fund in phases. They want to raise funds here, then again they want to issue some securities here, then again they want to issue some securities here. Right? If they're doing this every time, making a prospectus, filing a prospectus, issuing a prospectus, it takes a lot of time. Right? So they make a prospectus, and when they're making the first offer, they will file it with ROC and they will make the public offer. Right? And this is going to be valid for a span of 1 year. Now, during this 1 year, every time when they are issuing securities, they don't need to re-prepare the prospectus because they already have a prospectus ready with them. Right? So what will happen is, if you're filing shelf prospectus, you only need to file information memorandum. The information memorandum will basically contain the details like what are the new charges which have been created. New charges means you have read in the entire chapter of charges. Right? What is the new charge which has been created against any asset of the company? What is the change in the financial position of the company? Right? So all these details. So when the second or any subsequent offer comes, before that, prior to that, you will file this information memorandum. An information memorandum along with the shelf prospectus, which was along with the prospectus which was originally filed is actually known as shelf prospectus. Right? Now, it may so happen, see, prospectus which does not require to be reissued for one or more issues over a certain period, it has a validity of 1 year. Right? Information memorandum in PA is to 1 month prior to the issue of subsequent offer. This is going to be the content, effect. This is the prospectus, right? This I have already told you now. The only thing I need to tell you now is, if there is some person who has already made an advance payment, right, before the change of information memorandum, right, I have already given an advance payment that, okay, this is the prospectus, on the basis of this we are going to issue. Right, now the information memorandum is filed and I get to know, oh my god, the company's financial position is deteriorating and I don't want to invest this now. So the company will intimate to such person, and if that particular person agrees, great. If he doesn't agree, you will refund that amount within 15 days. Okay. So whatever subscription he has given, that will be refunded. Next is red herring prospectus. You will understand this very well in CMA finals, because basically you'll be reading about IPO, you'll be reading about SEBI regulations, right? But right now you have to understand that red herring prospectus is something which does not include all the details. I want to issue securities, but I don't know at what price the people will be willing to buy the securities of my company. So I have a price band. Maybe I can give my securities at 100 also, and I can give my securities at 500 also. So 100 to 500 is the price band. Whatever you want to quote, whatever you're willing at, supposedly you're willing to buy the security at 300, you will quote that. Right? Now, if the closing price is 300, then of course you'll get it. If the closing price is 400, you're somebody who's only willing to pay 300, you'll not get it. Right? So there is a whole system how it works, right? But there are complete details are not given in red herring prospectus. So company basically issues this prior to issue of a prospectus. Fine. So what you're doing is you're filing it with registrar at least 3 days prior to the opening of subscription list. Right. Now what they're doing, you have to give all the details of the prospectus and red herring prospectus also. It's just that certain details are missing. Now once you have filed red herring prospectus, there are people who have quoted the price, quantum, whatever it is, right? The offer is closed. Fine. Whatever is the variation, now you have the final prospectus, whatever is the variation between red herring prospectus and final prospectus is actually going to be highlighted. Fine. So the prospectus is going to state what is the capital which has been raised by debt, by share capital, what is the closing price, right? What details were not included in the red herring prospectus, and everything is going to be filed with ROC also, and as well as with SEBI also. Okay. Right. Fine. Now, the next section or the next type of prospectus, that is deemed prospectus, section number 25. Deemed means this is not exactly as prospectus, but it is deemed to be treated as prospectus. So if there is a company which allots or agrees to allot securities with a view to get it offered to public. Now, I know that if I am a company and I am going to allot securities to public, I will be exposed to so many compliances. Babare, I have to issue a prospectus, I have to file it with ROC, I have to do this, I have to do that. There should be this in the prospectus. This information also has to be disclosed. Oh God. So what I did is I hired an issue house, merchant banker, whatever it is, right? So I went to them and I sold them 500 shares. And I told them that you offer this to public, right? So I'm not making a public offer. I'm not exposed to all these compliances and regulations. Law says, wait. If you allot the securities by way of private placement with a view to get it offered to public, your intention is to get it offered to public, then this issue house is going to offer it to public through some document, and that document will be deemed as prospectus. And now that document must state all the requirements, must fulfill all the requirements of prospectus. It should also state the amount of consideration received, where can this particular document be inspected, it has to be signed by 2 directors, right? The rules of prospectus are going to apply to deemed prospectus. All this will apply. Ma'am, how will we get to know what is the intention of the company? Is it deemed in all the cases? No. See, if the company allots or agrees to allot securities with a view to get it offered to public, if the view is clear, of course, it is prospectus only. But why will the view be clear? Company will take a direct route of allotting securities if they're very sure. If they're using this route, that means they want to hide something, right? So we need to check. It may so happen that company has allotted the securities to issue house and issue house is offering it to general public. It's their call. They can do that, right? They take a lot of securities. They might offer it to public. So it is their call. They can do that. But how to get to know that whether company's intention was so or not? So we get to know, or we identify company's intention in these 2 cases. If company has allotted the securities and issue house or allottee has offered it to public within 6 months, they cannot take such call. That means it was pre-planned, it was pre-decided, it was company's intention to do so, and company is using this indirect route to make a public offer, right? Or when company has allotted securities to issue house and they're offering it to public at that particular point of time, this issue house has not paid the entire consideration to company. See, if I am a shopkeeper, I take the goods on credit and I tell to them that you give me the goods. When I sell these goods, I will give you the money. That is what I do, because I have a very clear-cut intention of selling it to public only, selling it to other persons only. If I have the intention of using it on my own self, I have the money, I'll of course pay it, right? The same goes over here. If the issue house has the intention not to offer it to public immediately, if they have this agreement that, okay, I am selling you, they are buying the securities, I am selling them only the securities, then the consideration will also be paid. Okay, so in these 2 situations, it is presumed that allotment was made with a view to offer for sale to public only. Okay, so that is deemed prospectus. There is another section called as section 28, again where we read the concept of deemed prospectus. But here, there are certain members of the company. There are a lot of cases when the promoters want to dilute their shareholding, right? How they want to dilute their shareholding. I have, let's say, 40% shares in a company. Now that 10% shares of this company I want to offer to public. Can I do so? Yes, you can do so. And you can do so according to the provisions, right? In consultation with board of directors. There could be individuals, there could be body corporates. If they want to offer their holding to public, it can be done only in consultation with board of directors. So the offer is made to public and that offer document is known as deemed prospectus. Here, you don't have to comply with the minimum subscription requirement, minimum application, right? All these are not required, right? This document will be deemed as prospectus. So all the requirement of prospectus will apply here also, except a few. And members will authorize the company to do everything on their behalf. However, they will reimburse the expenses in this regard. Okay, I had this written this over here. Clear? Okay. Now, there is also called something as Section 37 class action, which basically I didn't tell you. If I'm talking about Section 34, 35, 36, usually it's not just one person who is affected by it, but it is a group of persons who are actually affected by the same, right? And every person is making an application, is going to NCLT, right? Complaining about this, complaining about that. So this is a class action section which allows a group to make an application. Okay, so this is nothing but a group action by investors. It is very cost effective, and of course it is very effective also otherwise, because there is a lot of weight in the application. There are so many people who are affected and it is clearly evident on paper, right? Okay. Then we have Section 30, which talks about advertisement. So whenever you are advertising the prospectus, then that advertisement also must contain the objects, liability, share capital, signatories, and capital structure, right? Fine. Once you have raised funds from public through prospectus, you cannot vary those terms of contract, or you cannot alter the object clause basically. So alteration of object clause that we have read is exactly the same over here, right? So if you have unutilized money, then you cannot vary the objects unless SR is passed through postal ballot, and there is the details published in the newspaper, and the dissenting shareholders are being given the exit opportunity according to SEBI regulations. Fine. Okay. So this I have already told you. Now, securities in demat form. Section 29. Every company which is making a public offer, and of course the promoters holding, that has to be in demat form only. Unlisted public company in demat form only. Others in demat form only. Voluntarily it could be in demat form or physically also, but now I would say this is actually obsolete, because now we need to have the securities in demat form only. Now, Section 40. Section 40, one part we have already dealt with. The other part is underwriting commission. Can underwriting commission be paid? What is underwriting? Underwriting is basically a guarantee given by big issue houses, merchant bankers, and all that. What they are doing is they're giving us a guarantee, because we are coming up with a public offer. What if the public does not subscribe to our security? So we underwrite our issue. 100% issue also must be maybe underwritten, 50% issue may be underwritten, right? So proportionately that comes out. Supposedly 100% issue is underwritten, right? So I wanted to raise funds of 50 lakhs. Now people have subscribed to only 30 lakh, and I have 100% issue that is underwritten. So 20 lakh these people will actually take, right? So that is how it works. For them, they get the commission also. Later on, they can do a lot of things with the shares, right? So what is the commission that may be paid? First thing, you can pay the commission if it is authorized by articles. Secondly, it must be disclosed in the prospectus. Thirdly, you're not going to pay any commission on the securities which are actually not offered to public. If you are issuing securities privately to some angel investor, to somebody like that, on that you will not pay any commission, okay? Then contract of commission will also be delivered to ROC along with the prospectus. The maximum commission that you can pay is 5% or the rate in articles, lower of that. In case of shares, in case of debentures, 2.5% or the rate in articles, whichever is lower. And here we are talking about issue price. Supposedly the issue price is 100. What is 5% of 100? That comes out to be 5. Supposedly in articles it is given that 4.5% of the issue price, then maximum you can pay is 4.5% only. Fine, maximum you can pay is 4.5% only. Okay, next we move to private placement section 42, read with rule 14. right? So what is private placement? It is a way of raising securities privately, and it can be done by both private company as well as public company. So public company can also raise securities, issue securities and raise funds through private placement, and so can a private company do so. Okay, right. Now, there are two types of securities that we're talking about in this particular section. Type 1, non convertible debentures, which cannot be converted into equity, and then there is other type of securities, right? So convertible debentures, preference, equity shares, everything is included in the other type, right? So first of all, I'll talk about others, and then I will tell you the difference. What is the difference in this particular type of security, right? Fine. Now listen to me very carefully. How and what is the process? To issue securities through private placement, what you need to do is give notice of general meeting along with explanatory statement, call general meeting, pass SR. So you'll take the consent of your members that can we go ahead with the private placement. If they say yes, then you are going to go ahead with the same. Now what is going to happen is board will identify some person, because it is not a general offer made to any. You are identifying, okay, I am giving this offer to these 5 people to take shares. So privately, I am issuing shares to these 5 people. You can do that, right? So they have selected a group of persons who are identified by the board, and they're also known as identified persons. These persons cannot exceed 50. These persons cannot exceed 50, but ma'am, we have read something else. Or such higher number as may be prescribed. Or such higher number as may be prescribed. Right? So, you have identified those persons. You are going to issue private placement offer cum application PAS4 to those selected persons only, right? Maximum 50, higher prescribed is 200, right? So we go by the prescribed, of course. So 200 is the limit that we have, right? But you have to remember this also to write in the section, right? So board has identified some person, they record the same. Within 30 days of recording, they're going to issue them this application, and they can subscribe by sending money through check. Within 60 days, you are going to go for the allotment. Whatever money they have subscribed to, you are going to keep it in a separate bank account. Point number 1, there will be no renunciation right. What is renunciation? The right to transfer. I have been given this right to subscribe to this particular security because I am the identified person. Now I say I don't want to take these shares, but they are offering at a good price. Why don't you take it? No, you cannot do that. This particular offer can be accepted only by the person to whom the offer is made. Okay. The record will be maintained in PAS 5, right? Allotment, very simple. Within 60 days, there will be allotment. If there is no allotment, then refund within 15 days. If you don't refund, then there will be interest at the rate of 12% per annum from 50th day. If you allot, great, file return of allotment within 15 days and form PAS3, there is going to be penalty for non-filing. There are some additional points which you must remember. What is the additional point? What is the additional point? No new offer unless the allotment is completed or abandoned. See, first thing, whenever I'm talking about this private placement offer, or whenever I'm talking about this limit, it is basically for every security, right? It is not that it is the limit is in consolidation. No, it is the limit is individually for every type of security, right? So if I'm making an offer, let's say I'm issuing debentures to 50 persons, and I again want to issue some equity shares or some preference shares to again 150 persons. Can I do so? The answer is yes, I can do so. Right? If I want to issue to 200 persons, can I do so? The answer is again yes, you can do so. That is not the problem. But the problem is that one offer should be completed. That means the allotment should have been done. Then you can start with the other one. And you have to keep in mind the entire, the limit which has been prescribed, right? When I am saying that explanatory statement has to be given, what are the contents which you will write in the explanatory statement? What are the particulars of offer? Which security I'm offering? What is the price at which the security is being offered? What is the valuation? Who has done the valuation? Right? How much amount you intend to raise? Other terms and conditions. So all these will be written. All these will be written. Okay. So I hope this is clear. Apart from that, if you do not comply, there is penalty which you can learn, and that's it. And one very important thing, that when we are talking about the limit of 200, then that is not going to include your QIBs, and that is also not going to include your employees under ESOP, right? So this limit of 200 is going to exclude both of these, right? So it is going to exclude both of this limit is for every financial year. So in the new financial year, the limit gets renewed and you again get that fresh limit. And the restrictions that we are talking about, it would be reckoned individually for every kind of security, as I already told you, right? If I'm talking about NBFC, if I am talking about housing finance companies, they are not required to comply with all these, right? If at all there is a company, maybe it is a listed company, maybe it is an unlisted company, it makes an offer, or you can say invite public, or what, not invite public, but it makes such an offer to more than the prescribed number. Let's say it has made a private placement offer to 250 people, right? Then what it will be? Then it will be treated as a public offer, and you need to comply with the provisions of part 1 of the chapter. Fine. So it will be deemed public offer. Of course, we're talking about a public company only. A private company cannot make a public offer. Okay, fine.
Hi everyone, let's now revise the chapter of share capital and debentures, chapter 4 of Companies Act 2013, and it contains section numbers starting from section 43 till section 72. So first of all, what do you mean by share? Share is defined in section 2, and it clearly says that share is share in the share capital of the company, right, and includes stock. So that smallest unit basically in the share capital of the company is called as share, which is a movable property which can be transferred from one person to another. Of course, in a private company, it is transferred subject to the restrictions. In a public company, it's freely transferable, right? As regards different types of share capital, although the Act recognizes 2 types of share capital, equity and preference, but prima facie we need to understand the different categories of share capital. The first one being the authorized capital. What is authorized capital? Authorized capital is the highest capital which may be raised by the company and is mentioned in memorandum along with its classification, or along with its bifurcation, right? Okay, then we have the issued capital, which is issued by the company, subscribed capital, which the people have taken up. Then out of that subscribed capital, some part may be called, some may be uncalled, right? Whatever is the called capital, out of that, some part may be paid by the people, some part may not be paid by the people. So it is paid and unpaid capital, right? Ultimately, the paid up share capital, which has been issued by the company, taken up by the people and paid, right? That is there in our balance sheet figure as equity share capital. Okay. Or as of that matter, even preference share capital. But now, when we start with section 43, the first thing that we come across is the 2 types of shares, right? That is equity shares and preference shares. First of all, what do you mean by equity share capital? Equity share capital is something which is not preference share capital and is of 2 types, with voting rights or with differential rights, maybe as to dividend, as to voting. Okay. So with normal voting rights, they are also called as plain vanilla. Okay. What are preference share capital? Preference share capital is something which has a preferential right. Share capital, the concept
is all about the company needing funds. Whenever company need funds, it can go to a bank and take loan. That is a kind of debt, right? Likewise, it can take loan from general public, or maybe from five four people, right? Identified people, or maybe general public, by issuing different instruments like debentures, bonds, right? That is again a form of debt, right? Or it can raise funds from people by issuing them shares, that is equity participation, or by issuing them preference shares, that again has certain rights attached to it. So equity shares and preference shares both are a part of share capital, however they have some different rights. What are the different rights? Whenever I'm saying preference share capital would have a preferential right of repayment and dividend. Okay, what dividend? That if the company is making a lot of profits, the company can pay away a portion of these profits to its shareholders, that you guys have invested into the company, this is the profit that the company has made and it wants to distribute among you all. That is dividend, right? Now this dividend, first of all, it will be paid to preference share capital, which is fixed as a percentage, as an amount. Thereafter, if some part is left, some money is left, and the company wants to declare, it can go ahead and declare the dividend and give it to equity share capital also. That means preference share capital have a preferential right of dividend, right? Likewise, they also have a preferential right of repayment. When the company is going to be wound up, the first payment shall be to the creditors, secured creditors, right? Unsecured creditors, whatever it is. Then preference share capital, and lastly, equity share capital. Okay. We have different types of preference shares. We have cumulative, non-cumulative. Cumulative, where your dividend gets accumulated if it is not paid by the company. Non-cumulative, it doesn't. It is just if the company does not pay, it's all gone, right? So whenever the company has sufficient profits, it will pay. If it doesn't have, it will not pay, right? Then participating and non-participating. See, preference shares have a preferential right of repayment and dividend, whether or not they are participating in the surplus or not. What does it mean? When the company is being wound up, everybody is paid off their amount, and whatever surplus is left, that is distributed amongst the equity shareholders, right? It may so happen that preference shares are issued on the condition that whatever surplus will be left, you will also get a share in that. So they may be participating, they may be not participating. Then you have convertible, which have the option to get converted into equity, non-convertible otherwise. Redeemable and non-redeemable. Redeemable means after a certain tenure, they will be repaid, and non-redeemable during the lifetime of the company, they will not be repaid. So non-redeemable preference shares cannot be issued by the company. Okay. Now, when I say equity shares with different voting rights or different dividend rights, first of all, we need to understand what exactly are voting rights. So who has voting rights? Equity shareholders have the voting right, right? So they can vote on every matter which is placed before them. Wherever you need to ask the members, ordinary resolution needs to be passed, special resolution needs to be passed, you need to go and ask them. Okay. Now, in case a basic thing, that there are two types of voting which happens. One is voting by show of hands, wherein one shareholder will have one vote. Then there is voting by poll, which is standard. One share is equal to one vote. So if I have 10 shares, I have 10 votes, right? And if the company has issued 100 shares in total, I have 10% voting right. That is what it means. Okay. Now, so in case of poll, you will get the voting rights in proportion to the paid up share capital. Now listen, equity shares have a voting right on every matter, but not like preference share capital. Preference shareholders will not have a voting right in general. They can only vote on 3 matters: if there is any resolution which is affecting their rights, if the company is being wound up, or if you're talking about repayment of capital. Then on these 3 matters, because they have a preference of repayment of capital, so they will also get a voting right. They will also get a right to vote on that particular matter. Otherwise, they will not vote. However, if you're not paying them dividend for 2 years or more, then they will come and sit like equity shareholders and say, come on, now I'm going to vote on every matter, right? Because there is something that the company is not doing right, because I'm supposed to receive dividend. Maybe if you have issued 10% preferential capital, I'm supposed to receive dividend 10% every single year. And if I'm not getting that, then there is something which is not right. There are some decisions which are not happening in our favor. So we will be voting on every matter. So then they get a right to vote on every matter. Okay. Fine. Now, shares with differential right. Shares with differential right. Section 43, read with rule 4. Okay. This is not applicable to private company whose articles and memorandum otherwise provide. In fact, they can have different types of shares. That is not a problem. In case of public company, you have these type of capital. Otherwise, for private company, if your articles say something else, you can have something else type of shares also. Fine. Now, you need authorization in articles of association. First thing. Secondly, you need to pass an ordinary resolution. Okay. Yes, for issuing shares of differential voting. Differential voting means what? Usually we don't, we issue like one share is equal to one vote. Now we're going to issue, if you have 10 shares, then you'll have one vote. Why will somebody take a share like that? I would take a share like that if I'm getting a higher rate of dividend, because I'm not interested in the decision making of this particular company, but I'm interested in returns, right? So a lot of people might take it, right? Okay. And somebody who wants to keep the control within themselves, they would want that, okay, we can have a lot of people participate, we can have a lot of people contribute, but at the same time we'll not give them control by not giving them voting rights. Okay, we will give them more of dividend, so they might be interested and they may subscribe for the shares. Okay, so what we have to do is we have to call the general meeting, and for calling general meeting we have to send them notice, right? Notice to our members. Notice will be accompanied with the explanatory statement which will clearly state that what are the total number of shares that you're proposing to issue, right? And all the details, why are you issuing it, find the percentage, because the maximum percentage allowed is 74%, so you also need to mention the percentage. Okay, price at which you are issuing, fine. Then the basis at which you have arrived at the price, right? If there will be any change in control, then you have to mention that, right? Shareholding pattern before the issue of such shares, after the issue of such shares, right? Your EPS. So all this will be specified in the explanatory statement, and thereafter you have to follow certain conditions. What conditions need to be followed, ma'am? There shouldn't be any default. Default regarding what? Default in filing of financial statements and annual returns for last 3 financial years immediately preceding this year, right? Then there shouldn't be any default, like you have declared the dividend but you have not paid it, your deposits have been matured, you have not paid it, your debentures have to be redeemed, the due date has come but you have not redeemed it, right? So if you have any subsisting default of these, then you cannot issue shares with differential rights. Third one, if you have defaulted in dividend on preference shares or repayment of any term loan, like you have taken a bank loan, or maybe you have not made your statutory payments. Statutory payments like what? Maybe you have deducted PF but you have not deposited the PF, right? So in this case, you are disqualified for 5 years. Once you rectify the default, the end of that financial year, from that end of financial year till 5 years, you are disqualified. Thereafter, you are allowed. Okay. The next one is that during the last 3 years, you should not have been doing any offense, or you shouldn't have done any offense under RBI Act, SEBI Act, SCRA, FEMA, or any other special act. Fine. So if this is the situation, then you cannot issue shares with differential rights. Next, your shares with differential rights are not going to exceed 74% of total post-issue paid-up share capital. Earlier it was 26%, now it's 74%. Okay. Thereafter, there will be disclosure in the register, and Board's report also. Explanatory statement I've already told you, right? You will disclose clearly in the board's report that these are the total number of shares that we have allotted with differential rights. What are the rights that they carry? Voting rights, dividend, what is the percentage, what is the price, right? To whom it is issued, that means the promoters, KMP, who it is issued, if there is any change of control, pre and post issue shareholding pattern, diluted EPS. So all of that has to be mentioned. There will be a register that you will be maintaining for the same. Clear? Okay. Now we come to the different types of shares. Or rather, I should say that not the different types of shares, but shares issued at different prices. One is face value or nominal value, the other is market value, right? Don't confuse between the two. Face value, nominal value is decided by the company. Let's say the face value of a particular share is 10 rupee. Now, if the company is issuing the shares at 10 rupee only, that's share issued at par. If it is being issued at 9 rupee, then it is share issued at discount. If it is being issued at 11 rupee, then it is shares issued at premium. Okay. Now, one by one, we'll analyze this. At par, of course, there is no provision. It's very simple. It's all the same. But when we talk about discount, it is something which is not allowed and is void. When we talk about premium, the amount that you collect from premium has to be transferred to a securities premium account. Ideally, the money is not transferred because money will be there in the bank account only. You don't have to create a separate bank account and keep it over there. No, it will be there in company's bank account only. Just that a kind of reserve is created or a kind of account is created, and that securities premium that you have collected has to be applied for a certain uses only, for a certain purposes only. We read that under section 52. So first of all, issue of shares at discount. Can the company issue shares at discount? The answer is no, you cannot issue. Issuing shares at discount is void. However, there are two exceptions. One is sweat equity shares, which we read under section 54. The other is if there is any debt which is converted under a debt restructuring scheme in accordance with RBI regulations, like maybe the company has taken a loan and the company is not able to repay that loan. RBI, under RBI regulations, we formulated a scheme and it says that, okay, this company is supposed to issue the shares of its company to the bank at 5 rupee per share. So at discount, you're doing that. Why? Because it is under a debt restructuring scheme because the company is not able to repay the loan, right? So in that case, it is allowed, and it is also allowed in case of sweat equity shares. Otherwise, it is not allowed. If you go ahead and issue the shares at discount, then you have to refund all the money. There will be penalty, there will be interest, and you have to refund all the money. Okay. Fine. So what is sweat equity shares, ma'am? Sweat equity shares are different from ESOP, and the basic criteria of sweat equity share, or the idea, is to reward for what they have done, right? Reward them for value addition. Okay. So it is given to employees, it is given to directors. And what is it? Basically, we are offering the shares to you at a discount or for consideration other than cash. How do we do that? What is the procedure of issue of the same? First of all, company cannot issue some new type of shares as sweat equity shares. Whatever existing class of shares they have, like they have issued 1000 shares at the rate of 10 each, fully paid up. So you can issue maybe 100 more such type of shares, the same type of shares. So that is what you can do. You cannot issue like, okay, now we are going to issue 100 shares at the rate of 100 each, and these are the rights attached to those shares. No, you cannot create a new class of shares for issuing to your employees or to your directors. Okay. Basically, equity shares issued by a company to directors or employees at a discount for providing value addition or know-how, or making available some IPR, that is intellectual property right, that is known as sweat equity shares. Who can be the employee? The employee has to be a permanent employee. Outside India, in India, doesn't matter. You can be the director of the company, whole time or part time, it doesn't matter. Or you can be an employee or director of a subsidiary or the holding also. Okay, so it doesn't matter. Fine. But you need to pass SR, for the same. So issue is authorized by SR. Now when you want to pass SR, there will be a calling of general meeting along with explanatory statement. So explanatory statement will specify that when the board has approved, because first of all there is board meeting, the board approves that okay, these are the directors to whom we must issue sweat equity shares. Why? To encourage them. They are providing like real good stuff, like maybe in COVID some pharma company, they have developed a formula, so have provided value addition to the company, so we want to reward them with sweat equity shares. That is equity participation, that can happen, right? So under this section you can give them the shares at a discount, right? So the date at which the board approved the same, why are you doing this, to whom are you going to give, what are the total number of shares that you are going to give, what class of shares are you going to give as sweat equity, what are the terms and conditions, right? From how long they have been associated with the company, what is the price of the share, what is the consideration that you are charging, what is diluted EPS. So all of that has to be specified in explanatory statement. Okay, explanatory statement along with the notice is going to be sent to members, and members will pass special resolution. This will be specified in the resolution, and once the resolution is passed, you have to allot the shares within 12 months. You have to allot the shares within 12 months. Now, if you are a listed company, then you are regulated by SEBI regulations. If you are an unlisted company, then you have to follow Rule 8. So whatever detailed explanatory statement also I told you, that is for, of course, the unlisted companies, right? Okay. Now, the lock-in period is going to be of 3 years. Limit is 15% of equity share capital in one financial year and 25% total at any time. For startup companies, of course, because it is a startup company, there will be a lot of value additions which are being made. So the allowed limit is enhanced and it's 50% for 10 years, right? Okay. Register, you have to maintain in SH3, and if there is any non-cash consideration, then the treatment has to be according to AS, that is accounting standards. Fine? Okay. Now we come to issue of shares at premium. There is no condition, no restriction, no limit for such issue, no express power in articles. The only thing is that if you are issuing shares through private placement at a premium, then you will transfer that premium collected to securities premium account. If it is a public offer, you also have to follow SEBI guidelines, right? Now, this account is not a free reserve and has specific uses only. Uses or application or securities premium account can be debited only against these things. Fine? Only against these things. If it is used in this specific manner, great. If it is not used, it will be treated as reduction of capital, which we read separately. And what are the uses? It's B for bear, right? So we have bonus shares, we have buyback, we have expenses, commission, discount on shares of debentures, we have expenses which are preliminary, writing off, and we have redemption premium. So all these are the allowed application for securities premium account. Okay. For prescribed companies, that means which are required to prepare their financial statement in accordance with the section 133, then they have only 3 limited uses, more strict thing. Fine. Okay. Now, whenever a company wants to issue shares, the company issues shares for the very first time when it is being incorporated. So there are the subscribers, and the subscribers want to purchase the shares of the subscribers have committed to purchase the shares of the company, so they pay the amount and the shares are issued to them. That is the first time that the company is issuing shares. Now, any second or subsequent issue of shares, right, involves section 62. So all the companies which have share capital, and whenever you want to issue further shares, you will first offer the shares to your existing shareholders and that is called as rights issue. Supposedly you don't want to do that, then you pass SR and you may issue to your employees, or you pass SR and you may issue to any other person including a public offer by complying with chapter 3 Part 1 or part 2, whatever is applicable. Part 1 is public offer and part 2 is private placement that we have read, section 42, right? Or you may be allowed to issue shares against conversion of loan or debentures pursuant to section 62(3) without passing SR. Okay, fine. Now, rights issue. What is rights issue? So, company wants to raise funds by issue of further share capital. What they have to do is they have to give a notice. Basically, you have to give a letter of offer to your existing shareholders. Now, you cannot do like this, that okay, I am going to give offer to only these 3 shareholders and not to others. No, you cannot do that. If you're making a rights issue, you have to give an offer in proportion to your existing paid up share capital to all your shareholders, right? You can do this at par or you can do this at premium. You cannot issue right shares at discount. Shares issue just because they are your members, so you're going to offer them at discount. No, this is not going to happen. Okay, this is something which is not allowed. Fine. Okay, now your shareholders may accept it, may reject it, or may renounce it. Ma'am, what do you mean by renunciation? Renunciation is the right to transfer this right. What do you mean by that, ma'am? See, under rights issue, if I am an existing shareholder, I am getting a right. Right of what? Right to purchase company's share. If I want to avail this right, I will accept the offer, make the payment. If I don't want to, avail this right, I can transfer this right to somebody else. Now, the notice that you have sent to your existing shareholders, that is the offer that you have made, the letter of offer, which is in the form of a notice, that is going to contain that these are the number of shares that have been offered to you, first of all, and there will be a time period, right? Time period will be minimum 15 days and maximum 30 days within which you can accept or you can decline. Okay, if you do not accept, it will be deemed to have been declined. Fine. If you do not accept, it will be deemed to have been declined. Now, if the offer is declined, or maybe you have clearly rejected and communicated, can these shares be offered to someone else? The answer is yes, of course. If the company is in need of 10 lakh rupees and there are many shareholders who do not want to purchase the shares of the company, again, they have been given offer, but they declined. So the remaining shares which have not been sold, of course, the company is going to take an effort and company is going to dispose of those shares in the manner they think fine. They may not issue, they may issue to somebody else, but it should not be disadvantageous to the shareholders or the company, right? So the board of directors have the power to dispose of the shares which are left. Fine. Okay. The notice that you sent is going to be sent through registered post or speed post or through electronic mode. Right, with any mode that has delivery, right? At least 3 days before opening of the issue. Okay. I hope so far the things are clear. Fine. Next, we move to ESOP, Employee Stock Option Plan, which is read with Rule 12. Now, if you do not want to issue shares, or there are many cases, it is different from sweat equity, right? This particular employee stock option plan is more of an incentive to retain the employees. So they are like, will give you an option, they grant you an option that if you stay in this company or you work in this company for 2 years, you will get an option to buy company's shares at a certain price, at a predetermined price. Now, if the share price rises up to 5,000 and you have the opportunity to buy the same share price at 2,000, why will you not buy it? But you don't get an option straight away. Why? Because it is like, we are granting you an option that you'll get this option once you complete 2 years. So the option will be vested once you complete 2 years, but you have been given the option. So there's a difference between grant and vest. Now, any company other than basically a listed company, I would say, can go for this. but it has to comply with certain conditions, because for listed we have SEBI regulations, fine. So what conditions you have to comply? First of all, your issue has to be approved by special resolution. Now, as and when I say special resolution, of course, special for passing SR, you need to call your members. When you call your members, you need to send them notice. When you send them notice for any special agenda, it has to be annexed with explanatory statement, right? So what will be the content of explanatory statement? What other stock that we are offering, to which employees are we offering that, right? What is the vesting period? What is the maximum period? Then what is the exercise price at which you can buy it? What is the lock-in period, right? The maximum options which may be granted to an employee, the time, the conditions. If you do not do this, the option that has been vested in you may lapse. And likewise, okay. And one more, a statement that the company has complied with accounting standards, okay. Ma'am, we read about sweat equity shares, that it can be offered to a certain category of employees, right? Who are the employees covered over there? Are there specifically employees covered over here also? The answer is yes. Under ESOP, who is an employee, permanent employee in India, outside India, director of the company whole time, or not, but it's not going to be independent director, and an employee of subsidiary and holding, okay. But we have to be very specific that any employee who is belonging to the promoter group, because many times we have seen in the movies and all also, what happens that if there is a person who has opened a company, so all his family members are ideally a part of promoter group, but they want their children to learn from the very basics, and hence they employ them in their own company, right? So if you're a part of that promoter group, you'll not be getting a SOP. Or if there is any director who is holding more than 10% of the shares, directly, indirectly, through your relative, then you're also not covered as an employee. Okay, fine. Now, a company, you can decide the freedom price. It is up to you to decide. You definitely have to pass SR. There has to be minimum 1 year gap between granting and vesting. Supposedly today I've granted you the option, then I should say that at least you have to work for the company for 1 year, and then this option shall vest in you, right? So minimum gap has to be there. Lock-in period again can be determined by the company as they may deem fit, okay. Now, there has to be disclosure in the board's report that what options they have granted, how many options have vested, how many options people have exercised. See, there are three things. One, I got grant of option, that I have for wait time period. Okay, maybe 1 year, 2 year, minimum 1 year. Then the option vest. Now I will analyze, should I buy it, should I not buy it? If I exercise, that is the option exercised out of the vested option. Some may not exercise, maybe the share prices have fallen down, so I'm already getting your company's share at a lower price than what I have been told, right? So some of them may exercise, some of them may not exercise, right? There are many options which lapse if you do not exercise in a certain period. What is the exercise price, right? How much money have you realized? Okay, the employee wise details, that okay, these are these ESOP we have given to KMP, these are the ESOP we have given to any employee who has 5 or more percent of options. So likewise, we have the classification. You have to maintain a register in SH6, okay, and that's it, I think. Moreover, I have told you all the conditions. Then we come to the next part, which is conversion of loan or debt into equity. See, if a company has to issue equity shares upon conversion of debt, that means what? Supposedly, the company has issued convertible debentures, right? Or and convertible debentures means what? After 10 years, you'll get an option to convert them into equity, right? When the company issued these debentures, SR was passed. That means you got the approval from all the members that we are issuing convertible debentures. That is, after 1 year, after 10 years, they might be converted into equity. So you need to ask them again. The answer is no, you already asked them before, right? So you can convert and issue if the terms of issue were approved by SR. Terms of issue were approved. So at the time of issue, you approved. So at the time of conversion, you don't need any SR. Second is maybe there were no terms of issue which talk about conversion, but we are talking about a government company. So government has a stake in it, and government considers in public interest that it should get its debt converted into equity. Now, the terms of issue weren't saying that, but still it is government, and government thinks that in public interest we must do that. So they will instruct, they will direct that you have to convert this debt into equity. Now, the company may agree, the company may not agree. If the company agrees, great. If the company disagree, they have an opportunity to appeal within 60 days to tribunal, and tribunal is going to pass the orders accordingly. Right? Tribunal is going to pass the orders accordingly. Fine. Then we have bonus shares. Bonus shares are covered under section 63. What are bonus shares? The shares which are issued to our existing shareholders without taking any money from them. Right? So it is basically capitalization of profits and does not involve any outlay of cash. Right? So we have profits which could be applied for a lot of places, but we have issued more shares against, because we want more shares to be floated, maybe, right? So the company can do that, but the company has to do that proportionately to your existing shareholders. It cannot happen that, okay, to this particular person you are issuing 5 bonus shares and to this you are giving only 1. No, you cannot do that, right? So it has to be done proportionately. Maybe it is like for every 5 shares held, you'll be getting 1 bonus share. So something like that can happen. Okay. Now, if you're a listed company, you'll be following SEBI guidelines, but otherwise, this you'll follow along with the rules. Now, there are certain conditions of issue of bonus shares, and there are certain sources of bonus issue, right? So, first of all, let's talk about the conditions. What are the conditions? Condition number 1, you need authorization in articles of association. You need authorization in articles of association, and then you can issue bonus shares. Secondly, supposedly you have issued partly paid shares. Okay, that means you are supposed to take something from the members and you have immense and huge profits and you want to give away these profits as free of cost shares. You cannot. You have to make those partly paid shares first fully paid. Maybe you don't want to call money, use your profits and make them fully paid shares, and thereafter you issue them bonus shares if you want to. Okay, or make a call and make them fully paid shares, and thereafter you can go ahead and issue bonus shares. Okay. Then it has to be authorized in general meeting. That means first is authorization in article, second is fully paid shares, third is ordinary resolution. So you have to pass ordinary resolution. Fourth is there shouldn't be any default. Default of what? Default of any debt, deposits or debt securities, the principal as well as the repayment. Then there shouldn't be any default of statutory dues of employees. Okay, like maybe you have to pay them bonus, maybe you have deducted their PF, but you haven't deposited that, right? And other conditions as prescribed. You can pay bonus to your members out of free reserve, securities premium, and CRR, capital redemption reserve. Okay. So these are the 3 sources from which are used to capitalize, which are actually debited for making payment of or for issuing bonus shares. Once the bonus shares are announced, they cannot be withdrawn. Clear? And you cannot issue bonus in lieu of dividend. Next, we come to section 55, which talks about issue of preference shares. Issue of preference shares. Again, you need authorization in articles, and there shouldn't be any default in redemption of any existing preference shares or payment of dividend. How do you do that? Authorization, SR, then you have to follow the time limit. What is the time limit? You cannot issue, any company cannot issue irredeemable preference shares. That means they have to be redeemed within a certain tenure, right? And that tenure, maximum tenure, is also specified. Okay, this particular section is read with rule 9, right? So first of all, SR should be passed. Secondly, there shouldn't be any subsisting default, right? And when you're passing SR, of course, you're sending the notice, and along with the notice, you're giving the explanatory statement. So you'll clearly specify that what is the size of preference issue, what is the type of preference share that are we issuing: cumulative, non-cumulative, participating, non-participating, convertible, non-convertible, redeemable, irredeemable. You will not mention. Why? Because issue of irredeemable preference shares is not allowed, right? Price at which we are issuing, how have we arrived at the price, that is the basis, what are the terms and conditions of issue, what are the terms and conditions of redemption, how you will be redeeming, what is the current shareholding pattern, what is the expected EPS after conversion. Okay, so all that has to be specified. Fine. So if you are authorized by your articles and you pass SR, you can issue preference shares, but the time limit should not exceed 20 years from the date of issue. That means within 20 years, you have to specify any tenure, and you have to redeem the shares according to that. Okay, you may also issue convertible preference shares. But there are certain infrastructure project companies which are engaged in infrastructure projects. For them, the maximum period is 30 years. However, from 21st year, you must start part redemption. That is, every year, minimum 10% must be redeemed. Okay, on proportionate basis. It should not happen that, okay, to this particular person I am giving, and it's as good as 10% of the preferential capital, and I'm not giving anything to anyone else. No, this is not going to happen. So on proportionate basis are the option of preference shareholders. Fine. Okay, now we talk about redemption. The shares are issued, how the shares are going to be redeemed. Now once you have issued the preference shares, that is fine. For redemption, you don't need any authorization in articles. However, you still need SR. Okay, you can redeem only when they're fully paid up. So you have to make them fully paid up. How can you redeem it? Out of your free reserves or out of fresh issue. Okay, fresh issue of securities, out of free reserves or out of fresh issue. Now here is a catch, and I have very beautifully explained you in the class that why CRR is made, right? So if you are issuing if you're redeeming preference share out of profits, then you have to transfer nominal amount of the same, not the premium part but the face value part, as to CRR. CRR can be used for issuing bonus shares to the members. Okay, fine. Now, supposedly the company is not able to redeem preference share capital. What will you do that in that situation where a company is not in a position, it cannot redeem preference shares or pay its dividend? Then you have to take consent of your shareholders 3/4 in value, and if they agree, then you will apply to NCLT, and if NCLT approves, then what you can do is, against their old shares, you will issue them new shares, and old shares will be deemed to be redeemed. Okay, will be deemed to be redeemed. However, if there are some shareholders who dissent, who do not give their consent, then NCLT can order them to make immediate payment to those dissenting shareholders, right? Okay. Then we come to the alteration of share capital. If you want to increase your authorized capital, or maybe you want to consolidate and divide into larger amount or subdivide into a smaller amount. For example, if you have the classification or the bifurcation as 1 lakh shares at the rate of 10 each, you may make it to 10,000 shares at the rate of 100 each, right? Or vice versa, right? Then you can convert your shares into stock and back stock into shares, or you may cancel the shares which have not been taken, right? So you have the authorized capital of maybe 10 lakh, and there are issued or subscribed capital maybe only 8 lakhs. So you have 2 lakh extra, you can cancel those shares. That is not going to be treated as reduction, that is diminution. Okay, how do you do that? You need authorization in articles. You call general meeting, pass ordinary resolution, alter the share capital within 30 days. You have to give a notice. This is actually given in section 64. Within 30 days, you have to file a notice, SH7 plus copy of memorandum with ROC, and ROC is going to record the changes. Okay. Now, reduction of capital is different. Reduction of share capital is when the paid up capital gets affected or the liability gets affected. Okay. And what is buyback? Buyback is where the number of shares gets reduced. In this case, the number of shares don't get reduced. Fine. So, what are the cases? Basically, when you extinguish or reduce liability for shares not paid up. Let's say the company has issued a share of rupees 10 and the amount is 8 paid up. Okay. Now the company wants to reduce the share capital and they say that I am going to make these shares 8 paid up and the face value from 10 we are going to reduce it to 8. So when you reduce it to 8, it means shares of rupees 8 fully paid up. That means you are reducing the liability. You are actually not reducing, you are extinguishing the liability of that class of members. Like they don't have to pay that balance 2 rupee and they'll never be called to pay that balance 2 rupee. So this is reduction of capital, and the creditors might object. The creditors might say that if the company runs into financial difficulties, they're liable to contribute this much, and you're just waiving off their liability just like that. How can you do that? What if the company suffers? We will not let our money be lost or etc etc. So the procedure is not very simple. The procedure involves the approval of NCLT, and NCLT makes sure that everyone is satisfied. Okay. So this is case 1. Then cancel lost paid up share capital. Maybe the paid up share capital is written as 10 lakh. However, the corresponding assets are only worth rupees 8 lakh. There is 2 lakh accumulated losses. So cancelling this and making this 8 lakh, or paying off excess paid up share capital. The share capital is 10 lakh and in bank account they have kept 5 lakh. That means maybe only 5 lakh has been put to optimum use. Safe side keeping 2 lakhs in bank, 3 lakh is still a waste and we are not able to generate return. So we are paying off the excess paid up share capital. So all these cases, there is a procedure of reduction. What is the procedure? You need authorization in articles. You will pass SR. And there shouldn't be any default in repayment of deposits. You will make an application to tribunal with the prescribed documents, and within 15 days the tribunal sends the notice to central government and ROC, SEBI in case it is a listed company, creditors, and an advertisement is also published, right? They have to raise objections. So whatever objections they raise, they send it to tribunal. In tribunal, you have to provide it to the company. The company within 7 days submits its response that, okay, what we have to say about the objection which is raised. If within 3 months there is no objection which is raised, it is presumed that they do not have any objection. After hearing the objection and the response and looking at the interest of the shareholders, if tribunal is satisfied that, okay, fine, the debt will be discharged, they pass an order confirming the reduction. This order has to be filed with ROC and ROC shall register and issue RSC that yes, the capital stands reduced. Okay. This order is going to state the amount of share capital, number of shares, amount of each share and amount paid up clearly, specifically. Fine. Okay. Now we come to the topic of buyback of shares. Buyback is actually spread over four sections, section 67, 68, 69 and 70. You have to pay most important attention to section 68 and also some part to section 70, right? But other two sections are not so important for you. However, section 67 says that prohibition or financial statement for buyback. This is applicable basically on a public company. So public company, you are not going to assist, you're not going to give loan directly or indirectly to buy the shares of your own company or of your holding company. Okay. There are 3 exceptions. However, exception number 1, if you're a banking company and you're lending loans in the course of ordinary business, you can do that. You don't know what is the ultimate purpose of use of that money, right? They may buy the shares of your own company. Well, they can. You cannot stop them. Okay. Secondly, if there is a scheme which has been passed by the company by way of SR, okay, so they have ideally like maybe created a trust which is holding the shares of this company only, for which you have provided them the money, but they're holding the shares for the benefit of employees. So under a scheme they are doing that, and that is allowed. The third one, if you are giving loan to your employees who are not KMP, the loan amount does not exceed 6 months of their salary, and you're giving them loan for buying fully paid up shares, so again it is allowed. Okay, now the buyback is not allowed if you do not comply with these 4 sections, or if there is default in repayment of deposits, interest, debentures, preferentials, dividend, term loan interest due to any financial institutions. Okay, now, in these cases, if you have ever defaulted and you rectify the default and 3 years have elapsed, then you can go ahead and go for buyback. Okay. Now, section 68, that is the main section, buyback of securities. See, section 67, I told you only one part because I wanted to tell this together. Section 67 basically prohibits that you cannot buy back your own shares, or you can or neither you can provide financial assistance to somebody else. That means you are not allowed to directly buy your own shares or indirectly buy your own shares. However, if you buy your own shares or specified securities and thereafter you cancel it and follow all the conditions which are stated in section 68, you can do so. What are the conditions? Condition number 1, you have to have authorization in the articles. Secondly, there is going to be a special resolution which needs to be passed. Special resolution is not required if the buyback is 10% or less than 10% of equity plus reserves. Paid up equity capital and reserves. I shouldn't say actually paid up equity capital because there is more detailing to this particular thing. But then okay, let me brief this. Fine. So first of all, there is a limit. We have to check the limit of buyback, and accordingly we can decide that whether it can be done or it cannot be done. If the buyback is more than 25% of paid up capital and free reserves, you cannot do buyback, right? So that is something which is not allowed. However, if it is up to 10%, right? If it is up to 10%, that is 10% or less than that, board resolution shall be sufficient. And if it is more than 10% but up to 25%, then you need SR. Okay, now there are 2 types of securities that we might be buying, right? One is equity shares and one is other specified securities. So when we are talking specifically about equity shares, for every other place, we have seen paid up equity capital plus free reserves, paid up equity capital plus free reserves. But when we are buying our equity shares, then what we see is less than or equal to 25% of paid up equity capital. So the limit of 25% in respect of shares is going to be checked with respect to its total paid up equity capital, and not paid up capital, equity capital plus free reserves. No. Okay. Not paid up capital and free reserves, but paid up equity capital. That is it. Fine. Okay. Now, how do we do that? We can buy back our own shares from 3 sources. One is we have ample of free reserves, because this is like it involves outlay of cash. We are buying back our own shares or securities. So somebody is holding that shares, we give them, offer them a price, and if they accept, they give their shares to us, right? We cancel those shares and we tear off the share certificates. We physically destroy the share certificates and we're making them the payment, right? Whatever price is decided, right? So can we do that? The answer is yes, we can do that. If there are a lot of shares floating in the market, there may be a situation that company would think, okay, I need to stabilize the share prices, right? So let's withdraw some of the shares. There are X's in float, right? So there are situations where it happens. out of free reserves, or maybe out of securities premium, you can capitalize that also, or proceeds of issue of any shares or securities, but they shouldn't be of the same kind. If you're again going to same float the same kind of shares, what is the purpose of buying back, right? So you can issue new shares. You can, maybe you are buying equity shares and you think that preference shares, let's issue preference shares, raise money and buy back equity shares. You can do that, not a problem. Fine. Okay. So first of all, you will call the general meeting, and for calling general meeting, you will be sending the notice along with explanatory statement. Explanatory statement in general will contain all the details. Why are you buying back, the class of shares, the amount that you are going to invest, that is the amount that is collected, where are you going to invest it, the time limit for completion of buyback. However, there is rule 17 which provides specifically for unlisted companies. Okay, so that is what the date of board meeting on which you got the approval, why are you buying back, the class of shares, the number of securities, how are you going to buy back, the price, how did you arrive at this particular price, the maximum amount, the sources of funds, from where are you going to buy back, the time limit. Okay, and if there is any default about that, and a confirmation by the board of directors that yes, they have made a full inquiry and the company is not going to be rendered insolvent within 1 year. So all of that has to be there. Okay, you cannot buy back partly paid shares, they have to be fully paid up only. How do you buy it? Through a letter of offer. That letter of offer is going to be in form SH8. Okay, right? And it's going to be dated, it's going to be signed on behalf of board of directors, and it is going to be sent to the members through wherever you are buying, right? And before it is before it is sent or given to the shareholders, it has to be sent to ROC. Okay, so it is going to be dispatched immediately after filing this with ROC, and within 20 days. That means first you submit this letter of offer to ROC, within 20 days you send it to the shareholders, whoever you're making the offer, right? Okay, they may agree, they may disagree, right? If they agree, you will go ahead, buy within 7 days, you physically destroy the share certificates, and then next buyback you cannot make within 1 year, and no new issue of the same kind of security within 6 months. So these are the two proper specific conditions with respect to the time limit. And you also file a declaration of solvency with ROC in form SH9 that we are not going to be rendered insolvent, right? Apart from that, you have to find the return of buyback within 30 days. You have to maintain the register. Okay, there is one more condition. What is that condition? The condition is that the ratio after buyback of your aggregate debts to the paid up capital plus free reserves is not going to exceed 2:1. Okay, is not going to exceed 2:1. And the time limit for completion of buyback is going to be 1 year. That is actually 12 months from the passing of special resolution or board resolution, whatever the case be, right? Okay. Now we come to the transfer of securities, how the securities may be transferred. Of course, we are talking about the cases where securities are held physically, which is not much relevant and prevalent in today's time because most of the securities are in demat form. However, transferor and transferee, you have to execute a transfer deed, which is in form SH4. It's going to be dated, signed, and stamped, and within 60 days of execution, you will send it with your share certificate to the company. The company shall check. If it is partly paid shares, they will give a notice to the transferee in SH5, and if they do not receive for obtaining NOC within 2 weeks, And if the shares are fully paid up, no problem at all. They will go ahead, register the transfer. Within 1 month, they'll come send the new share certificate to the transferee. Okay, supposedly your deed is lost or is not delivered to the company, then you have to furnish the indemnity bond, and thereafter the company shall register your transfer. Let's say the company refuses to register the transfer. There could be two situations. One, after refusal, they're also sending an intimation or notice of refusal. The second is they're not sending any notice of refusal. Fine. So if they send a notice, there are two types of companies. We have a private company and public company. Both the provisions are same except for a small time limit like this. Okay, so let's say the example of private company. So we have a share, I have shares in the private company, and I have sent a transfer deed to the private company, but the private company has not registered the transfer. They have not sent the new share certificate, and they have not even sent any notice to us. So we will wait. When we delivered the deed, okay, from that date till 60 days is the time limit that we have to make an appeal to NCLT that they are not doing anything. Please instruct them to register the transfer. They have not even given us any intimation of rejection, that why they have rejected or why they're not doing anything like that. However, if they sent the notice, then when they sent the notice within 30 days, the transferee can appeal to tribunal, and tribunal is going to hear the parties and pass the orders as it complies fit, and the company has to follow the orders. Okay, exactly replica provision even in case of public company. However, if the notice is not sent within 90 days, you can make an appeal, and if the notice is sent, then within 60 days from the date of notice, you can send an appeal. Okay, what is transmission of security? Transmission of security is what operates by law. Like maybe Mr. X had shares in a company and Mr. X died, so his shares will automatically be transferred in the name of his legal representative. For this, you do not need a transfer deed, right? You just inform the company that this has happened and the shares will now be in the name of Mr. X's son, right? Let's say he doesn't want to get the shares in his own name, rather he wants to straight away transfer the shares and sell the shares to somebody else. So he has the right, he is entitled, and he'll be treated as if he is the registered member. Okay, and you can do that. Fine. Okay. Um, Thereafter, we have a section called as rectification of register. What is rectification of register? Again, if we follow the same league, there are instances and cases where we have sent the transfer deed, but unnecessary delay in writing the transferee's name in the register. Still, my name is only being evident or being visible. So why is there unnecessary delay in entering my name? Or maybe I've already transferred the shares to somebody else. Why are they not removing my name? So there is unnecessary delay in removing the name or entering the name, or maybe they have omitted my name unnecessarily, or maybe I'm not even the member or the shareholder of that company, but they have written my name. How come they have written my name? So if there is any entry without cause, or maybe any omission without cause, or unnecessary delay in entering or removing, so in that situation, there could be any person who's aggrieved. He may or may not be the member of the company, because I'm not the member of the company, but still my name is there in the register. So it is like person aggrieved, they may appeal for rectification with tribunal, and tribunal will hear the parties and will order the rectification and can also order the damages. Okay. Company, depository participants, SEBI or the holder, they may also apply for rectification. Then comes your topic of debentures. What are debentures? Debentures are debt or any instrument which evidences debt. It includes stock, it includes bonds and everything, right? Company can issue convertible debentures. It can issue secured debentures by complying with Rule 18. It cannot issue unsecured debentures. If you are issuing unsecured debentures, basically you are not governed under this particular section, Section 71. How can you issue secured debentures? First of all, you have to pass SR. Secondly, you cannot issue any debentures which has voting rights. Fine, you can issue convertible debentures. That is not at all a problem. Your date of redemption should not exceed 10 years. However, if it is an infrastructure company, it could be maximum 30 years. Okay. You are issuing secured debentures, of course you'll be creating a charge on some asset of the company, and that charge or the security has to be adequate. If you are issuing debentures worth rupees 10 lakh plus interest on that will amount to 2 lakhs, right? So 12 lakh, and you're providing security only of 3 lakhs, then that is unsecured only. Partial security is not complete security. Fine. You have to appoint a debenture trustee, before you issue the prospectus or offer. See, debentures, just like shares, can be issued by two ways: private placement or public offer, right? Public offer cannot be made by a private company. Fine. So public offer or private placement. Now, when you're making a public offer, there will be issue of prospectus. When you're making a private placement, there will be a letter of offer, right? Before both these cases, you have to appoint a debenture trustee. Debenture trustee is basically allowed, is basically important and relevant if it is a listed company, if the issue is more than to 500 members, right? And according to SEBI, if we talk, then debenture trustee is not required if the period is less than of 18 months, is 18 months or less. Okay. So you have to create DRR at a prescribed percentage, and likewise goes the provision for DRI, right? 15%. Before the issue of prospectus or letter of offer, you have to, this I have already told you, appoint debenture trustee to perform the duties and incur liabilities as prescribed. The company shall pay interest and redeem debentures according to the terms. If they fail to do so, the debenture holder or the debenture trustee can make an application to tribunal, and tribunal, after hearing, shall order forthwith payment. Now we have certain provisions with respect to debenture trustee. To appoint somebody as a debenture trustee, you need to obtain his consent, and his name will clearly be written in the letter of offer and prospectus and a statement that he has given the consent. He will be disqualified if he holds the shares, if he is the promoter, director, KMP, or officer or employee of company, associate, subsidiary, and holding. If he is entitled to any money apart from remuneration, let's say he is a creditor and he has to take 5,000 from the company, doesn't matter, you're disqualified, you cannot be appointed as a debenture trustee. If you are he is indebted to the company, holding, subsidiary, associate, or subsidiary of holding, that means you have to pay to companies, holding company, an amount of 10,000, you're disqualified. If you have given the guarantee of debt, you are disqualified. If you have had pecuniary relationship in the past 3 years, what is pecuniary relationship? This is how you calculate. Or you are a relative of promoter, employee, director, or KMP. This I've explained in the class, so I don't think I need to explain you again. And if you are guilty of breach of trust or you fail to exercise due care, then you will be liable for damages. It is your duty to protect interest and redress grievances of the debenture holders, convene meeting. You can be removed before your term if 3/4 value holders give their consent. Okay. Now some small point. First, okay, when we're talking about the debenture trustee, let's talk about the debenture trustee only. There are more duties. What are the more duties of debenture trustee? Where is it? Right. What are more duties of debenture trustee? You have to call for reports from the company, performance reports, and you have to keep an eye on them, right? You have to satisfy that what letter of offer contains the same conditions which are stated in the terms of issue of debentures. That means the terms of issue say the same thing which is being communicated to you, right? You have to satisfy that there shouldn't be any condition which is harmful for the debenture holders. You will communicate all the defaults of the company to the debenture holders. Okay, you will ensure that the company is not committing any breach. If you have to ensure at all times that the security that the company is provided is sufficient. Okay, you will call the meeting, you will perform all the acts which are necessary to protect the interest of debenture holders. Fine. If the debenture holders submit a requisition in writing by at least 1/10 of value, then you have to call their meeting. Okay, so I hope so far the things are clear. Okay.
Let's now revise the chapter of deposits, that is acceptance of deposits by companies. What do we mean by deposits? Deposits is basically receipt of money by the company by way of deposit or loan or whatever name you may give, whatever form you may call it, right? So that means every time a company is receiving some money, it is deposit. However, it does not include certain category of money which are prescribed in consultation with RBI. What are that? For one simple reason, you have to understand that if a company goes out and take a loan from bank, is it going to be treated as deposit? The answer is no. Why are we making the provisions of deposit? Because there are certain category of receipt of amount of money by the company which are unregulated, which are not regulated. Because if a company is receiving money and issuing you shares, you have the provisions of share capital, right? How it has to be done. If it is not allotted, it has to be refunded, everything, right? So everyone is secure. The people whose interest is being involved, their interest is safeguarded against these provisions, right? They have remedies, they have everything, right? When we are taking loan from bank, well, there's an agreement, but there are certain receipt of money just like deposits, right? You're taking, the company is taking money, there is no provisions which are going to regulate this receipt. So this could be disadvantageous, and that is why this chapter is there. Now, first of all, we have to understand that what do we mean by deposit. Deposit is defined in section 2 clause 31, which simply means any receipt of money. You may call it in the name of deposit, you may call it in the name of loan, or you may call it in any other form, but it's not going to include those categories which are uh, prescribed in consultation with RBI. What are those categories? If you receive an amount from government, okay, just a second. If you receive an amount from government, if you receive an amount from any foreign source, whether it's foreign citizen, foreign body corporates, foreign bank, foreign government, because they are again governed by the provisions of FEMA. Okay, if you receive a bank loan or any loan or financial assistance from PFIs. Okay. Thereafter, if you receive, if one company is receiving amount from another company, that is intercompany transfer, right? That is also not deposit. If you are receiving any amount on commercial paper, that is not deposit. If you are receiving application money, let's say the company issues shares to its members or issues shares to general public, whatever the case be, it receives the application money against which it has to allot the shares. Sometimes shares are allotted, sometimes shares are not allotted, sometimes shares are allotted to everyone, sometimes shares are allotted pro rata, right? So whatever it is, if the shares are not allotted within 60 days in case of private placement, it has to be refunded within next 15 days, right? If you refund it, great. If you don't refund it, then it will be treated as deposits. Otherwise, the share application money which the company is receiving will not be treated as deposits. Okay, the amount which a company receives from its own director, they're not deposits, provided they give a declaration that it is not their borrowed funds. Amount that you receive from the relative of director of private company, that is also not deposits. Okay, then amount that you receive by issuing debentures, amounts that you receive from your employees when you hire an employee and you ask that particular employee to deposit a certain amount of security, which is security deposit, and it's non-interest bearing. That means the company is not paying any interest on the security deposit which they have taken, right? Then that amount is also not considered as deposit. If the company is holding any amount in trust, that means it does not belong to the company, it belongs to somebody else. Company is just holding it in faith. That is not deposit. There are a lot of trade advances that a company receives. That is the amount that you're receiving in your ordinary course of business. If you're going out to buy a particular product, or if somebody is coming or somebody has placed an order, you'll be like, okay, I will get the order ready, but give us some advance. So you get that advance, right? Advance for providing secure services, or advance for providing goods, or maybe you have a land and somebody comes up and they finalize the deal. So what you get is a token amount, a booking amount, and you enter into an sale agreement, right? Agreement to sell, that I am ready to sell, he is ready to buy. That is what you enter into an agreement to, right? So this is what this advance that you have received for selling your immovable property. Is it deposits? The answer is no. It is not deposits. Why we are not identifying it as deposits? Because if we identify that category of receipt of money as deposit, then it will be governed by the provisions of deposits. So these are not deposits. These are the money that we're receiving for doing the business, right? In the ordinary course of business. Okay. uh, there may be for long term projects, there may be for subscription publication, magazine, etc., etc. All you have to remember is amount received in the ordinary course of business, maybe for an immovable property under an agreement, maybe as some security deposit, maybe for some long term projects for supply of capital goods, right? Thereafter, amount that is brought in by the promoters. What is brought in by the promoters? Who are the promoters of the company? Who have actually founded the company, who are actually responsible for arranging finance and everything for the company, right? Now, a company goes to a bank and asks for loan. The bank says that, okay, I will give you loan provided the promoters also contribute an amount of 1 lakh each. So that if promoters will have their own stake invested, they will be little worried, they will take care of the company in better ways, right? So the bank gives you a loan on a condition that promoters are also bringing in some money. So the money that is brought by the promoters is not considered as deposits. And anyway, the loan which is given by bank is definitely not deposits, right? Because bank loan is also exempted, is also there in this category. That means it is not deposit. Okay. So amount that is received by the from the promoters or by the promoters is not deposits. Amount which a nidhi company receives, or chit fund, or CIS, or AIF, DVCF, whatever it is, because all these funds, if I'm talking about mutual funds, or if I'm talking about chit fund, or if I'm talking about any CIS scheme or nidhi company, what is the purpose of nidhi company? It has its own members and it promotes the saving of, it promotes the habit of savings. So everyone, if there is some money with them, they'll come and deposit it. So what is nidhi company doing? Taking a lot of money, not issuing shares, but taking a lot of money. That is what is the purpose of this company. So every time it takes money, are these deposits? No, no, these are not deposits. Likewise, we have chit fund, we have CIS, we have these type of funds. And then we also have a startup company, because you are it is very obvious that you'll be needing a lot of funds. So if you are receiving money and you're giving them convertible notes against it, then that is not going to be treated as deposits, provided the amount should be at least of 25 lakhs. Fine. Okay. Now, a company is receiving money. Who can receive money or who can accept deposits? A private company can also accept deposits, as well as a public company can also accept deposits. Fine. Can deposit be accepted? The answer is yes. By a private company from its members only, by a public company from members and from public if it is eligible public company, that is, it satisfies the criteria for becoming an eligible company. After complying with Section 73 and Section 76, respectively, along with the provisions and rules. Okay. So who will be the depositor? Depositor will be member and could be a non-member in case an eligible public company is accepting deposits from public. So you can go out to your own members and say that, okay, I am in need of funds. This is a company, it's your own company, and I am the company is in need of funds, and our funds are blocked at some places. So we need some funds, and we'll return it to you in a span of 6 months. In a span of 6 months, we cannot go to the bank is not going to give us short term loans, and we cannot go ahead and issue debentures or shares. The entire process takes a lot of time. It is a short term fund requirement, and it is the company in which you have invested, you have seen where it is, everything. So you ask your own members, are you ready to give us deposits? We'll be governed by the provisions of deposits. So I'll be paying you interest, everything. Or if I don't pay, you have these rights, etc., etc. So you tell them everything. You accept deposits from them and repay it according to the terms. Can it be done? The answer is yes. Okay. So if you give money to the company by way of deposits, then you are the depositor. That is, you are the member and you are the depositor also now, because you have deposited money with the company, right? Sometimes we can go to general public and ask for deposits from them. Who can go? If you are an eligible public company, then you can go. Okay, then that those non-members will become the depositors. Fine. Okay. Now, if I talk about a banking company, if I talk about NBFC, if I talk about housing finance company, or maybe any other company which is specified by central government in consultation with RBI, all these companies, you are exempted. Okay, you are exempted. You don't have to comply with these provisions. That is but obvious. Your main and core business is acceptance of deposits only. Okay, fine. Now we have section 73, which talks about acceptance of deposits from its members. But even before that, the first thing that it tells us is that a company cannot accept deposits from public. Ma'am, you said an eligible public company can accept deposits from public. Yes. A company cannot accept deposits from public except as provided in this chapter under section 76 basically. So only and only an eligible public company you can go to public and accept deposits by following the conditions stated therein. Otherwise all other companies you can accept deposits from your members. How can you do that? You have to call a general meeting. Okay, pass an ordinary resolution. Thereafter, you have to prepare a circular, file that circular with ROC, and issue that circular to your members. Okay, the circular is basically going to state and show the financial position of the company, the credit rating that you have obtained, the total number of depositors, the details of outstanding deposits, then other details as may be prescribed. It is in Form DPT 1. Okay, it will also have a certificate included, and that is only going to certify that okay, the company has not committed any default in repayment of deposits, and if it has committed a default, it has rectified the default and 5 years from that date have elapsed. Okay, so you have to give the certificate also. You'll file it with ROC. You have to file it with ROC within 30 days prior to the issue. So it shouldn't be too old. Okay. Thereafter, you issue it to the members and provide a charge, create a charge, that is, provide security. And once you accept the deposits, issue the depository receipts within 21 days. And most importantly, you have to deposit something to DRR. The question is, what is DRR? You go to a scheduled bank, open a separate bank account, and that is named as DRR. Now you have to just set aside some amount of money in that account, and that account can be used only for repayment of deposits. What amount you set aside? Minimum 20%. 20% of what, ma'am? Supposedly you're standing over here at the beginning of financial year 25-26, so you foresee that in this coming year how much deposits are going to mature. Supposedly 1 lakh deposits are going to mature and that we have to repay. So 1 lakh, 20% of this 1 lakh, that comes out to be 20,000. So at least 20,000 will be deposited in this DRR on or before 30th April of that year. Right, so every year we will assess, and every year before, on or before 30th April, we have to deposit a sum of 20% in this DRR account, which is going to be used only for repayment. Fine. And thereafter, you have to file the return of deposits in DPT 3. Okay. Clear? If at all, the deposits are accepted by the company, no matter the deposits are accepted by the members or by general public, if they are accepted and if there is failure in repayment, then depositors, you can make an application to NCLT, and NCLT will pass an order and direct the company that immediately you pay their amount. Okay. Now, the next thing that we talk about is the acceptance of deposits from public. So the first thing is, who is an eligible company? Okay, because you need to be an eligible company, then only you can accept deposits from public. To become an eligible company, the first requirement is that you have to be a public company. The second requirement is your net worth should be at least 100 crores or more, or turnover should be at least 500 crores or more. So net worth not less than 100 crores or turnover not less than 500 crores. If any of these criteria is fulfilled, it's fine. So first, public company, any of the limit criteria fulfilled. Third, you obtain or you pass SR. Fourth, you file this SR with ROC. These are the four conditions which need to be fulfilled. SR SR may not be passed if the deposits that you are accepting is within the limit of section 180. Then OR is sufficient and OR is sufficient, right? You don't need SR in that case. So what are the four conditions? You should be a public company. Either your net worth should be 100 crores or more, or your turnover should be 500 crores or more. Thirdly, obtain consent by SR, okay, and file this consent with ROC. If you comply with all these conditions, then you are eligible to accept deposits from public after complying with conditions stated in section 73(2). So the conditions, the same conditions that we have read in section 73 need to be complied here also, plus credit rating. So this is the most important thing over here. Credit rating. What is credit rating? Credit rating is to be obtained by such companies from a recognized rating agency. Okay, the purpose is to inform the public that this is the risk that you're taking, right? This is just to ensure adequate safety, and it is not to be obtained only at the time of making offer of deposits, but every year during the tenure of deposits. Let's say the deposits is going to be repaid after 3 years, so at the time when you're making offer of deposits, you'll obtain the credit rating, which you will specify in the advertisement, in the circular is in the form of advertisement in the circular. Thereafter, every year you will obtain this credit rating, and that is mandatory. Okay, so it is going to be obtained every year till the time of tenure of deposits. So till 3 years you have to obtain that. Fine. So of course there will be secure deposits. You have to provide security within 30 days. The procedure is very simple. You pass resolution. The resolution is going to be passed in general SR if the limit is exceeded. You have to prepare circular. You have to have the certificate. You have to execute the deposit trust deed to appoint the deposit trustee. You have to issue the circulars. It will be in the form of advertisement because we are giving it to general public. You have to provide the security within 30 days, right? DRR and everything is the same. The additional part is credit rating, which I have mentioned here only, and you must know what is credit rating and how it is being obtained. Is this clear? Okay, so now section 74, repayment of deposits. Now supposedly Companies Act 2013 has begun over here, and at this particular point of time there is a company which had accepted deposits before this date, and on this date the deposits are undue. The deposits are due, they are unpaid. That means you have to pay it over here, right? I gave you an example also. I let me just go through that if I have it. No, this is not the one. Yes, let's say something like that. If you can see, if you can recall. Okay, so a company who accept deposits to be repaid after 10 years, in general, everyone should know this rule that according to the rules of deposits, deposits may be accepted in general for a minimum period of 6 months and a maximum period of 36 months. This is the general limit. Above 36 months, in no case it is allowed. 3 to 6 months is allowed for short-term needs, right? So this is the general rule which you all should keep in mind, although you don't have to read the rules in detail in your syllabus. Okay, now if a company, the Companies Act 2013 has commenced over here, that means before that this provision does not exist. So a company had accepted deposits for 10 years. Now this is the situation. So Companies Act 2013 came into picture, and at this particular point of time we have a company which had accepted deposits in the past and they are unpaid, right? So you have to repay it within 3 years. You have to repay it within 3 years, or your repayment date, whichever is earlier. Supposedly these deposits were to be repaid after 5 years only. That means here is the due date of repayment, so you'll pay it here. Supposedly the due date of repayment is after 3 years of commencement of Companies Act, then you have to repay it at the expiry of 3 years from commencement of Companies Act. That is what it means. Okay, now If this is the situation, that means there is deposit which is accepted before the commencement of Companies Act, and it is unpaid on such commencement, then within 3 months you will prepare a statement that what are your deposits accepted, what is unpaid, and what are the arrangements that you have made. So within 3 months you will submit the statement to ROC, and within 3 years you will pay it. If you are unable to pay it, you will seek an application you will make an application to NCLT for seeking extension. Okay. And NCLT will look at your financial conditions and everything, and they might grant you extension. Okay. Fine. Then we have the punishment, which is stated in section 74, and we have a section called as damages for fraud, section 75. That is, if there is any company which is accepting deposits, and it is proved that you have accepted deposits to defraud your depositors, then the officer who was responsible for acceptance of deposits is going to be made liable with an unlimited liability. Okay. Unlimited liability, and you have to repay it accordingly. You have to pay the damages accordingly. Okay. Then the last section that we have is section 76A, which talks only about punishment. So of course we have a punishment given in section 74. We also have a punishment given in section 76A. So you have to read and learn both the penalties. Okay. Hi everyone, let's now revise the chapter of charges. First of all, what do you mean by a charge? Right? Charge is nothing but providing security against any debt. Very simple, right? If we go by the general meaning or the definition which is given in which is stated in section 2 clause 16, we would get to know that okay, if I am a company and I have an asset, I have an absolute interest in this asset, right? If it is sold, it's my interest, right? The company's interest basically. But if I give this as a security to the bank because I'm taking loan, then bank will also have an interest in this asset. So charge or providing security is as good as creation of charge when we talk about company. So charge means an interest created on the assets of the company, right, as a security. Interest or lien. Lien means what? The right to retain. Supposedly we are taking a gold loan maybe, so the bank will get a right to retain that gold till their repayment is done, right? So charge is created by any agreement. Like if I'm taking a loan from bank, then there will be a loan agreement between the two of us, and there will be all the terms and conditions stated, and therein it will be clearly written that this particular asset of the company is being provided as a security. So this document creates a charge. The date on this document is the date of creation of charge. So charge is an interest or lien which is created on the property, assets, or undertaking of the company as a security and includes a mortgage, right? Although mortgage is a term that is used for immovable properties. We have pledge, which is used for movable properties. We also have hypothecation, which is like stock and all that, but that we don't have to get into all those details. Here we have to understand that no matter how we're providing the security, if we're providing the security, if we're creating an interest or lien on the property or on the asset, any of the assets of the company, that is a charge. Charge creation is not dealt with in this particular chapter. What is dealt is the registration of charge. So once you create the charge, it is the duty of the company to register this charge. How do you create this charge? Through the instrument, right? And when do you create this charge? When do you create this charge? Basically, you create this charge on assets which are movable or immovable, tangible or intangible, situated in India or outside India. It doesn't matter. Whenever you are creating a charge, you have to register this charge with ROC. How do you register this charge? For registering this charge, or it is whose duty? Let's say
If the charge is created by the company, it must be registered with ROC by the company. If the company doesn't register, charge holder also has the power under Section 78 to register the charge when within 30 days of creation is the prima facie time limit. However, there is an extended time limit also, right? How in such manner and with such fees as may be prescribed. If you register it, ROC will give you a certificate. This will be deemed notice of charge. There will be other compliances that you have to do, and once you have fully paid the debts, right, or it is satisfied, then you have to report the satisfaction. Okay, if it is not registered, then you will be like an unsecured creditor. Okay, and there will be no priority that will be given to you in payment, right? Because you're not, the charge is not registered, and there is penalty also for non registration. Okay, now Section 80. Before we go on to the main section, Section 77, first we read Section 80. What is Section 80? The question is, if the company has provided plant and machinery as a security to somebody, can this plant and machinery be sold to some other person? The answer is yes. So if this is a property that I want to sell it to some third person, do I need to tell this third person that this is a property which is subjected to charge? Well, humanity grounds, you should tell, but it will be presumed that he knows about the charge if he's acquiring the if he's acquiring the asset. Why it is presumed that he should know about the charge? It is because the charge is registered. So as and when the charge is registered, any person who is acquiring that asset, property, or undertaking, then such person should know about the charge. We will consider it that he knows about the charge, and he, even if he doesn't know, he cannot claim for any loss against the company later on. Okay, so company, if you're creating charge, whether it's situated in India or outside India, you have to register it within 30 days of creation. There is form CHG 9 for debentures and CHG 1 for others, right? So within 30 days, you have to file it with ROC. ROC is going to register the charge and issue us a certificate of registration in CHG2. They give it one copy to company and one copy to the charge holder. Now, Section 79 tells us some more details. What are some more details of Section 79? It tells that two more things need to be registered. What? First, modification also needs to be registered. What is modification? Modification is change or variation in the terms and conditions. Supposedly you have written that the loan will be repaid within a span of 10 years, you extend this span to 15 years. That is modification, because you're changing the terms and conditions of this particular agreement, right? So whenever this particular thing happens, you have to register this change also. Whether you're changing the rate of interest, whether you're changing the repayment schedule, whatever it is all modification. So if modification happens, then within 30 days of modification, that also needs to be registered. And ROC will provide us form CHG3, that is certificate of modification of charge, right? There is one more case which needs to be registered, and that is if this is company has a plant and machinery which is subject to charge, and company sells this plant and machinery to another company. Now that company, you have to now make an application, you have to register this particular thing with ROC. That is, if there is any company which is acquiring any property that is subject to charge, then you have to register that also, because now the property, the asset which is subject to charge belongs to you. So you are now the owner of that particular property, so you have to register that also. Okay, so all these three things need to be registered. Clear? What is the time limit for registration? Basically, this is the relevant time limit now. That is, you have to register the charge within 30 days of creation. If you don't register it within next 30 days with additional fee. If you don't register it within next 60 days with ad valorem fee. Ad valorem fee is a fee on the percentage, like more the amount, more the charges, right? But additional fee is like a fixed amount. Okay, so that is the difference. However, earlier the provisions for charges created before this date was You register it within 30 days. If you don't register, you can register it within 300 days. Okay, if you don't register, then you have to register it within 6 months from the date for additional with additional fees. Okay, you cannot register beyond this point and no further extension shall be granted. Now, because the consequences faced by the charge holder is very harsh, charge holder also has been given an opportunity and power to register the charge. So, if the company does not register the charge within the prescribed period, right, within 30 days, the person in whose favor charge is created, that is the charge holder, he can make an application to ROC, submit the documents needed, provided the instrument which is creating the charge, and get the charge registered. So when ROC receives such application along with the instrument, ROC will be like, company, there is an asset of yours which they are claiming that they have got as a security. There is a charge that you have created on your asset in their favor. It is them who have given the application and they're claiming it. Do you agree? Do you disagree? Should I register the charge? Should I not register the charge? So they are seeking a reply within 40 days. If they get a reply and they get a sufficient cause not to register, they will not register. But if they don't get any reply, or so there is some insufficient cause, or maybe they agree, ROC will go ahead, register that charge, and issue a certificate of registration of charge to both the charge holder as well as the company. Okay. Fine. This is something that I've already told you, right? Okay. Now there is register of charges. What is register of charges? Basically, there are two registers that we read about in this particular chapter. One is the register that is being maintained by ROC. And the second one is the register which is being maintained by company, which is more important, of course. So the register is in form CHG 5. It is kept at the registered office. It includes all the charges, fixed, floating, whatever are the charges on any asset, any property that you have created. And there will be the copy of instrument that will also be attached. And it will be open for inspection. Open for inspection by whom? Anyone can inspect. The members or creditors are allowed to inspect free of cost. Others can inspect by paying the requisite fee. Okay, then we also talk about the preservation, right? So the register of charges has to be preserved permanently, basically the instrument has to be preserved till 8 years from satisfaction. Okay, fine. Now we come to satisfaction of charges. What is satisfaction of charges? Just like we register the charge when the payment is being made, or maybe in place of that particular asset, some other security has been provided. Right? It is satisfaction. The asset has become free. Right? The company discharges the debt, the security becomes free. So within 30 days of payment, you have to intimate in CHG4 to ROC. ROC will send a notice to charge holder, will ask the bank or whoever the lender is your debt paid in full? Should I register the satisfaction? If they don't object, if they show a cause, no, still 4 installments are left, see, this is the proof. So ROC will not register the satisfaction. But if they don't show any cause and they're like, okay, then registrar will issue a register and issue you a certificate of registration of satisfaction of charges. Okay, will issue a certificate of registration of satisfaction of charges in CHG in CHG 5. Okay, fine. Now, sometimes it may so happen that there is no intimation which is being made by the company, although the company can intimate within 30 days, and thereafter, if it forgets to intimate, it can intimate within 300 days. That is ideally the limit which has been given for satisfaction. And even if you forget that, then there is another section which is about rectification, wherein if you omit to inform about satisfaction, you can later on, even after 300 days, you can go to ROC. ROC not, basically you can go to central government. Central government has delegated this power to RD. You can go to central government, and if you tell central government, you show them a sufficient cause, they will register that satisfaction of charge. Okay. Now, but there might be a case that the company was supposed to inform that yes, I have paid the amount in full and this particular asset is now free, the charge has been satisfied, but the company did not inform. ROC from some other source got the evidence that yes, the debt has been paid in full or the property has been released. So ROC enters that in the register of charges, a memorandum of satisfaction, and within 30 days of making entry, they will inform the affected parties. Okay, and also provide a certificate of satisfaction of charge. Okay, is that clear? Fine. Now we also have a section called as section 84. What is it? It's about informing ROC whenever you are appointing a receiver or manager. Basically, who is a receiver or manager? Sometimes it may so happen that the company has taken loan, but the company is not able to repay loan, right? And continuously defaulting in repayment of installments. Maybe the terms of agreement are so that in case you default 3 installments, then we will manage the security. Maybe like we have a building or from which we derive some, the company is getting some rent, so that building has been given as a security, so company is continuously using that building and bank has no objection at all. But when there is a default, the bank may approach the court and say that no, we are afraid that this is a security which or against this building our security interest has been created, right? So we now want some receiver to be appointed who is going to look after, who is going to manage this particular asset, who is going to maybe sell, who is going to ensure that the repayment is being done, right? Because maybe they're not using or managing the asset properly, and that we are afraid that the company may sell away this building or do something like that, right? So maybe the terms of agreement permit, so the bank is appointing, or maybe bank approaches the court and court has passed an order for appointment. So in both the cases, bank, either you appoint or you get an order for appointment, within 30 days of that same, you have to inform company as well as you have to inform ROC. Okay. And within 30 days of that, and the required form, the requisite form is chg 6. And any receiver or manager, if you're appointed and you cease to hold the appointment, that means maybe you resign, you will give a notice to that effect, and to ROC and to the company. Okay, fine. Now comes your section 87, rectification. If if there is any charge which has been registered or any modification which has been registered, and thereafter you get to know that oh my god, I omitted something in this form, or there was a misstatement in this form, then you can make an application to central government in CHG 8. And if CG is satisfied that okay, this misstatement or this omission was not deliberate, it was accidental, and uh, it is not affecting the creditors or the shareholders, then it will order that okay, let this be rectified. So ROC will rectify this. Okay, there is another thing that supposedly you forgot to report satisfaction of charge within the time limit, that is even till 300 days, but you make an application to CG, and if CG is satisfied that you forgot to register report the satisfaction uh, because of some genuine cause, sufficient cause, then it may extend time for satisfaction of registration, for registration of satisfaction. Okay. Or for satisfaction registration, even beyond that particular tenure, right? We also have section 86, which basically talks about the penalty for non-compliance, which you have to learn. And there are a lot of forms that we have read in this particular chapter. Please remember the form numbers for MCQ's perspective. Although from the chapter of charges, there are not many questions which have been asked in the past as far as the full-fledged questions are concerned. Yet I would insist that please revise this well, and moreover focus on the form numbers from this particular chapter, right? Okay.
Management and Administration, Chapter 7, according to Companies Act classification, containing sections starting from section number 88 till section number 122. Okay, so what is it all about? The first section that we talk in this particular chapter is about registers. So every company you are required, every company, doesn't matter you're a private company or a public company or you are any other. Basically, we have only three types of companies which are formed under Companies Act, right? So you have to maintain this register, right? You have to maintain the register, and that register has to be separately maintained for each class of preference shares, each class of equity shares. There has to be a separate register for debenture holders, a separate register for any other security holder that you have, right? So you have to maintain this, and if you do not maintain, there is going to be a penalty. Sometimes the shares are held in demat form, wherein the records of who is the member, who the transfer is being done, etc., etc., all these records are not with the company, but they are with the depository, right? So depository is maintaining all that records, and in the register of members of company there will be just like the depository's name, and they have these many shares. Now bifurcation, who is actually the beneficial owner, and who has the ultimate benefit and who is the ultimate shareholder, all that record is there with the depository. So if depository is maintaining that proper record, it's sufficient compliance under this section that yes, the company is also maintaining a proper register. Okay, how do you have to maintain the register? There are two forms which have been specified. One is MGT1 for shares and MGT2 for other securities, right? What details you need to put in the register? The name of the member, address, email ID, any unique identification number, the date when they became a member, the date of cessation, any other interest which they have, any special instructions which they have given, all those have to be specified. There is one additional requirement of index. What is index? And index is required only if the number of members is 50 or more, right? So just a way we prepare a normal index, in the same manner index has to be prepared. Now there is also a concept of foreign register. What is a foreign register? Supposedly there are certain members or certain debenture holders who are not living in India, but they are residing outside India. Okay. Now, if they are residing outside India, there are many of them who are residing outside India. If the company is authorized by its articles, it can allow that, okay, we are maintaining a register about your details, and since you are living outside India, let your details be maintained over there only, and that will be treated as a part of the principal register which is kept here. So every 15 days you have to remit every 15 days of whatever entry you make. Supposedly you have changed something, so within that after that change, within 15 days you have to remit that entry over here, and here a duplicate register we will be maintaining. So is that permitted? The answer is yes, it is permitted. Now foreign register will be kept at that place only, and you have to inform ROC that okay, we are keeping a foreign register at this particular place. If we talk about the normal registers, they are kept at the registered office. However, they may be kept at any other place provided. The place has to be such wherein at least 1/10 of the members reside. Don't get confused between foreign register and registered members. Since this is a revision class, I'm telling you all of them together, right? But I hope you have learned this well, you have understood this well, and then we are revising, right? So register of members is kept at the registered office. It may be kept at any other place, but for doing that, you have to ensure two things. One is that place is where at least 1/10 of members reside, and you need to pass SR. Okay, so if you do that, you can keep the register of members at any other place also. Okay, there are two rules basically for the register, for maintenance of register of members. You can say whenever there is allotment of shares, debentures, anything, when the board approves it, within 7 days entry should be made in the register of members, right? Okay, thereafter whenever there is buyback or there is any consolidation or there is issue of sweat equity shares, transmission, anything, entry is going to be made within 7 days after approval of board. In case any charge is created on promoters holding, like promoters have certain securities and they have pledged it. So if the charge is created on those, then you have to register it within 15 days. So basically we have only two time limits which are given. In some cases it's 7, in some cases it's 15 days. I have prima facie written it over here, 7 days, because that is what you need to remember more importantly, right? The register is going to be authenticated by the CS or any other person who is authorized by the board, right? Okay. Now, there are three things that are basically covered in section 94, where you keep the registers, where the place, the preservation and inspection, right? So how long do you need to keep the register of members? Register of members you have to keep permanently, but when we're talking about the debentures or any other security holders, once you have paid the debentures, right, they have been redeemed. From that date till 8 years you will preserve. Thereafter you can discard it, you can destroy it. Okay, it's again going to be kept in the custody of CS or any other person authorized by the board. Now, who can go and check and inspect these registers? Anyone. But since the registers are of members, debenture holders, or security holders, respectively, they can check and they can inspect without any payment of fee during business hours. But for others, they have to pay a requisite fee, and thereafter they can inspect those registers. Okay, they can inspect those registers. Now we will see in detail the foreign register. So company, if you have issued any shares or securities and you are authorized by your articles, then you can maintain a register of holders or beneficial owners of residence in that country only. But you have to maintain the same format, and once you open a register over there, within 30 days of opening, you will intimate to ROC and MGT 3. If there is any change, then also you will intimate within 30 days of change, a change of place of register. Supposedly you are keeping the register over here, you inform it within 30 days. You shift it from here to here, you inform it again within 30 days to ROC, right? And whatever entry you are doing in that register, within 15 days of that entry, you will transmit this information over here, and the same information will be entered in the duplicate register which is maintained here at the registered office or any other place. Okay, supposedly you don't want to continue that foreign register, you can close it, inform ROC, and all the contents will be transferred to the principal register. Foreign register is a part of principal register, and that is also going to be open and available for inspection. Okay, I think so far the things are clear. Okay, ma'am, is there any other register also which is being maintained by the company? Well, then you have register of members, you have register of debenture holders, you have register of other security holders. There is a register of beneficial owners which is maintained by the depository. There is foreign register which is being maintained. We also talk about register of beneficial owners and register of SBO, right? Significant beneficial owners, which we'll talk about a little later, right? Apart from that, you have to remember that these registers have to be preserved and they can be inspected. Okay, if you want to obtain any extract, then you have to make certain payment of that register. Not exact, but if you want a copy of a register, then you have to make certain payment, and within 7 days you will be provided that copy of register. Okay, now can this register be closed? The answer is yes. The registers need not be open all year round. They can be closed by the company at one time, two times, or multiple times. That is the call of the company. But at any one point of time, they cannot they cannot close it for more than 30 days. And together in a financial year, they cannot close it for more than 45 days. Okay. And every time they want to close it, they have to give a 7 days prior notice. If you're a public company, you have to give the notice and advertisement by way of advertisement also. You have to put it on your website of your company, and you have to give it to SEBI also if you're a listed company. But if you're a private company, then just give 7 days prior notice to your members that you're going to close the register, and the register is going to remain closed from this date to this date, and you can go ahead and close the register. Fine? Okay. Now we have two sections, section 89, which is about beneficial owners, and then we have section 90, which is about SBO, that is significant beneficial owners. So first of all, beneficial owners. See, at a lot of point of time, you can see that the share is in my name, but I'm not the beneficiary of that particular share. Maybe the benefit is being passed on to somebody else. Like if it is a wholly owned subsidiary, right?
So if I want to make a company a wholly owned subsidiary and that company is a public company, there has to be minimum 7 members on plate. So I cannot hold all 100% shares, right? One share I have to give to 6 other people just for the sake of compliance of law. But do these shares belong to these 6 people whose names are registered, whose names are entered in the register of members? The answer is no. The shares belong to me. All the shares belong to me. Just for namesake, I've entered their name for compliance of law. So I will inform the company that I am the beneficial owner of these shares and they are only the registered owner. They will inform the company that they are only the registered owner. They are not getting the benefit. So who is a registered owner whose name is there in the register but he's not getting the benefit? And or he's not holding any beneficial, it doesn't matter, he does not have any benefit in the shares, right? So he's not holding any beneficial shares, interest in the shares. And who is the beneficial owner? The person whose name is not entered in the register but he is the beneficial owner, right? Maybe the shares cannot be purchased in the name of a partnership firm, so some partner is holding the shares on behalf of a partnership firm, right? So there could be a lot of cases. There could be simple case, X is holding the shares but actually the benefit is going to Y, right? So it is the duty of registered owner as well as the beneficial owner to inform the company. They have the respective forms of informing, MGD4 and MGD5, right? So you have to give this declaration to the company that we are the registered owner, I am the beneficial owner. If you don't do this, there is a penalty, right? Sometimes, of course, the people try to hide for different reasons. So that is a different call, right? But of course, there is a penalty. When company gets to know, okay, that this person is my registered owner, this person is my beneficial owner, they will take note of the same, and within 30 days in MGT6, they will inform it to ROC. If the company does not inform, again, the company has also been given the penalty. Okay. See, if you inform the company, you get the right to all the benefits, and if there is any default, the benefit can be enforced through the company. But if you do not inform, then it's all gone in waste, right? Now we have another concept of SBO. Although SBO rules and everything are very huge, but you don't have to read it in detail. So what is SBO? Basically, significant beneficial owner. It is always an individual, right? Okay, so I am Shivangi and I hold 10% shares of ABC Limited. So everyone would be like, okay, Shivangi is holding 10% shares only. She does not have much control in the company. She's the holder of only 10% shares. But I am a major shareholder in PQR Private Limited. And this PQR Private Limited is holding 90% shares, or let's say 70% shares of that company. So just imagine, I have a direct control of 10% and I have an indirect control of very huge, right? We're not getting into the calculations, but I have very huge indirect control also. So if the company gets to know that, okay, this particular individual is directly controlling this much and indirectly also controlling this much, that means she's getting some good benefit. She's a significant beneficial owner. Okay, if I'm directly controlling 50% shares in that company, then I'm not an SBO. Why? Because it is clearly visible. SBO is a concept of indirect holding and not a direct holding, right? So if I am an individual, alone or together, if I hold beneficial interest of 25% or the prescribed percentage, which is 10%, right? But in the section it's written 25%, through any other person, like maybe company, LLP, firm, HF funds, anything in a company, then that means I am a SBO, right? Now every significant beneficial owner, you have to file a declaration in form Ben 1 within 30 days to the company. The company is supposed to maintain a register of the same, and the company has to file a return of SBO in Ben 2 within 30 days to ROC in the same manner. Then there is penalty of the same. Okay, you don't have to read about company's duty with respect to SBO. Fine. Then we move to the next part, after registers. After registers, we have to understand and we have to discuss a lot about meetings. What are the different types of meetings? We have meetings of shareholders, which are called as general meetings. We have meeting of debenture holders, which are called as the meeting of debenture holders. We have the meeting of directors, which is called as board meetings. And there could be other class meetings, other meeting of creditors, and a lot of things. In this particular chapter, we discuss and we talk about general meeting, which could be AGM, which could be EGM. Annual general meeting is held once every year It's annual general meeting, of course, and that is mandatory for every company except for OPC. When we talk about EGM, it is not mandatory, there is no requirement. But if you want to transact some urgent business, like maybe you want to change the name of the company and for which you need to seek the approval of members, but you cannot wait till AGM because AGM has a time limit and AGM will be held annually only. So if you cannot wait till then you can call EGM. Okay, but no matter you call AGM or EGM, the requirement is that it should be properly called, convened, and conducted. Before meeting, we have to ensure that the notice is sent correctly. The notice is annexed with explanatory statement wherever required. There is adequate quorum in the meeting. There is a chairman who presides over the meeting and ensures the decorum. There can be a provision of proxy, right? All the provisions of proxy must be complied with. The voting should be done according to Companies Act only. Likewise, the resolution should be passed according to Companies Act only. So this should be ensured during the meeting, and once the meeting is concluded, we have to ensure that we are writing and we are compiling all the minutes of meeting correctly, and there are certain other maintenance of documents which must be done, right? Okay. There are two types of resolutions which we talk about. Actually, there is the third one also, resolutions which require special notice, which we'll talk about a little later. But otherwise, we have two types of resolution. One is ordinary and one is special, which is being passed by the members. For ordinary resolutions, just the votes in favor should exceed votes against. We talk about the members who are present and who are voting, right? Okay. Like if you want to change the name on direction by central government, then we need to pass only OR. Okay. Then we have special resolution. For a special resolution to be passed, you must pre-hand tell the members that we are proposing SR. You cannot pass SR without telling the members that SR has to be passed. Okay, there has to be a proper notice which is sent, and votes in favor should be more than equal to votes 3 times votes against. So if the number of votes against are 25, 25 into 3 is equal to 75. So at least if the votes in favor out of 100 votes are 75, that means SR is passed. SR is needed in a lot of cases that we have been reading and we will read. Okay. Now we begin with all these sections that we have read so far. The first one is notice of meeting. Notice has to be sent properly. It has to be sent in writing or through electronic mode, right? If it is a private company, it's same unless the articles provide otherwise. That means articles can provide otherwise. If it is a Section 8 company, you have to send 14 days notice, right? In all other cases, you have to send 21 clear days notice. What is 21 clear days notice? That means you exclude the date of general meeting and exclude the date of the date of serving notice. The notice is deemed to be served at the expiry of 48 hours if the notice is sent by post. Okay. So if you're sending the notice via email, you exclude that date and you exclude the date of the general meeting, and in between that the member should clearly get 21 days. That is the meaning of 21 clear days. But if you're sending the notice by post, then today you are sending, it will be deemed to served at the expiration of 48 hours. That means you leave 2 days, then it is deemed to be served. So you skip that day and skip the date of meeting, and in between the member should get 21 clear days. That is what is intended, right? You will send the meeting notice of meeting to every member, director, stock exchange, legal representative, and the auditor. Okay. If you give the notice, great. If you don't give, we will check whether it's accidental omission or deliberate omission. If it's accidental omission, it's okay. But if it's deliberate, then the notice and entire proceedings will turn out to be invalid. What do you specify in the notice? The notice or the content of notice is going to clearly specify the place where you are going to hold the meeting, date, time, and what are you going to transact in the meeting. That is, what is your agenda. Okay. And when we talk about agenda, there is section 102 which is associated and talks about explanatory statement which needs to be annexed with the notice of meeting. But before that, supposedly the company is not able to send 21 days clear notice. It is running short of time. So what it can do is it can obtain written consent from 95% of the members in case you're calling AGM, and for members holding 95% of paid up capital, plus they should be majority in number in case the company is with share capital. In case the company does not have share capital, the members who have 95% of voting power. If you take their prior consent in writing, you can call for a shorter notice. That means maybe you are giving just 10 days notice and you're calling AGM or EGM. So you can do that. Fine. Sometimes when we send the notice, along with the notice there has to be explanatory statement which is annexed. What is explanatory statement? Which gives you the details about what business are you going to transact. To understand this, you have to understand one very basic thing. What is ordinary business and what is special business? Please don't confuse this with ordinary resolution and special resolution. Ordinary business requires special resolution, but special business requires SR. This is not the case. Special business may require OR, special business may require SR. Like if you have been given the instruction by central government to change your name, it is a special business only, but it requires OR. But if you want to change the name of your company voluntarily, then it requires SR. That is also a special business, but it requires SR, right? So we have broadly only 4 ordinary business, and they are taken up at every annual general meeting. So at every AGM, these 4 matters are ordinary business which are taken up at AGM only. Apart from that, any business, whether they taken at AGM or EGM, will be a special business for which you need explanatory statement. So ordinary business does not require any explanatory business, but all special business need explanatory statement. What are 4 ordinary business? Consideration and adoption of financial statements, declaration of dividend, appointment of directors, and appointment of auditors. Fine. All other other than 4 ordinary business, they are special business. They can be transacted at EGM or AGM and requires explanatory statement. The question is, what is explanatory statement? We have read one thing when we are issuing ESOP, when we are issuing sweat equity, we have read what are the contents to be included in the explanatory statement, and every time we have incorporated a lot of information which enable the members to understand that what are we transacting, what will be the consequences, what is the scope and everything, right? So it helped them in take an informed decision, right? All that information is definitely included. Apart from that, there is some additional information which is to be there in explanatory statement, and that is the disclosure of interest of directors or KMP or their relatives. What type of interest? It could be any interest. I have some interest in this particular contract because this contract is being given to my father, so I have this interest. Maybe I have some financial interest. Why? Because I am a partner of this firm which is going to transact, which is going to deal with the company, right? So any type of interest I may have, that interest has to be disclosed. Thereafter, if the company is contracting or dealing with another company, and in the other company the director, KMP or promoter have 2% or more of shareholding, then that also needs to be disclosed in the explanatory statement. Why? Because the directors are proposing this transaction to take place and they already have some interest. Members should be aware of this interest so that they are taking an informed decision. Okay. Next, we go to quorum. What is quorum? The minimum number of members required to constitute a meeting. Otherwise, the meeting is going to be invalid, right? Okay. So, first thing, when we are talking about a private company, then hire of 2 members or whatever is prescribed in the articles. The articles may say that the quorum for this company shall be 6. So 6 or 2, whichever is higher. What is higher? It's 6, of course. So the private for this particular company, the quorum shall be 6 members personally present. Proxies are not counted for the purpose of quorum. Public company, higher of this limit or the number prescribed in articles. What is this limit? If your number of members are up to 1,000, 5 members personally present. If they're more than 1,000 but up to 5,015, and if they're more than 5,000, then 30 members personally present. When do we check the quorum? When the meeting starts, that means the commencement of meeting time is 11 a.m. So we'll check at 11:30 whether the quorum is there or not. If quorum is there, great, we'll proceed with the meeting. If the quorum is not there, it will be adjourned to same day, place, time of next week. Or it may be determined by the board that no, we are not free on this day, we can keep it at any other place. You can keep it, no problem at all. You have to give 3 days notice individually or through advertisement to the members, informing them about the adjourned meeting. Okay, but if the meeting was called by the requisitionist, EGM was called by the requisitionist, the meeting shall stand cancelled. Because if it is called for the by the members for the members and the members are not attending, what is the purpose of postponing the meeting? They're not interested clearly, so it should be cancelled. Fine. Quorum must be present throughout the meeting, and proxy is not going to be counted for quorum. Okay. Next, we move to the section of chairman. Fine. Now, chairman is somebody who is needed in every meeting, and he ensures that the entire proceedings are being done in a fair and transparent manner, and he will regulate the entire thing, right? Now, who is going to be the chairman? Chairman is somebody who is appointed according to the article. So, articles may say this particular person is the chairman, he will be the chairman. The articles may say that chairman is going to be appointed in this manner, it will be appointed in that manner. But what if articles don't say anything? Then whoever members are present, they will elect one of them to be the chairman, right? They will elect them just by simple voting of show of hands. However, if poll is demanded, then immediately the poll will be carried out and the chairman will be elected as a poll, and that elected person will act as the chairman. Okay, then we have proxy. Is proxy allowed? The answer is yes. Okay, so any member, if you're allowed to vote, you're allowed to attend the meeting, you're also allowed to send a proxy on your behalf. Okay, but one thing you have to understand, that although proxy can be any person, it could be a member, it could be a non-member, but when we're talking about a section 8 company, a proxy cannot be a non-member, it has to be a member only. Fine. How do you appoint proxy? You have to appoint proxy by depositing with the company a proxy instrument which is in MGT 11. Okay, you have to deposit it 48 hours before the meeting. Articles may say that you have to provide it 72 hours before the meeting. That particular provision is not going to be valid, and even if you are depositing it 48 hours before the meeting, it's going to be a valid one. Okay, so you give it to the company, and company takes into record the proxy. It may be revoked. Like maybe you have appointed a proxy, but later on you yourself want to attend the meeting, you can go and attend the meeting, and if the proxy has not voted, you can also vote. Okay, fine. Okay, now sometimes it may so happen that you have sent one proxy and thereafter you sent another proxy. That means maybe first you have appointed Mr. X to attend the meeting and vote on your behalf. Thereafter you feel that no, Mr. X is not the right person, I will appoint Mr. Y, right? So whatever proxy is received latest or last, that is going to be valid proxy, provided it is received within time. So if it is received like just 2 hours before the meeting, it's not a valid proxy and that will not be counted. But if you have sent a proxy like 50 hours before the meeting, then this is going to be valid because it has to be sent at least 48 hours before the meeting. Okay, now this proxy form can be inspected by anyone. Okay, before 24 hours of meeting by the members. So before 24 hours till the conclusion of meeting, you can attend the you can inspect that proxy form. However, if you have the intention of inspection, you have to give a 3 days prior notice. So you inform the company, I have the intention to inspect your proxy forms. Fine, they'll make arrangements. You can come, you can check the proxy forms. Okay. Now, when we are talking about appointment of proxy, then one thing has to be clear, that the notice that you're sending under section 101 will clearly specify that member, you are entitled to attend the meeting in person, or you may also appoint a proxy who can vote only on poll, who cannot vote on show of hands, and proxy need not be a member. So you will specify this content in the notice of general meeting. Now, one person can be a proxy of 50 members maximum, but they should not be holding more than 10% of the share capital. Now, supposedly there is one single member who is holding 11% share capital. Can he not appoint the proxy? He can appoint the proxy. That is the exception. If one member is holding more than 10%, so there will be one person who can be appointed as his proxy, and that person will not act as a proxy of any other person or the shareholder. Okay, proxy has some limited rights. He cannot speak at the meeting, he cannot vote on show of hands, he'll not be counted for quorum, and he'll have the right to vote only on poll. Only on poll. Fine. Okay. Now, when we talk about proxy or when we talk about quorum, we say that the proxy is not counted for the purpose of quorum, but you have to understand that the representative is counted for the purpose of quorum. Representative of whom? Representative of government, governor, representative of president or governor, or maybe company, right? Because company cannot come and attend the meeting in person, so they will always have a they will always have a representative that they send. That particular person will have all the rights just as a member and will also be counted for the purpose of quorum. Okay, now, can you restrict somebody's voting right? The answer is yes. When the member has not paid calls. So if your article says so, then you can restrict. You can say that you are not allowed to vote. Why? Because company has asked you to pay this call money, you haven't paid this call money, or there is any amount which is due from you and you haven't paid it, so we are going to restrict your voting right. You cannot vote until you clear this dues. On any other ground, you cannot restrict anyone's voting rights. Okay, so the voting right can be restricted only on this ground, that is non-payment of call or sums due. Okay, fine. Now, if I am voting by show of hands, it's very clear that one shareholder is equal to one vote, right? So, if I have more number of shares, I'm as good as the other shareholder, right? But when we talk about voting by poll through electronic means or postal ballot, then one share is equal to one vote unless there is DVR, right? That means voting will be in proportion to the paid up share capital that I hold. Okay, so more the number of shares, more the number of votes. That is what I have. Okay, so whenever there is a meeting which is being done, first of all, usually the vote is done by show of hands. Actually, this is not the practical thing, but yes, voting by show of hands is very simple, and a decision is going to be taken. So there is a chairman who is going to preside over the meeting, and if there is any agenda, let's say we are calling annual general meeting and there are 4 agendas which need to be taken up. The first one was declaration of dividend, right? Whether the company should declare dividend or not, for which you just need ordinary resolution. So the board proposes that we are proposing to declare a dividend of 10%. Do you all agree? There might be some people who say I agree, there might be some people who would say I disagree. So the chairman counts the number of votes in favor and the number of votes against. There might be some who will be like sitting like this, I will not vote, right? So if you're not participating in the vote, it doesn't matter. All the members who are present and they're participating in the vote, out of that we will see whether majority has been obtained or not. So if majority has been obtained, OR will be passed. If majority has not been obtained, OR will be lost. Okay, either a resolution is passed or it is lost. That is how it works. Fine. Okay, now one by one we will read about the different types of voting. Okay, voting by show of hands is very, very, very simple. Then comes your voting by poll in a meeting, right? So sometimes the members may demand for poll. Okay, the chairman also has a discretion that even if nobody demands on poll, the chairman himself can say that okay, voting is going to be carried out by poll only, right? And sometimes the members may demand poll. Who has the power to demand poll? somebody is holding 1/10 of voting power or 5 lakh paid up share capital, and if the company is without share capital, somebody is holding who is holding 1/10 of voting power. Okay, at least 1/10 of voting power. Okay, so you become eligible to demand for poll. Why? Because you have so much of capital, and you know that voting by show of hands and voting by poll will bring out completely different results, because I will get more power and I want to vote in this way. Okay, so now one thing everyone has to understand, that if I am a shareholder and I have like maybe 100 shares, that means I get 100 votes. I can use all my votes differently. Maybe I can say that one vote I want to cast this way, other vote I want to cast this way. That is absolutely at my discretion. I may want to cast all my 100 votes in a certain manner only. Okay, so that is something which is allowed. Fine. Now supposedly there is an agenda which is being taken up, and voting happens by show of hands. Now when voting is happening by show of hands, during that time, or maybe once the results are declared, the people who are eligible may demand that no, 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 let this be gone and carry out poll. So they can. Whenever there is a demand for carrying out poll, that demand is being entertained and the poll is being carried out within 48 hours of the demand. However, if the demand for poll relates to the adjournment of the meeting or election of chairman, then it is going to be carried out immediately. I already explained you the logic why, right? Okay, now comes your procedure for poll. Okay, how the poll is going to be taken. So there is first of all an appointment of scrutinizer. It may be one person, it may be more than one person, and he's being provided with the register of members, the specimen signatures, the register of proxies, and all the documents which are needed, right? Okay, now he will arrange for the polling papers and he will distribute it to all the members, and he'll receive and keep record of the same, and whatever he's receiving back, he will lock and seal in an empty box, and this is now going to be opened in presence of two witnesses. You count all the votes, you prepare a report that okay, these are the total votes which have been cast, these are the votes in favor, these are the votes against, these are the valid votes, these are the invalid votes, and everything, right? You prepare this report and sign it and submit it to the chairman within 7 days, who will countersign it and thereafter declare the result. Okay, clear? So very simple one. Then comes your voting through electronic means. Now electronic means include two things. One is remote e-voting, and the second is basically electronic voting system is as good as electronic ballots, where everything is happening electronically. You don't have to manually count that how many votes are in favor, how many votes are against. There is adequate cyber security which is being ensured, and accordingly the voting takes place. Okay, so here there are certain companies for which it is mandatory that you have to provide the e-voting facility. What are those companies? Listed companies and companies with 1,000 shareholders or more, right? So if you have 2,000 shareholders, it is mandatory for you to provide the voting facility by electronic means. Okay, now what is to provide electronic means? There are two things. One is remote e-voting. That means you're sitting at the comfort of your home and you have been provided a login ID and password on the depository. You log in there and you register your vote, that I agree or I disagree. Apart from that, you can also walk down to the meeting and there you can vote if you haven't voted at your home. There they may have like voting which is being carried out through polling papers or ballots or electronic voting. So at the general meeting also they have made voting arrangement, and they are also providing you the facility of remote e-voting if it is a company, listed company or company with 1,000 or more shareholders or members. Fine. Okay, so they shall give an option of e-voting for resolution at general meeting, and notice of meeting will clearly indicate. There are two things you have to understand. There are two things. One is the notice and the other is advertisement. Okay, first is the notice. When we send you the notice of meeting, it is going to clearly specify that you will be getting an option to e-vote, and at the meeting also you will get an option to vote if you don't exercise your vote through remote e-voting. And anyone who has casted the vote through remote e-voting can still come and attend the meeting, but you will not be entitled to vote, right? What is the process of e-voting? What is the time when you can cast your vote, right? How do you generate your login ID? How do you generate your password? All these things will be clearly stated in your notice. There will again be an advertisement, and in the advertisement, in English newspaper and vernacular newspaper, in the advertisement also it will be clearly stated that this business is going to be transacted through e-vote. This is the time for commencement of e-voting. This is the time for end of e-voting. What is the cutoff date? How you can generate your login ID and password? What is the website of the company? And if you have any grievance, to whom you can contact, that is the details of that particular person. So that is going to be specified in the advertisement. Remote e-voting is going to be open for at least 3 days, and usually it's open for 20 days, 30 days, right? It's going to be open for at least 3 days, and it will be closed at 5 p.m. before the date of meeting. So if 25th is the date of meeting, it will be closed on 24th at 5 p.m. Fine. So some votes will be registered remotely, and some votes will be done when the members attend the meeting. So there are certain members who don't register their vote remotely, but they attend the meeting, right? So if you haven't voted before, you can come and attend the meeting. What will happen here also, the board is going to appoint the scrutinizer who will count the votes, maintain register, and within 3 days, they will prepare a report and submit to the chairman, will consider, approve, and declare the result. Then comes your voting by postal ballot. What is postal ballot? Postal ballot is voting by post or electronic mode. It may happen without conducting general meeting. Okay, voting by postal ballot may happen without conducting general meeting. Okay, so what is happening? Basically, we're sending the ballot papers and everyone is recording their assent or dissent and sending it back. Apart from that, we also may provide them the facility of remote e-voting. We are providing them the login ID and password. They're registering the vote. We're getting the votes. Right? So this is how it happens. Fine. Now, for ordinary business, postal ballot is not allowed at all, because there we need to have discussion, and wherever the director or auditor has right to be heard, then postal ballot is not allowed. There are certain matters for which postal ballot is mandatory. Like if you want to alter your object clause of memorandum, if you want to alter your articles when you're converting the company, right? If you want to change your registered office from outside the city, or if you have if you want to change your object clause when you have unutilized money raised from prospectus, if you want to issue DVR shares, if you want to vary the rights of shareholders, buyback, director election, sale of undertaking, and what else is there? There is one more thing, right? Sale of undertaking and extending of lease, right? So if any of these cases has to be done, then it's going to be done through postal ballot only, ma'am. It is mandatory for all the companies. The answer is no, it's not mandatory for all the companies. If it is a company having up to 200 members, then it is not mandatory at all. Then you don't have to transact any business through postal ballot. But other than that, you have to transact through postal ballot. These many matters for sure mandatory, and other matters voluntarily you may, right? Okay. Fine. Okay. Now, what is the procedure? The company, you will send the notice to the shareholders along with the draft resolution, the reason, and ask them to send their assent or dissent within 30 days. So within 30 days, they have to send it. And if any assent or dissent is received beyond the span of 30 days, it's going to be treated as if no reply is received by them. Again, there are two things. One is the notice and the other is advertisement. Okay, so when we talk about notice is sent to the shareholders by registered post, speed post, electronic modes, courier facility, any of these, right? And then there is also going to be an advertisement in English newspaper and vernacular newspaper, which will clearly specify that this is a transaction which we're doing through postal ballot. This is the date of completion of dispatch of notices, when the voting will commence, when it will end. A clear statement that if we receive a reply beyond this date, then we are not going to treat it valid, right? And we have complied with everything. And if you have any difficulty, this is the person who you can contact, that it is in case of any grievance. Okay, thereafter, again, board is going to appoint the scrutinizer. He will maintain the register. He will receive ballot papers and keep in his safe custody. And once the date is over, within 7 days, he will open it in front of the witness, and he'll submit the report within 7 days to the chairman. Chairman is going to consider the same. Result is placed on the website of the company. The resolution shall be deemed to be passed at general meeting, and papers are kept till that date in the safe custody of scrutinizer. After that, it is returned. Okay, fine. Then we come to annual general meeting. Now, what is annual general meeting? It has to be done annually by every company except OPC. Okay, so every company are required to hold annual general meeting. What day? Day other than national holiday in the registered office, at the registered office, or in the same city. Time, business hours 9 a.m. to 6 p.m. When you have to hold it, for all the cases, there are three compliance which need to be done. That is, once your financial year ends, within 6 months, you have to hold your annual general meeting. Ideally, the date comes out to be 30th September. That is the last date for holding annual general meeting. But you can always get an extension by ROC if you make an application and a sufficient cause is shown. Maximum extension is 3 months. So by any case, you have to hold your annual general meeting by 31st December. Okay, this is the maximum extension that you can get. But there are three compliances. One is 6 months from end of financial year. Secondly, the gap between two AGMs should not be more than 15 months. And thirdly, one meeting should be there in each calendar year. Okay, so that is how you have to hold your annual general meeting. But it is not the case in case of first annual general meeting. So first annual general meeting, there is no extension which can be granted by ROC, but they have given a liberal limit straight from the start. Okay, that is, you have 9 months from the end of financial year. So without any extension, only you have the date till 31st December. Okay. Can AGM be held at any other place? The answer is no for a listed company, but for an unlisted company, you can hold at any other place if you receive the consent of members in advance. Okay. Supposedly, the company fails to call or conduct annual general meeting, then in that case, any member can make an application to NCLT, and NCLT will give direction to the company that go and conduct your AGM. They may also give additional directions like, no matter if the members are not coming, if the proxy is coming, consider proxy to be the quorum and do the meeting, or consider this to be the quorum and do the meeting. So they can give directions as they deem fit. Okay. Now, once you are done with your AGM, in addition to minutes of meeting, you also have to prepare a report on AGM that is only to be done by listed company. What report? When was the meeting held? Date, time, place, chairman, who was the chairman, what was the quorum, how many members were present, is there compliance of law, was the meeting postponed or adjourned, what business was transacted, what was its result, was it passed, was it lost, and everything, right? So these details have to be prepared in MGT 15, and they have to be submitted. The form has to be submitted within 30 days of the conclusion of annual general meeting. This is mandatory only for listed company. Okay. Now we come to AGM. AGM may be called by the board whenever they deem fit at any place in India, even on Sunday. But sometimes board has to call EGM if the requisitionists are requesting. Who are the requisitionists? Requisitionist means if you're holding 1/10 of share capital or 1/10 of voting power, you are allowed to, you are an eligible requisitionist, and you can request the board to call extraordinary general meeting by clearly stating out the matters which need to be stated, which are to be considered in the meeting. Okay. Now, if the board fails to call the meeting, the requisitionists themselves can call the meeting, and in that case, well, the meeting is going to be not be called on Sunday, and it has to be called either at the registered office or in the same city where the registered office is situated. Then comes section 98. What is section 98? Tribunal gets the power to call EGM, right? Tribunal can call EGM suo moto, or if a member or director makes an application where it is impracticable to conduct EGM by giving directions as they deem fit, just as we have read the other section. Now, section 96, 97, 98, where you have to call the meeting either upon directions of NCLT or a normal compliance of AGM, and you don't follow it, then you have a penalty stated in section 99. Okay. Now, this I have already told you. So if you are eligible member, you have to give a signed requisition and deposit it at the registered office 21 days before the proposed date. And board, you are going to hold the EGM within 45 days. If you hold, great. If you don't hold, then requisitionists themselves can within 3 months obtain the, can call within 3 months, call the EGM, right? How? By obtaining the list of members, sending them the notice in the specified manner, hold EGM on any day except national holiday, and you can get the expenses from the company, and that expenses will be given by the company after deducting the remuneration of the directors who were in default, the directors or officers who were in default. Okay, then we have section 111, that is about resolution circulation. What is it? Supposedly we know that a meeting is going to be conducted 1 month from now, and we believe that in that meeting we must remove this particular person as a director, maybe, right? So we want this resolution to be passed. What we can do is the eligible members, whoever is eligible under section 100, that is the person holding 1/10 capital or 1/10 voting power, they may prepare with sign and deposit any resolution at least weeks prior to the meeting, and any statement at least 2 weeks prior to the meeting. Okay, and at the registered office of the company. In a company, it is your duty to circulate it to all the members, because one member can't reach the other member directly but through the company only. So if you want any resolution to be passed, then you can give it to the company, and it will be their duty to circulate it all over around. If they don't, then they will be liable for a penalty. However, if they consider that no, this is pure defamation and they're trying to bring us down and this is not going to bring a very good image, then what can happen is that particular member or that particular director, or they can make an application to central government, and central government may declare it to be defamatory. In that case, you need not circulate it. Okay, fine. Now, there are certain resolutions which require special notice. Okay, so if members, you want to appoint some other auditor other than retiring one, or you don't want to appoint him, you want to pass a resolution that Mr. ABC and firm will not be appointed, you are not satisfied with their audit report. Okay, or you want to remove a director before his term, or you want to appoint some other director in his place, then that is a resolution which requires special notice. This is a normal resolution which you want to be passed, so you are doing this, fine, but there are certain resolutions which require special notice. So what you have to do is you have to send the notice of this intention to the company at least 14 days before general meeting, but not earlier than 3 months. Who is eligible? The ones who are holding 1% voting power or 5 lakh share capital. You will give it to the company. Company shall give the notice at least 7 days before general meeting to all the members. If it is not practical, you will publish it in the newspaper and on the website. There are certain resolutions and agreements which need to be filed with ROC, which are given in section 117. What are they? First thing, all the resolutions that you pass, all the resolutions, there are 3 types of resolutions, I'll tell you: the special resolutions, OR, and resolutions with requisite majority, which are majorly the board resolutions and all, right? So what need to be filed with ROC? Not every resolution needs to be filed with ROC. Supposedly we have passed an ordinary resolution, this need not be filed with ROC. Okay, the special resolutions need to be filed with ROC. Any resolution which requires unanimous approval of the members, which has got unanimous approval of the members, there is no resolution which has been specified in the Companies Act as such, but it is there in the section. So if in future it is specified, then we have to file that also. Okay, the resolution with respect to appointment or reappointment or renewal of the managing director, right? Then any resolution by the class members. Okay, then resolution of winding up, voluntary winding up, then resolution under section 179. There are a lot of resolutions which are there under section 179 which are passed by board. So they are board resolutions with requisite majority, and any other resolution which may be prescribed. So all these resolutions need to be filed with ROC. Okay, in MGT 14 within 30 days of passing off the same along with the fees as prescribed. Next we come to minutes of meeting. Minutes of meeting. These are the provisions are contained in two sections. One section is section 118 and the other one is section 119. What is section 118? It tells that every company, whether you are doing any meeting, it is the meeting of creditors, it is any class meeting, it is any general meeting, it is any board of directors meeting, any committee meeting, any meeting it may be, you have to prepare the minutes. And there will be a distinct minute book, different minute book for each type of meeting. What is the meeting, minutes of meeting? The correct summary, fair and correct summary of what happened in the meeting, right? It has to be entered within 30 days from the conclusion of meeting, right? Fair and correct summary. It is going to be signed, dated. It is going to be preserved permanently, signed by chairman, kept at the registered office within 30 days. And there shouldn't be any loose pages, and it's going to be open for inspection during business hours by members without any charge. Okay, fine. Now, when we are talking about the signing, if it is a board meeting minutes, it is going to be signed by the chairman, right? If it is general meeting minute, it is going to be signed by the chairman, of course, or if there is inability of the chairman to sign it, it will be signed by the any director who is authorized by the board. Okay. Again, if it is a minutes of postal ballot, it will again be signed by the chairman, and if there is inability, it will be signed by any person who is authorized by the board. Okay. Now, what will be there in the minutes? Specifically, it is written that in the minutes, you will clearly specify the directors who were present and the directors who disagreed. I am talking about directors, so definitely I'm talking about board meeting, right? So in the board meeting, you will clearly specify that these 4 directors will be present, and maybe this director dissented, this director disagreed. Why? Because it's very important. Once you read the chapter of directors, you will understand that the directors are held liable for a lot of things. So by the minutes of meeting, we get the evidence, oh, this director was not present when this happened, right? So he does not have the knowledge. How can we hold him liable, right? So we get to know a lot of things. Then there are certain things which should not be included in the minutes. What the chairman considers to be irrelevant, like maybe this director wore a beautiful or she came wearing a sari. It is immaterial, right? Something which is defamatory or something which is detrimental to the interest of the company, in the opinion of chairman. So the discretion and the opinion of chairman is supreme. If he thinks that it's not worth it, it's not going to be included at all, right? It's kept at preserved permanently and kept as an evidence. Okay. Fine. Now, if you don't maintain it, there is going to be penalty, and then there is inspection part, which I have already told you. Section of inspection is not something which is very huge. And then we have one section called as annual return. Annual return again has to be prepared by every company, and it is basically information. Annual information about the company. So if you hold the AGM, within 60 days of AGM, you have to prepare an annual report, annual return. There's a difference between annual report and annual return, okay? And what you will do is you will file it with ROC. Okay, one copy of annual return is going to be on the website and Wembling disclosed in the board's report. Thereafter, one copy, that is MGT7, it is going to be signed by the authority which is needed, and it is going to be furnished to ROC within 60 days from the date of AGM. Supposedly AGM is not held, then within 60 days from the last date on which AGM ought to have been held, that is 30th September. If till 30th September AGM is not held, then within 60 days from 30th September, you will still file this MGT7. There is an abridged annual return which is prescribed, MGT7A. Okay, and that is being prescribed for OPC and for small companies. Okay, so they are not supposed to give this elaborate information, and they can simply file a small one, and they can go ahead with it. Okay, now you have to understand what is there in this annual return. The details about the company, like Where is company's registered office? What is the principal activity that it's doing? Its shares, its debentures, where it is indebted, right? Any change in the members or the debenture holders, any change in the KMP, right? The number of meetings of the directors, the remuneration which is being paid to the directors, then if there is any foreign institutional investor which is holding shares, that or any other matter which may be prescribed. Okay, so all these are going to be there. Now when we are talking about signing, if you are a normal company, a director plus a CS will sign if there is a CS in the company. If there is no CS, director plus any CS in practice, they are going to sign. If you are a OPC or small company, by CS, and if there is no CS, by by the director, okay, they are going to sign. That is how it is. But if you are a listed company or with paid up capital 10 crores or more, or with turnover 50 crores or more, then in addition to the signing, there has to be a CS certificate which you will obtain in MGT 8. Okay, and thereafter you have a penalty, and there is a penalty on CS also if he certifies not in conformity with law, straight away penalty of 2 lakhs. So CS also is going to be in strict compliance over in this particular section. Okay, thank you. So what is director? Director has been defined in section 2 clause 34, which simply means director appointed to the board of the company. Well, I can say a person will be treated as director not if he works as a director, but if he is designated as a director, right? So that designation or that appointment is very important according to that definition, right? Okay, now Companies Act says that when we're talking about the company or company or the board of directors, basically they are the trustees of the assets of the company, right? The directors, when I'm saying it is collectively all the directors, or when I'm saying board, it is collectively all the directors. When I'm saying board of directors, it is collectively all directors. One individual director does not have the power. Okay, right? Directors or the board of directors or the board, they are trustees of companies' assets or properties because they are managing those assets. They are also the agents of the company because they are acting on behalf of the company on all the routine matters. However, clearly under entire Companies Act, there are certain powers which have been reserved for shareholders, right? Okay, so the shareholders have the power to, in fact, change the directors also. They can remove the directors, they can appoint the directors. So, appointment, removal, all these powers are there with the shareholders only. Okay, if there is a manager in the company, he's not a director. That you have to very well keep in mind. When we are saying the officer of the company, officer includes a director. So whenever we say officer in default, we are also charging the director of the company, whoever is responsible for the same, right? Okay, some basics which you must know, that these are the minimum number of directors which are required in a company, and maximum is 15 in all types of companies, which can further be increased by passing special resolution. Only individuals can be appointed as directors. Board of body corporates or likewise, they cannot be appointed as directors, right? Before I take you through the resignation, removal, disqualifications and everything, there is first thing that you must know, that what a director does, or what are the duties or what are the responsibilities of a director. They're given in section 166. You have to act according to articles. You have to act in good faith. You have to exercise all your duties with reasonable care, right? You don't have to involve yourself in a situation where there is a conflict of interest with a company with your own interest, right? So personal interest should be kept at the last, right? no undue gain or advantage, and you will not assign your office. What is assignment of office? That if I am going somewhere, I'm giving this director's position to someone else. No, you're not somebody who can assign your office. You don't have the power to do that, right? This is against the duties which are given. To become a director, the basic requirement is that you should be an individual, first thing. Secondly, you must have DIN. What is DIN? Director's identification number, right? So there is an entire procedure. How can you obtain DIN and etc., which you don't have to read in detail, right? But basically, you should have done. So every individual, if you want to become a director, you have to make an application to ROC for getting that DIN, right, in the prescribed form, and then you get that DIN, right? DIN is applicable once in a lifetime. That means one DIN is going to stay with you till the lifetime. No matter you become the director of this company, then you leave this company, you become the director of another company, it's okay, right? Secondly, you want to become a director, there is no academic or professional qualification which is being given that you have to be a CMA, then only you can become a director. No, right? You are anyway welcome to become the director of any company, right? So there is no requirement. Secondly, there is no share qualification requirement. Earlier, there was a provision which stated that if you want to become the director of a company, you must hold the shares of that company, minimum this many shares. Right now, we don't have any such requirement. However, there could be any specific articles of association of any company which could say so. Right. So if that particular company says so, then you need to hold those shares. Otherwise, no academic qualification needed, no professional qualification needed, no share qualification needed, right? However, there is one section called as section 164 which states that you should not be disqualified, right? That means you are eligible to be appointed as a director if you're of sound mind. That means you are not eligible to become the director if you are of unsound mind. And unsound mind doesn't mean that your friends call you so. Unsound mind as declared by competent court. Secondly, undischarged insolvent. There is a whole phase or process of insolvency. You apply for insolvency, then you are declared as insolvent. Thereafter, there is a tenure, then you are discharged. Now you can start a fresh life. So till the time you are not discharged, you are undischarged, you are not eligible to be appointed as a director. You have made an application for insolvency, right? So you have applied, you have made an application. Right now you have not been declared as insolvent yet. So still you cannot be appointed as a director. Fine. So general grounds of disqualification. Let's see how far I have told you. I've told you this one, I've told you this one, I've told you this one. The next comes offense. If you have been convicted means found guilty. So if the court has found you guilty, that yes, you have done this offense, it doesn't matter it involves moral turpitude or not, right? And you have been sentenced to imprisonment for at least 6 months. So any time in the past you were found guilty for any offense for which you got imprisonment of at least 6 months. Now, when that 6 months will expire, that means whatever was the tenure of your sentence, you were sent to jail for 6 months. That 6 months expired. From that date, 5 years have expired, 5 years have elapsed. Now you are eligible to be appointed as director. So during that tenure of sentence, you're not allowed. After that, after expiry of sentence, till 5 years, you're not allowed. Okay. If at all your period of imprisonment was 7 years or more, you are disqualified for life. You can never be appointed as a director in any company. Okay, clear? Next, if the court has passed an order disqualifying you, you cannot be appointed. Next, if you are a shareholder also, you are a director also and you are a shareholder also, or you're not a director yet, but you are a shareholder and you have not paid call money. The company is continuously asking for call money, you're not paying the call money. There was a last day fixed for payment of call, you have not paid it. After that last date, 6 months have elapsed. 6 months have gone and you have still not paid the call money. So you become disqualified to be appointed as a director. Next, we have offense under section 188. I would suggest learn it as it is. Right now, we don't have the time to explain you what related party transactions are, right? But if you have done any offense in respect of related party transactions during last 5 years, you're disqualified. If you have not been allotted in under section 154, that means it is a non-compliance of section 152 basically, or if your directorships are exceeding the given limit under section 165. Okay, so you're disqualified. Fine. Right? Okay. Now, disqualification is checked at the time of appointment of directors, and we have another part. What is another part? Section 164(2). Now, if you are already a director of a company and that particular company has not filed its financial statements or annual returns for continuously 3 years, then my dear, listen to me very carefully. You are not eligible to be appointed, right, to be reappointed as a director of that company or appointed in any other company for 5 years. So you become disqualified for 5 years if you are a director in any company wherein the financial statements or annual returns have not been filed for continuously 3 years, or that particular company has not repaid its deposits timely, redeemed its debentures timely, right? And this particular failure has continued for 1 year or more, then you are not eligible to be appointed in that company, eligible to be reappointed in that company or appointed in any other company for 5 years. Okay, for 5 years. They're disqualified for 5 years. Fine. But supposedly, I just joined this particular company. So I am a new director and I got to know, oh my God, this company has not been filing financial statements for 3 years. What do I do now? Now I become disqualified to be appointed in any company as a director for 5 years. Where will I go now? I didn't know all this before joining, right? So for the first 6 months from the date of appointment, this disqualification doesn't get attracted to us. So what you can do in that tenure, either resign from that particular company or rectify these defaults if you can and continue. Okay, so this is what can be done. A private company can provide additional grounds of disqualification under section 164(3). Okay, then we come to the appointment of directors. See, we need a lot of directors. Basically, the director have to be appointed in general meeting because there is a lot of requirement. You need to have a resident director. Some companies need to have women director. Some companies also need to have independent director, right? So independent director, women director, resident director, there are additional directors, alternate directors, nominee directors, right? So there are so many type of directors which are actually needed to be appointed. You don't have to read all details at the inter level right now. So we'll read them at the final level. But right now you need to know some basics about the appointment of directors. What is those basics? We are talking about a public company, right? Okay. So in public company, whatever is the total number of directors, it has to be minimum 3, but let's say the company chooses to appoint the total number of directors as 9. Your articles may say that all the directors will retire at general meeting and again they will be reappointed or somebody else will be appointed. So this may happen. But if they do not say anything, what will happen at not less than at least 2/3 directors will be rotational directors. 2/3 rotational means what? 6. Out of those 9 directors, 6 directors will be appointed as rotational directors at least, and 3 directors may be appointed as non-rotational directors. If I talk about, let's say, Reliance, there could be Mr. Ambani who is appointed as non-rotational director. He is not going to retire. But out of these 6 directors, they are rotational directors. Now, out of these 6, one third of these, right? That means 2 director at every general meeting out of these 6 will be retiring. They can be reappointed, or in place of these, somebody else can also be appointed. You get my point? Right? Now, who selects who is going to retire? So the directors who were in the office for a longer period will be liable to retire first, right? If there are two directors who have been appointed on the same day, then there could be a mutual understanding. Okay, this time you retire, the next time I'll retire, right? Or maybe on the basis of some lots, we can pick up some chits, and then that retirement may happen, right? So basically, this is how their appointment will be made, and this is how they are going to retire, right? If AGM is not held, the retiring directors are going to vacate. If the AGM is held, of course, vacancy on such retirement is filled. It can be filled by reappointing the same persons or appointing somebody else in case of the retiring directors. Okay, fine. So the vacancy can be filled by the same person also, or by some other person also. Disqualifications I've already told you. Next comes resignation. Okay. A director is allowed to resign. How can he resign? He has to give a notice to the company that I am resigning, right? He may also, it is not mandated on part of director, but he may send this copy of resignation to ROC also, because till the time everyone gets to know that he is retired, till the time he has a lot of connections, there's liability, there's a lot of things, right? So basically what happens, director, you want to resign, you give a notice in writing to the company, the board is going to take note of the same. Resignation is going to be effective later of the date of receipt of notice or the date specified in the notice. Supposedly I'm giving this particular notice on 2nd May, but I have written in the notice that I'm going to resign with effect from 10th May. So the resignation is going to be effective from this particular date. If there is no date which is given, the resignation is going to be effective from 2nd May, right? So the board will take note of the same, and within 30 days, they'll display it on company's website, and they will also intimate in DIR 12 to ROC. Okay? The promoter or central government is going to fill vacancy if all the directors resign. If all the directors resign. Fine? So you can send a letter informing the chairman or the secretary of the company that you are resigning from the post of director. It is absolutely okay. And once a resignation letter is submitted to the board, then the director ceases to be the director. He is not a director anymore, right? It doesn't matter you have informed to ROC or you have not informed to ROC, right? Immediately after this particular board meeting, right, whatever general meeting is held, in that also it will be, you have to place this fact of resignation in front of the members, right? If we want to remove the director, can we remove the director? See, if the board wants to remove the director, it is not possible. But if the members want to remove the director, then it is possible. Eligible member, that means if you are a member who is holding at least 1% of voting power or 5 lakh, then you are an eligible member, right? Or collectively you may become an eligible member. So if you're an eligible member, you can send a special notice for removal of the director or for appointment of somebody else in place of that particular director. You have to send it 14 days before the general meeting to the company. The company will send a copy of it to the director. The director can always make his written representation that why you want me to be removed. I have done so much of work, this, that, etc., etc. And they'll send it to the company. The company is going to forward it to all the members 7 days before general meeting. If it is not possible to be sent, it will be read out at the meeting. Apart from that, the director will also have an opportunity to be orally heard at the meeting. Thereafter, at the meeting, all the members will take a call, they'll take a decision, and just by passing ordinary resolution, they can remove the director. Whatever vacancy is generated, it can be filled. If there was somebody else who was proposed, then that particular person can be appointed. If no, then it will be treated as casual vacancy, as in this case also. The resignation of directors is also as good as a casual vacancy, and casual vacancy is filled by the board. Okay, so if a director resigns, then the board appoints in place of that particular director. Right. What are we going to pay to the director, ma'am? See, we have a contract with the director, what we want to pay. If I'm talking about managing director, Whole-time director, because there are two types of directors. One are whole-time directors, which are also called as executive directors. Then there are non-executive directors who are not actually the employees of the company. They're part-time, they're independent directors, right? They're different. When I'm talking about the remuneration, we have manager, we have whole-time director, we have part-time directors, we have independent directors, we have women directors, we have so many directors, right? Section 198 gives us the overall managerial maximum remuneration which can be paid in a public company, and that is not going to exceed 11%. Ma'am, the total remuneration paid to whom? Only the managing director and whole-time director, or collectively to all the directors or manager? All the directors plus manager. 11%. 11%. Sometimes the company may not have adequate profit. We also have Schedule 5. We have a lot of detailed provisions about which you don't have to read right now. Basically, what happens in a company, the company fixes the remuneration per month, right? At the end of the year, they have to review that this is the profits that we have made. 11% of these profits comes out to be this is the remuneration that we have paid. If we have paid excess remuneration, we have to recover it. If we have not paid excess remuneration, great, right? So the directors cannot fix themselves the remuneration. There's an upper capping which is given under law only. Managing director or whole-time director, they can definitely be paid on monthly basis or as a specified percentage of profit. That is not the problem, but then you have to keep in mind the overall limit. What is remuneration? Remuneration is basically the money or any equivalent thing which you're getting for the services that you are rendering. What you have to remember is one thing: a public company can pay remuneration to all its directors, executive directors, non-executive directors, maximum 11%. Maximum 11%. Okay. So this is one thing that you all must remember. Apart from that, you also have something called as powers of board in the chapter of directors only. So the board can do all the acts which a company can do, right? You cannot do something which has been reserved only for members, right? But then there are some powers which are exercisable at board meeting only. Ma'am, what does it mean? Board takes all the decisions at board meeting only? No, my dear. Board may take some decisions through circulation also. That means if there are 4 directors, there is one matter which needs to be resolved. It is being sent to everyone's place. That means the board resolution is circulated and thereafter it is passed, right? And there are certain matters for which you need to call a board meeting where all the members will, where all the directors will come, they will meet, and then only they can take a decision, right? So there are certain matters which can be resolved only at the board meeting, and they are: if you want to call make calls on shares, if you want to go for buyback, issue of securities, borrowing of money, investment of funds of the company, giving loans, right? Approving financial statements, board's report, right? Diversifying business, approving amalgamation or merger, right? Any political contribution if you want to make, right? Takeover, appointment of KMP, removal of KMP, or or any other matter which may be prescribed. Okay. Now, these three powers, I call them big powers: borrowing, investment, and giving loans. They can be delegated also to any specific director, any committee of directors, or any managing director, any principal officer, likewise, right? So after directors, the next topic that we revise is operational and financial control. The question is, what is operational and financial control? Although this question has never been asked directly, but if asked, it can be a direct question only, right? Now, when we talk about operations, it is all about operations, which is very different and diversified from company to company, right? So, if you are an operational controller, then we cannot specify that these are the responsibilities that you will be entrusted with, because that duties will differ from business to business, because every company's operations are different. Maybe somebody is manufacturing, maybe somebody is just storing, maybe somebody is just selling the products, or whatever your operations are, which are the core business, right? So depending upon that, you have to control everything. Basically, in a company, there is a CEO, which is operational head, and there is a CFO, which is a financial head. So financial controller, your job is about financial function. Although when we talk about a financial or an operational controller, both have to do some sort of budgeting and forecasting in their respective areas. But financial controller, you're responsible for finances overall in the company, and more than the finances, you're also responsible to ensure that there are proper accounting records, there is proper reconciliation, there is early detection of fraud and errors and everything. Then only you'll be able to be a good financial controller, right? We have a unit called as internal financial control for financial reporting. So who is somebody who is internally controlling the finances? Well, these are the board of directors. Well, these are the internal auditors appointed. Well, this is the audit committee which is appointed. So here we talk about board, here we talk about auditors, here we talk about audit committee, and likewise all the content related to reporting, all the content related to financial reporting, so that we get to know what is the state of the company, right? So the first thing that we start in this particular unit is section 134. Section 134 is divided into two parts. One is the signing of financial statements, the other is content of board's report. So we all know that financial statements are prepared by the company. Thereafter, they are presented before the board of directors. The board of directors basically approve it. Now they don't have an official signature, the board. So somebody has to sign on behalf of board. Who signs it? Because the financial statements have to be signed by the board and it has to be signed by the auditor. So before it is handed over to the auditor for examining and for giving their opinion, it has to be first approved by the board. So for approval, it is going to be signed by the chairperson and CEO, CFO and CS if appointed, in case the chairperson is authorized. If he is not authorized, by two directors, one of whom shall be MD, and CEO, CFO, and CS. Okay. When we talk about one person company, then it can be signed by just one director, because there is only one director. Okay. The next portion that we come across in section 134 is about board's report. Okay, so board's report is something which is a report of the work which is done by board of directors throughout the year and is addressed to the members. What will it include? The web address, that is the website, the number of meetings, the number of times we met, a director's responsibility statement that we have complied with all the accounting standards, we have applied certain accounting policies, we have prepared the financials according to going concern basis, and likewise, right? Then if there is an auditor and maybe he has given some adverse remark, then what is your comment on that? Whether it's a cost auditor, whether it's a secretarial auditor, whether it's a statutory auditor. Thereafter, if there is an auditor who has detected some fraud, then you have to give details about that fraud also and the remedial actions that you have taken. Declaration by independent directors. Okay, if the company has NRC, what is the policy that you have decided for appointment of directors and their remuneration? Okay, thereafter, the details about your related party transactions, the details about the loans that you are giving under section 186, the details about your dividend, the details about your reserves that you are going to transfer, the details about your committees, NRC, CSR, audit committee, all of that. If you have concluded your financial statements, obviously on 31st March, right, and the date of board's report is maybe 30th June, the material changes that have occurred between that period, right, then something related to your energy conservation and import of technology and all that, something related to your risk management policy, right, then there is evaluation of performance of the board and its committee and all that things, which is not relevant in all the cases, but yes, it is. There is also a bridged board's report for certain companies, but these are the basic contents of board's report which has to be specified. Okay. Then we move to the duties of auditor. See, auditor has certain duties, then auditor has certain rights, and then there is certain reporting which has to be done by the auditor, obviously. So first of all, when we talk about the right, auditor, you have the right to all the information, right to all the books of accounts which is maintained by the company at this place, at that place, at the branch office, everywhere. All the vouchers which are being maintained, right? It doesn't matter you are maintaining it here or there, you have to provided to the auditor as and when they ask. In fact, if they have any doubt in the voucher, they can also go ahead and seek explanation from the employees, right? Thereafter, it is your duty to make certain inquiries. Inquiries about what? Inquiries that your personal expenses should not be booked to the company's accounts. If you have sold your investments below cost, you have to tell the details of the same, right? There shouldn't be transactions which are just book entries. There shouldn't be loan unsecured loans that you have given. Maybe if you have given a loan, it should be properly secured, whether it's done or not, right? If it's not done, then you will always add a remark to that, right? So that the members are aware of the same. Okay, then if you have allotted shares, whether the cash has been received or not, right? So it is your duty to make inquiries. It is also your duty to make report. What type of report? First is the basic. You have to give a report on true and fair view of the financials. That is your basic audit report, right? Thereafter, you also need to report that you have got all the information that you needed, right? Secondly, you have got all the information that you needed from the branch, right? Thereafter, the balance sheet and the P&L which has been prepared, they comply with the accounting standards. They have been in agreement with the books, right? And thereafter, you also have to state about the internal financial controls, right? Whether they are adequate or not, whether any director is disqualified or not. Okay, so all of that matter and other reports, caro reporting and all that has to be made by the director, by the auditor, by the auditor. Okay, it is also your duty to follow the auditing standards and exercise reasonable skill and care. Fine. The auditor is not required to always give a clean report. He may add a remark, he may make an adverse report, he may add a qualification, everything can be done. Okay. Now, we have something called as audit of government companies. So, audit of government companies is not going to be done by just another auditor, it is going to be done by the comptroller and auditor general. Okay, so who is appointed? Who appoints the auditor? So CAG is going to determine the manner, scope, and everything of audit of a government company. Fine. So government companies auditor, when you prepare your audit report, you give it to, you address it to the shareholders. It is being laid down before the general meeting. That is all fine. But you also submit a report, a copy of your report to CAG. And CAG has certain powers. Within 60 days of receipt of audit report, they can conduct a test audit. They may order a supplementary, that is an additional audit. They may add a comment or supplement an audit report. Whatever they do, that final audit report is going to be sent to the company and is going to be laid in front of the members at AGM. Okay, then we have something called as branch audit. The branch audit can be done by the company's statutory auditor, or maybe there can be some other person who is hired, who has the requisite qualification, and he is hired for auditing the accounts of the branch. So if he is doing that audit, then he is going to prepare a report and send his report to the company's statutory auditor, who is going to deal with the report in the manner he considers necessary. Now, there is another duty of auditor, and that is reporting of fraud. Reporting of fraud. So if your fraud is less than 1 crore, within 2 days of knowing, you report it to the board or audit committee, and they have to disclose it in the board's report, the nature, amount, party involved, and the remedial actions that they took. If the fraud is 1 crore or more, then within 2 days of knowing, in the same manner, you'll report it to the board or audit committee and ask them to reply within 45 days. If they reply within 15 days of their reply, your report, reply of board, your comments on the reply of board, you will forward it to central government. If they do not reply, then within 15 days of expiry of 45 days, your report and the details that you send it to the board and they didn't reply has to be sent to central government. To central government. We all know that the central government consults and thereafter they lay down the auditing standards, and that has to be followed by every auditor, right? And you all know, I hope, that there is some authority called as NFRA, which is National Financial Reporting Authority, which is constituted under section 132, and that is actually supervising the entire professional body. So that is looking after that, okay, the company's accounts have to be checked by the auditor, but if the auditor is delivering proper professional work or not, that is going to be checked and is going to be under the supervision of NFRA. Fine. So that is how it has to be done. Fine. And if you do not report this, then there's going to be a penalty. For listed companies, 5 lakh by the auditor, and for any other company, if you're doing the audit, then the penalty is going to be 1 lakh, right? Okay. Thereafter, we come to the concept of audit committee. Audit committee is constituted under section 177, right? It is not mandatory for all the companies, but the listed public companies, and if you are a public company and having paid up capital of 10 crore or more, or turnover of 100 crore or more, or loan or deposit more than 50 crore, then you are mandatorily required to constitute an audit committee, which is nothing but a few directors forming a committee, right? These directors have to be minimum 3, and in which majority are going to be independent directors with the ability to read and understand the financial statements. Fine. What do they do? The first and the foremost task is to recommend that which auditor should be appointed, how much remuneration should he be paid, reviewing the auditor's performance, examining the auditor's report and the financial statements, right? And also scrutinizing loans. Whenever valuation of assets is going to take place, then evaluating that process, right? Evaluation of internal control, monitoring the use of public funds. That is, if the company has raised funds by issuing securities to the public, then whether the funds are going to be utilized in a proper manner or not, that is going to be monitored by the audit committee. Apart from that, they can also call some information from the internal auditor about the control, how is it going to be maintained. They also have the powers of investigation, and they also oversee vigil mechanism. What is vigil mechanism? Vigil mechanism is like a whistleblower policy. Have I written? Yes. Vigil mechanism is like a whistleblower policy. These 3 types of companies, that is a listed company, company with public deposits, or company with borrowings of more than 50 crores, are mandatorily required to establish a vigil mechanism, which is a whistleblower policy wherein any employee, if he is a victim, maybe something wrong is happening to him and he's not able to complain because it involves a hierarchy and he has to report to the manager. The manager himself is doing or harassing that particular person. He's not able to reach to the top, and there are a lot of issues that they're facing. So there is a whistleblower policy or a vigil mechanism which has been established, wherein employees can anonymously reach direct and they can complain and the actions can be taken. So in the companies where there is audit committee oversees the vigil mechanism. Where there is no audit committee, then the board of director, the board authorizes, nominates one director, and that particular director oversees the vigil mechanism. Now, apart from that, there is one more thing which the audit committee is doing, and that is approval of related party transactions. What is a related party transaction? Like, who is a related party? The company, its holding company, or maybe associate company, or maybe the directors, they're all related parties. Now, if you're entering into a transaction with that related party, maybe you're buying some products from them. If it is at arm's length price, no problem. But if not, and it is a transaction which is covered under section 188, then you need to obtain approval. If it is not covered, audit committee will only give recommendation, right? But if it is covered, then you need to obtain approval for the same. There is also an option of obtaining omnibus approval, which is a pre-hand approval for upcoming transactions and which has a validity period of that financial year only. So every financial year you have to take that omnibus approval if you want to. So what audit committee does is, audit committee goes to the board of directors and they tell that this is the criteria we are specifying. You please approve this. Based on this criteria, if somebody approaches us and they fulfill this criteria, then we'll grant them omnibus approval, considering that how justified it is and what is the nature of transaction, how repetitive it is. That is, maybe there is a holding company with which the company has to incur transactions n number of times. So every time seeking approval from the audit committee would be difficult. So one time approval they are taking for all the transactions which will be done during that financial year. Now audit committee is concerned, so they specify a particular criteria that this is the maximum value during which, that is the total value, maximum value per transaction, the disclosure that you need to be made, the review that we will be doing, and the transactions which are not permitted for under omnibus approval. Okay, so they can, based on this, approve and also impose restrictions or impose conditions. So this is allowed, but if you want to sell the undertaking for that, omnibus approval is not allowed. So this is how omnibus approval may be obtained. Okay, if there is any related party transaction which is for an amount less than or equal to 1 CR, if you have not taken pre-hand approval, then you can get it ratified within 3 months. If you don't ratify it, then it's going to be voidable at the option of audit committee. The board's report is going to clearly disclose that this is the audit committee that we have composed, and at what times we have not accepted the recommendations of audit committee. Okay, and why? So that also has to be stated. Next, we move to the unit called as the rights of shareholder. You all know who a member is and what are the rights of shareholder. They have been read at different places throughout Companies Act, and if we compile it all, shareholder has a right to vote, shareholder has a right to receive the notice of general meeting, shareholder has the right to receive dividend, shareholder has the right to give a requisition for calling EGM, shareholder has the right to appoint a proxy, shareholder has the right to inspect all the registers, register of members, proxy register, and all that of that. If the shareholder is a body, corporate, or president, something like that, he has a right to appoint the representative. Then shareholder has a right to get the share certificate. Shareholder has the right to inspect the minutes. Shareholder has the right to remove the directors, elect the directors, right? Appoint the auditors. Shareholders have the right to apply to NCLT for relief against oppression, mismanagement, and shareholders also have the right to participate in the surplus which is left after the process of winding up. The last unit that we have talks about KMP, that is key managerial personnel, and the question is, who is a KMP? You have CEO, you have MD, you have the manager, right? You have the company secretary, you have whole-time director, you have CFO. There is any other officer which can be maximum one level below the board who is designated as KMP, and any other officer as prescribed. So they are going to be called as the KMP. So I hope this was a quick and effective revision of the entire chapter of directors and the content of extra company law.